Give all
But
the
before
memos.
your lordship takes up
matters
any matter,
One by one. Sir, 1 minute, sir. I'll get back to you, sir.
yes,
My lord, the urgency is the 354C case has been filed.
Wait.
All intention.
Wait, sir. I'll give all the memos.
Just pass the soap. ಆಮೇಲೆ ಏನ್ ಮಾಡಾರ fresh
Any memos for settlement? Settlement, when do you want?
Is for
Huh?
a fresh.
Okay, other mele write and give, when do you want?
I already filed 5 to 6 memos, lordship.
For settlement,
Fresh matter. sir.
fresh matter it will come.
No, it's not coming at all, lordship. A date may be
Come.
fixed for lordship settlement.
It will come on Monday, sir.
the settlement.
Settlement memos, please give. Fresh matter tagoli memos.
Settlement tomorrow.
Now what's the problem? Nimden urgency iralla bidi. Chartered accountant, ಅದು Friday ಬರುತ್ತೆ ಕೊಡಿ. ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ? ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಕರೆಕ್ಷನ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ತಾನೆ? Friday. Yes. ಪೆಂಡಿಂಗಾ? ಯಾಕೆ? ಸ್ಟೇ ಇಲ್ವಾ? ಕೊಡಿ.
Hello, I filed a
ನಾಳೆ
memo
ಹಾಕಿ.
for vacating the stay.
ವಾರಂಟ್ ನಾಳೆ ಕೊಡಿ.
Will come from that side.
Fresh matter. Give it. Friday. Withdrawal ಹೇಳಿದ್ನಲ್ಲ ಕೊಡಿ ಅಂತ ಕೊಡಿ. Next week. No date, give it. ಬೇರೆ ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ? ಅವಾಗ ಮೆನ್ಷನ್ ಮಾಡಿ ಅವಾಗ ಆಗುತ್ತೆ. ಇವಾಗ ಆದ್ರೆ ಆಗಲ್ಲ ಅದು. You mention that when that is called. Okay? Yes. We'll see if it doesn't reach, mention at 4:45. Yes. Fresh matter. Urgency ಏನು? Charge frame ಆಗೋವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? What were you doing till now, sir? ಏನಾರು ಆಗಿರ್ಲಿ, what were you doing till now? Direct answer ಕೊಡಿ. ಆಯ್ತು, give it. No, yes. It will come, fresh matter, they'll come. So, police harassment, there is no other way, give it. Give it, yes. Bail ತಗೊಳ್ಳಿ sir. Bail ಆಗಿದೆ ಅಲ್ವಾ? ಏನ್ urgency ಇಲ್ಲ. If bail is there, no urgency. No, sir, yes. It will come Monday, it will come. ಅದಕ್ಕೆ ಮುಂಚೆ ಆಗಲ್ಲ. Yes, give it. Pending a fresher, sir. ಆಯ್ತು, ಬರ್ಲಿ ಬಿಡ್ತು. Give it, Monday ಎಲ್ಲ ಆಗಲ್ಲ. Pending matter ಇಲ್ಲ, ಎರಡೂ ಆಗಲ್ಲ. Friday ಅಂತ. Yes, ಕೊಡಿ. ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಬರುತ್ತೆ ಬಿಡಿ. Yes, give it, ತೊಂದರೆ ಇಲ್ಲ. Yes, ಕೊಡಿ. Sir, fresh up pending us. Why tomorrow? What were you doing till now? That's Kodi, yes. Rajendra Reddy or the Friday hack. Yes. Huh? You are for the respondent. Monday could. It will come fresh matter. Monday bar. Fresh matters, why are you waiting to make a mention? Please give it. Please give it, sir. Fresh matter, they'll come on Monday, give it. Then we'll take it after 2 weeks, move another 2 times. Give it, sir, Monday. Give it, yes. Jodi, madam. You're for the rest. Travel abroad. ಅದು ಕೊಡಿ, yes. Travel ನಾಳೆಗೆ ಹಾಕಿ. Civil dispute. Excise Act ಅಲ್ಲಿ civil dispute. Designs Act. One fresh matter, right? What were you doing till now, sir? What happened to that petition? Then give it tomorrow, yes. Why? Tomorrow, sir, give it, yes. Tomorrow, yes. Give it, madam, please give. Please give, please give. No date, please give, yes. No date, madam, yes. Give it, madam, next week. Pending matters alla next week kodi. Vacating stay, dates will be assigned for vacating stay, give it.
Vacating stay application I filed.
Yes, give it, give it.
Application for stays to be considered, my lord, I will
Huh?
file. Application for stays to be considered. The pending matter 2022.
Hmm.
Directed to.
22 in the, till now, there is no stay. What stay you will get now?
Some protection granted.
That will continue as stay.
Directed to impede the PD and my lord has responded to, they have also filed a statement now.
Ah.
The application for stay may be considered.
We'll see, give it, yes.
Lord, this is a fresh,
Your lordship,
fresh matter, my lord. Or there is no allegation against this.
Give it, sir, fresh matter kodi. Fresh matter. Fresh matter.
Presiding officer of DRT, she just completed her term.
Hmm.
She's got another term as well. In between, the complainant has filed a complaint against her for some loss of document in DRT, my lord.
Correct. No doubt about it, yes.
Administrative, my lord, the document has been restored as well. My lord,
We'll see, give it.
230.
Yes. Why 2:30? Just because you want to tell the DRT chairperson that I have taken a stay at 2:30? No,
My lord, at this.
tomorrow, Monday, sir. All
My lord,
fresh matters-
your lordship,
The pending matter, 2022 matter, my lord.
all pending matters, please give the memo.
Yeah, this is that, matter. can you
Memo
take-
kodi, sir.
your lordship, yeah, for the respondent, already FIR has been quashed, your lordship, and they have taken stay for only for release of amount, and they have not filed their objection.
What's
In-
your petitioner respondent?
Respondent, your
What
lord,
do you want now?
vacation, stay vacation, your honor.
Stay vacation.
Yes, your
Worships kindly for 230 minutes, 16 years
Not
after.
tomorrow. Not,
lordship, tomorrow, your lordship, because 4
which
crores
year
have
is
been,
that? Which year is that?
24, your lordship. January
Welcome,
list
madam.
ಆಗಿದ್ದು ಇನ್ನ ಲಿಸ್ಟೇ ಆಗಿರ್ಲಿಲ್ಲ, your lordship.
ಇದು ವಿಕೆಟಿಂಗ್ ನಾಳೆ ನಡೆದ ಅಷ್ಟೇ ಸಾಕು, ಐದೇ ಹಾಕಿ. Yes.
My lord, kindly for 230 minutes, 16 years after the incident, FIR is filed. An illegal arrest is attempted to be effected by the investigating officer.
2:30, yes.
My lord,
2:30 ತೊಗೊಳ್ಳಿ madam.
criminal petition. Court memo, there is no interim protection. The charges.
Next
going to
week,
be
next week.
filed on
Monday, sir.
Monday, kindly. Because this is my fourth
Submission.
This I am requesting for a memo for release of the matters. Because it is repeatedly being.
Release of
Date
matters ಯಾವ್ದಕ್ಕೆ ಸರ್?
ಅದು 29th May reserve ಆಗಿರೋದು, it is repeatedly 2-3 times.
ಇವತ್ತು ಬಂದಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ I am
I can't do that. If you ask, I can't do that. Don't enter into such practices, sir.
Sir.
Reserve ಮಾಡಿ 3 months ಆಗಿದ್ಯಾ? 3 months ಆಗಿದ್ಯಾ? What do you mean almost?
After that, whatever has been done, your lordship said.
All
18
right.
July, tomorrow.
Yes,
we will do
yes,
it.
we'll do it.
Also.
It
was
should
not-
have come today, I don't know. It will come on Friday if it is not there. Don't try to move such memos. Yes,
Connect-
no, don't do that.
Connected petition.
3 months ಆಗಿದ್ರೆ you are entitled to say that, not before that.
Actually requesting.
No, that's not the way to do it.
At least it can be.
That we'll see, yes.
Achha.
Connected.
Just because you are a respondent in person, don't overreach, yes. Thursday,
My lord, connected petition ಅಲ್ಲಿ one petition ಮಾತ್ರ ಲಿಸ್ಟ್ ಆಗಿದೆ. Connected.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್. ಎಲ್ಲಿವರೆಗೂ ಮೆಮೊ?
ಅಲ್ಲ sir,
12
report
ಗಂಟೆವರೆಗೂ
settlement
ಮೆಮೊನೇ
ಮಾಡಿ.
ತಗೊಂತಾರಣ್ಣ?
Reporting settlement.
12 o'clock ವರೆಗೂ ಮೆಮೊನೇ ತಗೊಂತಾ ಇರ್ತೀವಿ.
Real number
Memo.
906.
ಕೊಡಿ, give all the memos.
It's a fresh matter.
Fresh matters, give all the memos.
Matter.
Monday it will come, give it. Monday. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ವಿ? ಏನಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸರ್? ಅಪಿಯರೆನ್ಸ್ ಇದೆಯಲ್ವ ಸರ್? ಅಪಿಯರ್ ಆಗಿ ಸರ್, ಪರವಾಗಿಲ್ಲ.
My lord, fresh matter, my lord.
Give it all the memos. No problems, give it. That's okay, yes.
Right.
No 2:30, why?
My lord, fresh matter.
Blood. Blood one.
ಅಲ್ಲೇ ಎಲ್ಲಿ ಜಗದೀಶ್ ಇದ್ರಲ್ಲ ಹೇಳಿ ಅವ್ರಿಗೆ.
Reporting settlement.
Monday.
Blood one pending matter, my lord.
All on Monday.
Matter list ಆಗಿದೆ. My lord one.
Monday. What is posted tomorrow? It's all right. You have 7 in. 13 ಆದ್ರೂ ಕೊಡಿ ಎಲ್ಲ ನಾಳೆ. 13 ಎಲ್ಲ ಕೊಡಿ.
7 AM. 7 AM.
13 memos ಕೊಡಿ.
7 AM.
Give 13
My lord,
memos.
it's a fresh matter. Fresh
One day,
matter.
one day,
My lord, 498 matter, my lord, please to,
one day.
my lord, 498, my lord,
Being a
please to-
fresher, sir.
my lord, pending matter, my lord.
Body.
My lord, please to issue notice, my lord.
Please
Now
give the memo, sir.
Trial court has issued NBW. my
No
lord. My lord has
problem.
directed
Give
to
the memo, sir.
file exemption.
Reporting
Appear
settlement.
before the court. Yes.
Seven AM.
Give the memo. Yes.
My lord, case on counter case, my lord. Respondent has filed a wakalat, my lord.
Maybe give it. Yes.
My lord, 7 AM.
Please give all pending.
He's a senior official, my lord. 7
I am
AM.
not senior official.
Sorry,
Next week, sir. Yes.
Reporting settlement.
Settlement, give settlements.
Connected matter list ಆಗಿಲ್ಲ, single matter ಮಾತ್ರ list ಆಗಿದೆ.
ಪರವಾಗಿಲ್ಲ. ಆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿರೋದಕ್ಕೆ ಹೇಳಿ ಅವಾಗ.
Yes.
2021 ದ.
Yes, your honor. Senior bench in ಕೊಡಿ ಅಂತ ಅಲ್ಲಿ ಹೇಳೋದು.
ಸೀನಿಯರ್ ಬೆಂಚ್ ಯಾರು 21? ಹಾ ಸರಿ ಅದಕ್ಕೆ ನಾನು ಐ ಕ್ಯಾನ್ ಡೈರೆಕ್ಟ್ ಇಸ್ ಇಟ್? Yes.
Uganda adoption matter. Lordship was pleased to dispose of the Uganda adoption matter in March 2024.
What happened?
Pursuant to that, no objection or approval has been passed at all.
ಯಾವ್ದು ಜರ್ಮನಿ?
The
Uganda.
The
ಕೊಡಿ.
fighter nine.
ಅದು ನಾಳೆ ಹಾಕಿ ಮೇಡಮ್.
Absolutely.
Tell Shanti Bhushan. Yes. That's everybody are victims of something. Tell me. ಕೊಡಿ ಎಸ್ ಟುಮಾರೋ. ಟೈಮ್ ಆಗೋಗಿದ್ಯಾ? ಪರವಾಗಿಲ್ಲ. ಇಲ್ಲ ಮಂಡೇ. ಎಸ್.
Well, it's the case of.
Lord, item 151.
Yes,
with
sir.
Lordship's permission, my lord.
151, what is that, sir?
That is that SIT matter which involves serious allegations against several lawyers.
Yes, yes, sir, yes, sir, yes, sir.
Your lordship had heard it and reserved judgment. It was
Reserved,
supposed to be-
I have not reserved, I think
order.
dictating orders, sir.
Yes, yes.
Not reserved, sir, dictating orders.
So it was to be listed today at 4 o'clock. Unfortunately,
It is not listed, it's listed.
it is listed,
Time is
but
not fixed.
it's
Oh,
not
we'll take-
time.
We'll
It is
take
not-
it, sir, we'll take it, sir. Yes,
But what is something extraordinary has been happening in this case.
extraordinary.
Yes, yes. One lawyer of involving one of the parties who was in that tape recording, and the nephew of one of the petitioners was arrested on a FIR made by the wife of one of the accused in that case. And thereafter, my lord, of course, they have now, yesterday, they have been released on bail. But meanwhile, the investigating officer has committed, has either been murdered or he has committed suicide. His wife has made a statement that he was being pressurized by the parties in apparently this case, one
This
of the
case.
parties in this case. And not only that, not this the one senior police officer rang up the petitioner in this case and told him that you withdraw this petition for SIT and I will release your nephew and this lawyer.
Oh.
And after that, my lord, that investigating officer has committed, either he has been murdered or he has committed suicide. His wife has alleged murder and his wife says that he was.
Anyway, that's a separate proceeding, we'll see.
I know, my lord, but that amounts to contempt of court. If a senior police officer rings up one
No,
of the parties.
If it is correct, then it does amount to, let's see.
Yes, we
We'll
have
pass,
filed it.
whatever
We
order
have-
is to be passed in this, we will pass.
Yes, my lord, your lordship, because the delay in this matter is leading to all this. Actually, they are trying to pressurize the petitioners to
All right.
withdraw.
Afternoon, 4 o'clock, we will try to pass some order.
My lord, one more thing which I wanted to mention, which my lord might have forgotten. My lords, during the course of argument in the bail application,
Which bail application?
before the trial court, in that FIR, my lord, allegations are leveled against the advocates who represented accused persons that they advanced such submissions will lead to the suicide of the investigating officer. I was one of the advocates who advanced submissions, and my lords, I cited your lordship's judgment only, wherein your lordships have directed serious orders against an investigating officer in a similar matter for conducting for arresting accused persons illegally beyond the in violation of the Arnesh Kumar judgment, my lord. In that matter, your lordship had directed disciplinary proceedings.
That is state by division bench.
My lords, that order was cited and that order was read on. Thereafter, my lords,
Kuldeep.
on the yes, my lord.
Yes.
On the very next day, the IO committed suicide, and when public prosecutor filed his objections to
No,
bail-
those are, how are those
My lord,
relevant? relevant to this.
That
matter.
objections read that the advocates for the accused during the course of arguments advanced certain submissions which led to the suicide of the investigating officer. So attempts are being made to incriminate the advocates, my lord, who are representing
see.
the petitioners at the forums.
Yes.
My lords, I humbly
You've said
request,
everything that you wanted to say.
my lord, I humbly request this honorable court to pronounce orders. Today in
Pronounce,
the-
right? I have not reserved it, madam.
Dictating of orders,
That
whatever.
we will do, yes,
Public.
yes.
Please, my lord, state has filed a petition, my lord, questioning the magistrate order, referring the matter for further investigation. 230 may kindly be taken.
Yaಕೆ urgency ಏನು?
Urgency, contempt has
ಹೌದು.
been moved against the commissioner of police, my lord, on account of which
Yes, 230.
Millards memo for posting, Millards, this is the matter of poker and rummy, Millards.
Huh?
Lower, poker and rummy, the company is.
Poker
petting
and,
us. Poker.
poker game.
Poker
Yes.
game and rummy. Millards.
What's the urgency?
Millards, they've been undergoing losses of 60 lakhs. per day,
Losses, what
and
is that?
their accounts are frozen, Millards. Memo for posting.
Monday.
Please, Millards, obliged.
Yes.
Being spoken to still number one.
Operative portion of the order. Yes, special CC number 204, but 2004, that has become 2024.
Oh, yes.
One correction.
ಒಂದೇನಾ?
August.
In the connected 26 matters, my lord, in 3 matters, we filed an appeal. That's not bring it to not the court. That is the reason, my lord, I will also file it.
ಏನು
not
ಅದಕ್ಕೆ
in this
recall
case.
ಮಾಡ್ಬೇಕಾ?
Huh?
Recall ಮಾಡ್ಬೇಕಾ?
Because we filed an, against acquittal order, we filed an appeal. before this-
Subject to that always.
Please.
Yes, whatever happens is subject to that. The 2004 ಇವಾಗ ಹಾಕಿದ್ದೀರಾ ಅಪೀಲು?
ಅಲ್ಲ, disposal 2020 ನಲ್ಲಿ.
ಆಯ್ತು ಸರಿ. The petition, this court had disposed the matter on 25th June 2024. The learned counsel for the petitioner has moved a memo for being spoken to on the score that the special, on the score that there is an inadvertent typographical error in mentioning the case number. It is mentioned as special CC 204 of 2024, which ought to have been 204 of 2004.
Yes.
The correction be effected to and a certified copy be issued to the petitioner.
Petition is handling and hand delivery with some urgency that
Hand delivery,
of this order.
correction line hand
Correction.
delivery. Yes, it will come, it will be uploaded, yes.
But so,
ಏನು ಬರೋದೇ ಇಲ್ವಲ್ಲ? ರೆಸ್ಪಾಂಡ್ ಒಂದು ಪಾಸ್ ಓವರ್ ಮಾಡು.
3. Filing memo for being spoken,
Memo for?
being spoken.
It is come for being spoken to. What do you want to tell me?
Swami, ಅದರಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಡೇಟ್ ರಾಂಗ್ ಆಗಿ ಮೆನ್ಷನ್ ಆಗಿದೆ.
ಏನ್ ಡೇಟ್ ಮೇಡಮ್?
23/11 ಅಂತ ಮೆನ್ಷನ್ ಆಗಿದೆ.
ಹಾ.
26/12 of 23 ಆಗ್ಬೇಕಿತ್ತು.
ಸರಿ. The same inadvertent, this court on 29/7/2024 had passed the following order. There is an inadvertent typographical error in mentioning of the date, therefore the matter has been moved for being spoken to. The date of the impugned order should have read as
26/12 of
26/12/2023 in place of 23/11/2023. Madam, ಎರಡು ಕಡೆ ಬರುತ್ತೆ. The corrections be effected and order be reloaded on the website. Yes.
Fresh matters number 4.
I appeal for the petitioner in this matter. I pray for 2 days' time. I need to furnish a plaint in which there is a case between the.
Post the matter for admission on 21st. Yes, next.
5.
It's case and counter case, not.
Hmm.
I request that, case and counter case, my lord. Both the cases may be watched, my lord.
Yes, sir. ಎರಡರಲ್ಲೂ ಸ್ಟೇ ಇದೆಯಾ?
ಎರಡರಲ್ಲಿ stay.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಯಾಕೆ ಬಂತು ಮತ್ತೆ?
My lord, because case, last time when it was.
I think your
listed,
lordship felt
I
that
mentioned that
since
this
both the
case, it
parties
can
are
be disposed.
relatives, could be quashed ಅಂತ.
307
307 ಇಲ್ಲ.
ಅದು ಡ್ರಾಪ್ ಮಾಡಿದ್ರಾ? ಇಲ್ಲ 307 ಇದೆ
ಇಲ್ಲ,
ಯಾವ್ದು?
ಈ ಕೇಸ್ನಲ್ಲಿ ಯಾವುದಿಲ್ಲ. ಈ 307 ಯಾವುದಿಲ್ಲ, ಈ 327.
ಇಲ್ಲ. 506,
ಇದ್ಯಾವ್ದು ಕ್ರೈಮ್ ನಂಬರ್ 250 of 2019?
ಅದು ಬೇರೆ, ಅದು ಹಳೆ ಕೇಸ್.
ಹಳೆ ಕೇಸ್. ಸರಿ, ಸ್ಟೇ ಇದೆಯಲ್ಲ, ಇನ್ನೊಂದ್ ದಿನ ಕ್ವಾಶ್ ಮಾಡು.
Please.
List on 28th for admission.
Great.
Interim order subsisting shall continue till the next date of hearing.
Number 6.
List after 2 weeks, interim order subsisting shall continue to the next date.
7.
List after 2 weeks for admission. Admission.
I appear for a respondent, my lord.
Yavrali madam?
Serial number 7.
7.
We have not received any direction from our respondent.
Copy kodi.
So we are
It was
trying
only
to.
served on second.
Huh.
Even before serving them, they said, serve it on the parties. Since my
Yes,
last-
madam.
We are trying to establish contacts with the. respondent,
Establish contact. With whom?
but With the respondent side. So we are not receiving it any, so kindly an accommodation may be given.
This is a case where the check is not disputed. I have given the check, but the check was given with respect to me purchasing a property, wherein there are
You
cases.
file your
pending.
objections, copies are served.
Copies has been served.
The learned counsel appearing for the respondent, registry to print the name of so and so is appearing for the respondent. Wakalat hakidara?
Anyway,
You entered appearance?
they seeking.
The
time to
learned
second
counsel so and so submits that she has not been able to establish contact with the complainant and therefore would seek 2 weeks' time to enter appearance or file objections as the case would be. Therefore, list the matter on 28th till such time further proceedings before the concerned court shall remain stayed. Next.
8.
For the respondent, who in this matter? Is the matter where there is
Data
data
theft.
theft that has taken place.
Hmm.
I may make a submission.
Hmm.
We've got the laptops examined by a third party forensic auditor. We will submit the laptops to the police authorities. Let it be with them till the disposal of this petition.
His laptop,
Their
laptops that are
laptops.
in his possession.
My lords, if the crime is related to the laptops, my lords. So if this petition were to fail, the evidence may be tampered with. That is our,
We'll hear it and dispose it.
please, my lords, may have it next week, then we'll address.
Next week?
Next week.
All right.
I'm not, my laptop is with them. I don't have salaries. I'm not.
My lords, their services are terminated, my lords. That may not be
And-
quite right to.
And
Whose
also
laptop is it?
My laptop,
Personal,
personal.
or the company gave it to you?
No, that also they have taken.
Company
on the same
laptop
day,
is their
but
pers-
that was on the day of taking it. Next day, they come to my house, and take it.
Yes, return the personal laptop.
My lords, may have it next week. This
No,
matter
no,
may be
it's
disposed.
all-
my lords.
Your lordship, you kindly see.
Return the personal laptop and not the official laptop you can keep.
My lords, my only submission is, in the eventuality this petition were to fail, the data on that laptop may be deleted, my lords.
Which data?
The company data, the forensics of the laptop may be altered or the hardware may be altered. Investigation gets tampered then. That is my submission.
No. Now, your personal laptop, your official laptops are with you.
Please,
Why did you take his personal laptop?
my lords, because on the company laptops, there is a tracking software
All right.
which informs us that if company data is transferred to personal accounts. So that is the allegation.
Where
that
is the complaint like that?
The allegation says that, my
Where
lords,
is the complaint?
at annexure A, which starts at page number 14.
Internal verification by our IT team.
Please, my lords. And it's
Compressed
been
folders.
discovered that the,
This is not subjected to FSL, Jagdish?
I may have sent it, my lord, I'll repair.
Either I did not find any report of the FSL.
I'll check.
Check if FSL reports are required, we'll get it.
Yes.
that is my,
We'll release it. No,
after.
if you,
It is with them, my lord. It is not even with the investigating
Give it to
officer.
the-
They are
Yeah,
acting
we'll
like the
hand it
investigating
over,
officer.
we'll hand it over, my lord.
the learned counsel for the second respondent in whose possession the personal laptop of the petitioner is at this juncture, as the allegation is that the data from the company laptop is transferred to the personal laptop and therefore there is data theft on the part of the petitioner. The laptops be handed over to the investigating officer for it to be sent to the forensic FSL for examination. The said exercise shall be done in the next 2 days.
We'll hand it over
Forthwith.
tomorrow.
Forthwith,
They have no author, 1 month, I think, no.
Fourth-
author-
forthwith.
Please, ma'am.
Handed over forthwith, the learned additional SPP to get the examination of the forensic science laboratory with regard to the contents of the laptop or the material that is necessary for investigation.
But there's a pen drive also.
Pen drive ಬಗ್ಗೆ ಹೇಳ್ಬೇಡಿ.
ಇಲ್ಲ,
ಅದು
ಅದು ನಮ್ದೇನೆ.
ಅವ್ರಿಗೆ ಹೇಳಿ.
Their pen drive only, let that also.
That
come.
they will do.
2 laptops and 1 pen drive.
Yes, whatever investigation material is there.
Please.
Yes. Why did you seize it?
My lord,
Should you not give it to the investigating
my lord,
officer?
After 1 week,
If-
they get it.
if I may make a sum.
Why you did not give it to the
When
investigating
we
officer?
discovered it, they handed over to us, my lord. We didn't.
All
seize
right,
it.
why you did not hand it over to the
He'll hand it
investigating
over
officer?
now.
You're not casually doing
They
so.
are having it. Now they are handing it over.
And-
That also has to be considered by the.
We'll hand it over forthwith, my lord.
The investigating officer shall continue the investigation, bearing in mind the allegations made against the petitioner or by the petitioner against the complainant. Togoli, papers. Next, list
First
on,
day of investigation.
list on 28. Investigation ಮಾಡಿ ಅಂತ ಒಂದರಲ್ಲಿ ಹೇಳಿದ್ರೆ ಎಷ್ಟೇ ಕೇಳಕ್ಕಾಗತ್ತ? Yes.
My lord,
Entry order ಇದೆಯಾ?
There is
There's no
imprimatur
prayer
not
for
to precipitate.
investigation.
Investigation shall go on.
I have sought for not a stay, but I not
Yes,
for.
yes.
My lords, they have not sought any prayer of investigation against me, my lords. The petitioner has not sought any prayer of.
Allegations. Yes.
Please.
Allegation is that you have taken the laptop and gone without authority.
Forcefully.
Let that also be examined.
Yes.
We'll furnish their letters where they've submitted
Let's
to
see,
us.
let's, yes.
I applied a date may fix, not even for the FSL's
ಅಲ್ಲ
report.
FSL ಎಷ್ಟು ದಿನ ಆಗುತ್ತೆ?
We'll get it as early as possible.
Will list on 4th September.
Great.
Yes.
Interim auditor.
Interim order in the form that it is present shall stand extended till the next date of hearing.
I appear for the respondent, my lord. In
you
this
appear
case, on the previous hearing, my lord, I had furnished certain decisions of other high courts wherein the issue stands covered, my lord.
138. Yes, sir.
My lord, I filed this petition quashing the proceeding for the offence under section 130 of NA.
Correct.
My contention, my lord, I have borrowed the
Loan.
loan of 55 lakhs.
Correct.
And the mortgage it was registered, my lord.
Hmm.
Subsequently, it was discharged. Discharge it also registered, my lord. My lord, the documents produced,
Discharge how?
discharged, registered.
You cleared the loan, is it?
Please, kindly, my lord.
My lord, that is not the case there.
1 minute.
No.
Well,
ನಾ ಮಾಡ್ತೀನಿ
one-
sir.
ಇಲ್ಲಿ ಹೇಳಿ sir.
ಹಾ.
Don't get
Madam.
agitated by what it
Sorry,
says. Yes.
Madam, Page number 92.
90?
92. Annexure G, my lord. Discharge it was registered on 2nd day of March 2020, my lord.
92 ಅಲ್ಲಿ ಯಾವ discharge due ಇಲ್ಲ sir.
Page number 9. Annexure G, my lord,
Discharge receipt 9. Oh,
Yes, yes.
yes.
is registered in the sub-register office. The.
Has repaid the entire loan along with interest.
Please,
This is by the bank in
Yes.
favor of, yes.
please, my lord.
When was this, sir? 2nd March 2020.
Second, my lord, the document produced in this 138 proceeding is respect to this loan only. I'll kindly see,
1 minute. When did they register the private complaint?
private complaint, my lord,
2023.
please. My lord, my request is, my lord, section, kindly see page number 65, my lord.
60?
5. This is a loan application. A flat number G3 and flat number F3 was mortgaged.
Hmm.
This is a document produced in the 138 NA Act, my lord. This is discharged, the loan is discharged, my lord. On the same property, my lord, loan is discharged.
Now, what are you challenging here?
My lord, the quashing of the proceeding.
Entire proceedings.
Please. My humble submission is, the document produced by them in the 138 is, with respect to loan, my lord, sanction dated, my lord, same date. It is discharged, my lord. When the loan borrowed by the couple, the accused is discharged, my lord. The proceeding against,
What was the check given?
my lord, the 55 lakhs at the time of loan.
Availing the loan.
Please.
Where is the check?
Page number 98, my lord. Moreover, the other transaction is concerned, the other mortgage is concerned, section 14 was invoked. The judgment was passed by the magistrate court, my lord, appointing the advocate to take the possession and hand over it to the office of the bank. Admittedly, they have taken the possession before the magistrate court, my lord, in this proceeding. They admitted in the evidence that they had taken the possession. By reading the documents produced by them in the proceeding, in this proceeding, my lord, it's clear that this is discharge.
Yes, sir.
Please, ma'am. My lord, what has happened is Annexure C at ink page 49. Initially, 2 flats were mortgaged to us, G3 and F3. Thereafter, my lord, he comes forward and says that ನನಗೆ ಈ ಫ್ಲಾಟ್ಸ್ ಗೆ ಬೈಯರ್ ಸಿಕ್ಕಿದ್ದಾರೆ, ನಾನು ಬೇರೆ 2 ಫ್ಲಾಟ್ ನ ಮಾರ್ಟ್ಗೇಜ್ ಮಾಡ್ಕೊಡ್ತೀನಿ, ದಯವಿಟ್ಟು ಇವೆರಡನ್ನ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾರೆ. Thereafter, my lord, Annexure F page 84, S3 and T3 are mortgaged to me. 2 other flats are mortgaged to me.
S3,
ST and T3 ಎರಡು ಬೇರೆ ಫ್ಲಾಟ್ಸ್ at ink page 84. Initially ಕೊಟ್ಟಿದ್ದು 2 ಫ್ಲಾಟ್, my lord, they have swapped the secured asset. That is the case, my lord.
Why did you swap it?
But they came forward and informed us
So
that
illegally you do
they have found borrowers, they have found buyers for the 2 flats that they had earlier mortgaged. Hence, we executed a discharge deed, before which itself the second mortgage was entered in.
That's all right. What is the 138 proceeding that you have now instituted?
130 on their failure
Check issued on which property?
My lord, check is issued in favor of the loan, man.
Which loan?
My lord, loan secured by
Loan which mortgage?
My lord, initially 1 mortgage was executed.
Which is that?
My lord, that is at ink page 49, Annexure C.
Annexure
C. A DTD was executed.
23rd December.
Wait, you wait, sir. Annexure C.
Please.
Page
49.
48,
Ink page 49.
49. 49. All right.
Please. ಇದ್ರಲ್ಲಿ 55 ಲಕ್ಷದ ಲೋನಿಗೆ
ಈಗ 55 ಲಕ್ಷದ ಲೋನಿಗೆ ಇದರಲ್ಲಿ ಚೆಕ್ ಕೊಟ್ರಾ?
My lord, check was issued at a later point of time when we had initiated proceedings. They came forward to settle the amount. Hence, along with interest, the check was issued for 66 lakh odd rupees. What has happened is flats have been swapped. Before executing the discharge deed, I had entered into a fresh mortgage for the 55 lakh loan. Only the flats have been swapped, my lord.
Where is the fresh mortgage?
The fresh mortgage is at ink page 84, Annexure F. Same, my lord, again for 55 lakh rupees.
Where have you indicated that you are swapping the properties? ಇದಕ್ಕೆ ಯಾವ ಚೆಕ್ ಕೊಟ್ರಿ? ಇದು 55 lakhs ಚೆಕ್ ಇದು.
My lord, check was given at a later instance along with interest amount, which is for 66 odd lakhs, my lord. That is at ink page 98.
Yes, that I have seen.
Please. It is only a swap of the secured asset, my lord. This is not the case where entire loan was repaid. That is exactly why SARFAESI proceedings have taken forward, and that they have not challenged admittedly.
Matter of evidence, sir. Alle.
Lord,
And my lord, this is with respect to only this petition. In the second petition, there is no such swap of mortgage.
ಅಲ್ಲಿ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲಿನೂ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿಲ್ಲ, ಅಲ್ಲಿನೂ SARFAESI proceedings initiate ಆಗಿದೆ. Another fact, my lord, which is not forthcoming in the petition is this. ಈ apartment complex ಅಲ್ಲಿ of the 2 petitions, 6 flats have been mortgaged to me. The underlying, my lord, land, site numbers 49 and 50 of that area were earlier mortgaged a few years back to PNB and Bank of Baroda. ಅದರಲ್ಲಿ NPA ಆಗಿದೆ, ಅದರಲ್ಲಿ auction ಆಗಿ ಅಲ್ಲಿ purchaser ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. When I went to take possession of my 6 flats, I got to know that this has happened. The auction purchaser has filed a petition before this court. There is a status quo quo 6 flats that I have taken possession of. That, my lord, my hands are tied. Here as well, if my hands are tied, my lord, I have no other remedy.
So, my lord, so far as this submission is concerned, my lord, the complaint is filed, PCR, my lord. In this case, my lord, this only one loan. Subsequently, they are changing their version, my lord.
No, whatever. That's a matter of evidence.
Lord, so
I will not sit and see which loan is for which
So far as
check.
my lord, the possession
It's
is
covered
taken
by
the
judgment.
bank, my lord.
Wait.
Possession is taken by them.
That's a SARFAESI proceeding that you take. This is 138 proceeding, is a matter of trial. Stay ಕೊಟ್ಟಿದ್ದೆ ಅಲ್ವಾ first?
Stay ಕೊಟ್ಟಿದ್ದು.
So far as my lord, the Punjab National Bank is not, I seek some time, my lord.
No.
Say, I take instruction from.
No, I won't rely on that at all. Which the earlier your thing.
My bless, it's not informed.
No, ಎಲ್ಲ you put up every defense there.
In the 138 proceeding, they admitted they have taken the possession, my lord.
All that is before the court. The only ground I granted stay was having initiated SARFAESI proceedings 138, whether it is maintainable or not. The courts have held it is maintainable.
My submission. when they have taken the possession, when I not challenged the proceeding, my lord, the.
That's a
138
different,
not
sir,
there, my
that,
lord.
that
If
you,
I
that
challenge.
you submit there.
My lord, if I challenge the section that Surface Act proceeding, my lord, this complaint is maintainable. But I not challenged the
No, no,
proceeding. Then in this case, my lord.
That's all right. The discharge is not per se discharge. There is some underlying contract between both of you.
But they have stated in the discharge, deed, my lord, clearly that the loan is
You
clear.
put that up in evidence, sir. The petitioner is before the, Ibru one petitioner, huh?
Already, father.
Father and son.
Father, 2 crores.
The- These petitions are preferred by the father and the son, calling in question registration of the proceedings,
On submission.
institution of the proceedings for offense punishable under section 138 of the Negotiable Instruments Act. The petitioners in both these cases are borrowers from the hands of the respondent, the complainant, before the concerned court. On 16/12/2000, on 16/12/2019, the petitioner applies for a loan of 55 lakhs in criminal petition. Criminal petition
5268.
number 5268 of 2024. And in the other petition, ಎಷ್ಟು loan?
2 crores.
And in the other petition, an amount of rupees 2 crores.
By the father.
In terms of the loan so availed, it transpires that certain checks were handed over to the respondent bank in lieu of the swapping of the properties, i.e. the swapping of the mortgage that was subsisting between the parties. Therefore, a discharge deed had come to be issued against in favor of the petitioners, discharging certain properties and creating mortgage of certain other properties. When the loan became sticky, it transpires that the respondents have instituted SARFAESI proceedings against the petitioner. The issue in the list does not concern the institution of SARFAESI proceedings. Simultaneously, it transpires the respondent bank invoked section 200 of the CRPC before the learned magistrate for offense punishable under section 138 of the Negotiable Instruments Act. The proceedings have gone on since the institution in the year 2022. The petitioner is now before this court on a solitary contention that the loan is discharged completely by the acknowledgement of the bank itself, and once having instituted SARFAESI proceedings, the proceedings under section 138 was not maintainable. The learned counsel appearing for the petition.
Possession is taken, my concerns.
And the bank has already taken possession of the property, and therefore the 138 proceedings should not be permitted to be continued. The learned counsel appearing for the petitioner would reiterate the grounds that are urged in the petition. Per contra, the learned counsel appearing for the respondent, bank would submit that the petitioner comes forward to settle the dispute, to settle the loan by issuing a check pursuant to which a discharge deed was issued and the property was swapped against a fresh mortgage that was entered into with regard to a different property which the petitioner owned. The loan amount that was granted to these petitioners run close to 2 crores and 55 lakhs, which the learned counsel submits has become sticky, and the bank has instituted proceedings and taken possession of. The issue therefore revolves around the discharge deed executed and the fresh mortgage created qua the parties for against the loan that was taken by them. He would submit that these are all a matter of trial, and there is no ground to interfere at this juncture, particularly on the score that once having instituted SARFAESI proceedings, it is not open to the bank to invoke 138 of the section 200 of the CRPC for offense punishable under section 138 of the Negotiable Instruments Act. He would seek to place reliance upon 2 judgments rendered by one rendered by the High Court of Punjab and Haryana, and the other by the High Court of Madras. I have given my anxious consideration to the submissions made by the respective learned counsel and have perused the material on record. The afore narrated facts are not in dispute as they are all a matter of record. What has driven the complainant respondent to the concerned court is the check that is issued in favor of the bank. The check is admitted. The check is admitted, though the contention is it was issued as a security. All hinges upon the submission of the learned counsel of the petitioner that a discharge deed is executed by the bank on clearance of the loan. The discharge deed is appended to the petition. The submission is refuted by the learned counsel appearing for the respondent, contending that discharge deed was executed on handing over of a check in exchange of other discharge, in exchange of creation of the fresh mortgage, which are also appended to the petition. If that be so, it clearly becomes a matter of trial for the petitioners therein to come out clean. The issue with regard to maintainability need not detain this court or delve deep into the matter, as the High Court of Punjab and Haryana in so and so. Paragraphs in
9.
Which one?
Punjab and Haryana. Ma'am.
The High Court of Punjab and Haryana in so and so has held as follows, para 9. And the High Court of Madras?
In the second case, my lord, page 15, just above para 13, my lord, para 12, the last 6 lines.
Para 12.
Para 12, the last few lines, my lord,
12
on
and-
page 15.
12 and 13 up. I am in respectful agreement with what the High Court of Punjab and Haryana and High Court of Madras have so held, that section 138 proceedings can be maintained, notwithstanding the initiation of proceedings under the SurFace Act, the SurFace Act 2002. In that light, all the submissions made by the learned counsel to the petitioner would become unacceptable. The petition thus stands rejected, reserving liberty. Thus stands rejected. Yes.
Let me begin.
For what?
What is the grounds taken?
The petitioner, ಯಾವ ಈ ground ಮತ್ತೆ?
But ಅದೇ ನಾವು
Not maintainable. The except the maintainability, ಅಲ್ಲೇನಾಗಲ್ಲ ಬಿಡಿ ಅದು. The petitioner is at liberty to urge all other grounds that are not considered in the case at hand before the concerned court.
Please.
I'm grateful.
Next.
But 10?
Here for petitioner in this case, the punishable offense under section 306.
306, sir.
Password under some files.
ಇಲ್ವಾ?
Yesterday ಇತ್ತು ಅದಕ್ಕೋಸ್ಕರ.
Demand of loan. ನೆನ್ನೆದಲ್ವಾ ಇದು?
ಹೌದು ನೆನ್ನೆ ಇತ್ತು.
Get the file. Password. Password ಆಗಲ್ಲ ನಾಳೆ. Plus tomorrow. Investigation papers ಅಲ್ಲಿ?
File ಅಲ್ಲಿ.
Yes.
11?
Copies has been
Huh?
served, copies has been served on the other side. Even process ಇವತ್ತು ತಗೊಂಡ್ಬಿಟ್ಟು.
ಏನ್ ಗ್ರೌಂಡ್ ಹೇಳಿ ಸರ್? ಅವತ್ತೇನೋ 4:15ಗೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬಂದಾಗ ಏನೋ ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ, ಇವಾಗ ಹೇಳಿ ಏನ್ ಗ್ರೌಂಡ್?
ಅದು ಆಕ್ಚುಲಿ in this there are 3 grounds. ಒಂದೇನು ಅಂತಂದ್ರೆ they deny that they have taken
What
purchase.
have you challenged now?
Now it's a 138 proceedings.
ಅದು ಗೊತ್ತು.
And
Set aside the order. 3424, what order is that?
ಅದು 91 CRPC with read with
What's wrong with the order?
ಇದರಲ್ಲಿ ಏನು ಅಂತಂದ್ರೆ
What's
They have-
wrong with the order?
that's what the the court has observed that if they do not furnish the stamp paper, it will affect those people itself, means the complainant himself. But ಇದರಲ್ಲಿ ಏನು ಅಂತಂದ್ರೆ ಸದಾಶಿವ
ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಕರೆಕ್ಟ್ ಆಗಿ. Tomorrow in the fresh matters list. Yes.
ಅಲ್ವಾ?
Next.
Interim order ಇದೆ.
Interim order subsisting shall continue to the next date of hearing. ನಾಳೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀವಿ.
Please,
Yes.
both the cases.
Both the cases. ಆಧಾರ್ ಕಾರ್ಡ್ ಆಯ್ತಲ್ಲ?
Please. Both.
ನಿಮ್ದಾಯ್ತು ನೆಕ್ಸ್ಟ್ ಕೇಸ್. ಎಸ್,
ಮತ್ತೆ
tomorrow
petition.
ಓದ್ಕೊಂಡ್ ಬನ್ನಿ.
For petitioner, my lord.
Huh.
The allegation is under 376, 420 and.
Why have you got this man here, settlement?
Yes, in the last date of hearing, your lordship directed us to keep present the petitioner before. the
Who
court.
said?
Lordship directed us to.
Who said?
I was there. I was the person who.
Where I passed an order?
No,
Then
but your lordship directed us to keep him
for
present.
what purpose?
Is there any chance of settlement at that?
Where, with what chance of settlement? He ran away to get his Aadhaar card, ಅದೇ ತಾನೆ?
Adhe Swami. Idರಲ್ಲಿ 376 ಬರಲ್ಲ, there is a delay of 3 years. They are in love from past 8 years. my
That's
lord.
all right.
Both are major.
No, why did you go up to the stage of marriage and run away?
It is only due to the quarrel between the families,
Ah.
these petitioner and the second respondent filed cases against each other.
It's all right, sir. Engagement ಆಯ್ತಾ?
ಇಲ್ಲ, ಟೆಂಪಲ್ ಅಲ್ಲಿ ಮದುವೆ ಆಗಿದೆ ಅಷ್ಟೇ
Temple
ಅಂತ
ಮದ್ವೆ
ಅವ್ರು
ಆಯ್ತು.
ಹೇಳ್ತಾರೆ.
Why did you run away then?
But 3
He
years.
is married
ಆದ್ಮೇಲೆ-
now?
ಇಲ್ಲ, ಮದುವೆ ಆಗಿಲ್ಲ sir.
The girl is married.
ಇಲ್ಲ, ಇಬ್ರು ಮದುವೆ.
So if you want to get married, you can get married.
But the allegations are
That
not.
we'll see. Why did you run away? ಎಲ್ಲ ಆದ್ಮೇಲೆ.
ಅಲ್ಲ, he has not run away ಸ್ವಾಮಿ. ಅವರು ಅದಂತ they are alleging ಅಷ್ಟೇ.
ಮತ್ತೆ ಏನ್ ಮಾಡಿ ನೀವು ಹೋಗ್ಲೇ ಇಲ್ವಾ ಅಲ್ಲಿಗೆ?
ಮದುವೆ ಆಗಿ ಆಮೇಲಿಂದ ಜಗಳ ಆಡ್ಕೊಂಡು ಒಬ್ರೊಬ್ರು ಸಪರೇಟ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವರೇ 50,000 ರೂಪಾಯಿ ಕೊಟ್ಟು ಇವ್ರಿಗೆ ಹೆಲ್ಪ್ ಮಾಡಿದ್ದಾರೆ ಬಿಕಾಸ್ ಇಟ್ಸ್ ಅನ್ ಇಂಟರ್ ಕ್ಯಾಸ್ಟ್ ಮ್ಯಾರೇಜ್. ದಟ್ ವಾಸ್ ದ ಪ್ರಾಬ್ಲಮ್. His parents are not accepting
Let's
the
see, let the
relationship.
respondent come. Serve ಆಗಿದೆಯಾ?
We have taken the process as per the direction of this honorable court.
List immediately after service of notice upon the second respondent.
Interim order.
Interim order subsisting shall continue till the next date of hearing.
Punjab.
Put up the matter immediately after service of notice without a memo from the hands of the court, from the court. Memo moved before this court. Yes, next.
Much obliged.
13.
My lord, first petitioner, my lord. This is school matter.
I'll place the paper, ma'am.
ಎಲ್ಲಿದೆ?
I'll place it, ma'am.
ಕೊಡಿ ಪಾಸ್ವರ್ಡ್. ನೀವು ಪ್ಲೇಸ್ ಮಾಡಿದ್ರೆ ನಾಳೆ ಹಾಕ್ತೀನಿ. ಲೆಟ್ ಮಿ ಸಿ ಅಂಡ್ ಕಮ್. ಎಸ್, ನೆಕ್ಸ್ಟ್. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಪಾಸ್ವರ್ಡ್.
14.
Matter last time, lordship asked me to verify whether charges have been framed. Lord, apparently.
Mic use ಮಾಡಿ.
12/9/2020
Mike.
On 12/9/2022, charges are framed. But the issue is.
Petition ಹಾಕಿರೋದು ಯಾವತ್ತು? 18 June. Yes, sir.
Kindly, no, one issue, without compliance of section 207, without supplying the copies of charge sheet.
That is a separate cause of action. You can urge that,
Can
but
that,
not
can
costing
the
of the.
charges be framed at all? That's the next issue.
It's a different thing. 207 ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ಅದ್ ನೋಡು.
ಅಲ್ಲೇ ಇದೆ order sheet. Kindly come to page 208.
You are,
Page
you
60.
are asking quashment of the complaint, quashment of the FIR,
No.
quashment of the charge sheet.
Lord, we have
That I
filed,
will not entertain when charges are framed.
now we have filed the amendment application. Lord.
Amendment 207 matra you can, you file a separate petition. This is in the form that it is there, I will not entertain.
With that liberty.
The learned counsel appearing for the petitioner submits that the charges have been framed on 29/11/2022, 2 years
12,
prior to
12,
29/12/2022.
12/9/2022.
12/9/2022, 2 years prior to the filing of the present petition itself. But he would contend that under section 207, no documents are furnished to the petitioner and the charges are directly framed. If that be so, it is a separate cause of action for him to challenge the said order and not call in question the entire proceedings. The learned counsel at this juncture seeks leave of this court to withdraw the petition, reserving liberty to raise a challenge if he so desires.
Please.
Reserving such liberty, the petition stands disposed.
Please.
15.
Petition.
Appearing for petition, respondent number
Complaint and counter complaint, my lord, the investigation officers are different.
ನೋಡ್ತೀನಿ ಅಂದ್ರೆ ನೀವು ಡಿಫರೆಂಟ್ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ಸ್ ಅಂತ.
Yes, madam. The charge sheet submitted by the different police investigation officers.
Different charge sheet file ಮಾಡಿದೆ.
ಮತ್ತೆ this is the precise reason why your circular is there.
Yes.
Anywhere.
Respondent number 2.
Complainant.
Learned counsel so and so undertakes to enter appearance for the respondent. They register to print the name of so and so as appearing for the respondent. Yes.
ಅಲಿಯಮ್ಮ ಅಂತ ಹೇಳಿ.
Huh? ಅದೇನಾರಾಗ್ಲಿ different. Then we'll have to say something about it.
You have to say something.
Because every time you're doing this, case and counter case, it should be a single investigating officer.
Circulars also have been issued.
ಅದು ನಾಥಿಲಾಲ್ ಇದೆಯಲ್ಲ ಜಡ್ಮೆಂಟ್
That is judgment.
ಕೊಟ್ಟಿದ್ದೀರಾ ಕೊಡಿ
Yes.
ಕೊಡಿ ಇದು. ಇಲ್ಲಿದೆ ಸರ್. ಅದಲ್ಲ ಅದು ಕೊಡಿ ಜಡ್ಮೆಂಟ್. ನಿಮ್ ಸರ್ಕ್ಯುಲರ್ ಅಲ್ಲಿ
Circular may have placed it in different case, not in this case.
the yes, you have something to say.
ವಕಾಲತ್ ಇವತ್ತಷ್ಟೇ ಫೈಲ್ ಮಾಡಿದೀವಿ
ಹಾ?
ಮಲಾಡ್. ವಕಾಲತ್ ಇವತ್ತಷ್ಟೇ ಫೈಲ್ ಮಾಡಿದೀವಿ ಮಲಾಡ್.
ಜಗದೀಶ್ ಇದು ಕೊಡಿ ನಿಮ್ ಸರ್ಕ್ಯುಲರ್ ಎಲ್ಲ ಕೊಡಿ.
I'll ಕೊಡ್ತೀನಿ.
We'll pass a detailed order so that this problem does not crop up again.
Yes.
List on 21st in the fresh matters list. Interim order subsisting shall continue till the next date of hearing.
16.
Paper, system. The complaint against several cases was pending before the lower court fell.
Heard the learned counsel so and so. All other issues would merit entertainment of the petition. What was necessary to be noticed was only the offence punishable under section 354A. A perusal at the complaint would clearly indicate a squabble between the petitioner and the complainant. The petitioner has registered a crime on 21st, has communicated the complaint to the Nagarabhavi police station on 21st March 2024. After the said complaint being communicated, the impugned complaint comes to be registered by the complainant, alleging several offences, including the one punishable under section 354A. The narration is that when the complainant was alone near the police station, all the events have happened. The
For passing the order. Well, the several.
one
case
ನಿಮಿಷ
was-
ಸರ್.
The several
One
case was
ನೀವು ಸುಮ್ಮನೆ
pending.
ಇದ್ರೆ ದನಪ ಸರಿ ಇರುತ್ತೆ.
ಇಲ್ಲ.
Yes, have happened near the police station, which is completely shrouded with improbability of such happening even. Therefore, there shall be an interim order of stay of all investigation against the petitioner till the next date of hearing. One HCGP, two emergent notice.
The two
Several
notices have
cases
been,
was pending before the honorable court.
ಈಗ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಲ್ಲ.
two notices have issued to complainant. She's not even cooperating.
She will not cooperate. She registered so many cases.
Notices or.
ಇಲ್ಲೂ ಬರ್ದೇ ಹೋದ್ರೆ next we will pass orders.
Yes.
This is the habit. 354A is misused by, for such reasons. Yes, ಅದು ಕೊಡಿ ದನಪ ಇಲ್ಲ.
I'll place this material. Notices have
ಅದು
been issued.
ಅದು ಕೊಡಿ ಇಲ್ಲಿ. ಇಲ್ಲಿ ಬರ್ಲಿ, ಇಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆಯಾ? ಆಗಿಲ್ಲ. ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಮುಂದೆ 354A ಆಯ್ತಂತೆ, ಪೊಲೀಸ್ನವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ. That's the allegation. This is the way, yes. ಇರ್ಲಿ ಇದು.
ಮತ್ತೆ ಬಂದು ನಾವು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದು ಎಲ್ಲದ್ರಲ್ಲೂ ಅದೇನೆ. See, if you see the nature, allegation of 354A in every case, compromise later.
Two notices we issued because we have to record 164 statement.
But
It doesn't come.
don't come. Yes. ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ. Emergent notice returnable by the 4th of September. Yes.
17.
Split up charge.
Not to. ಯಾರು ಅಕ್ವಿಟ್ ಆಗಿದ್ದಾರೆ?
A2 to A5, A6 my lord, sir.
You are A6.
I'm A1.
A1. What is your role? A1 ಹೆಂಗೆ how it applicable? ನೋಡಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ. Judgment my lord is 2023 my lord.
ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ?
Will hack.
ನಾವು ಹಾಕಿಲ್ಲ.
EM
20
report.
Why did you escape trial?
I am serving my lords in the army. Hence my lords I did not. Thereafter my lords I am arrested my lords and now by virtue of the bail granted by this honorable court I am out. Thereafter I have challenged this case.
ಬೇಲ್ ಸಿಕ್ಕಿದೆಯಾ?
Take it. I have annexed that order also.
Yes.
ಹೊಡೆದಿದ್ದಾರೆ ಆಮೇಲೆ
ಆಗಲ್ಲ
ಟ್ರೀಟ್ಮೆಂಟ್
ಒಂದು
ತಗೊಂಡು
ಮೂರ್ ದಿನ
ಮನೆಗೆ
ಆದ್ಮೇಲೆ
ಬಂದ ಮೇಲೆ ಮತ್ತೆ he has developed something and thereafter he died.
ಆಯ್ತು ಮಾಡು.
Overtaxed against A6.
We'll see. We'll post it on, ಈಗ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಾ?
Stay.
302 ನಿಮ್ಮೇಲೇನು 201?
ಇಲ್ಲ, ಹಾಲಲ್ಲಿ ಹೊಡೆದಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ. ಹೊಡೆದಿದ್ದಾರೆ. No weapon, my lords, is in this.
Just look into it. It's not.
It's not, but only thing is if the appeal has been filed ಅಂತ ಅಷ್ಟೇ.
ಅದು ನೋಡಿ, yes, placed on 22nd, 28th August in the fresh matters list. The learned counsel appearing for the petitioner submits that Quay accused number
A2 to A5.
A2 to A7,
A5.
A5, the concerned court has acquitted those accused on account of lack of evidence for the offense punishable under section 302 inter alia. The learned counsel for the petitioner submits the petitioner is arraigned as accused number 1 and was in employment in the army at that relevant point in time. But the evidence would go otherwise is what the learned additional SPP would contend, and he would further submit that the acquittal order is of the year 2023. He would verify whether any appeal has been preferred against the said order of acquittal in acquittal. In that light, list the matter on 28th till such time further proceedings against the petitioner shall remain stayed. Yes, next.
18.
Post immediately after service of notice of stay ಇದೆಯಾ?
Stay ಇದೆ. First serve ಆಗಿದೆ ನಾವು.
ಹಾ?
Respond to serve ಆಗಿದೆ.
ಎಲ್ಲ ಸರ್ ಒಂದ್ರಲ್ಲಿ ಆಗಿದೆ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಆಗ್ಬೇಕಲ್ಲ.
ಅವರೇ ಸೇಮ್ ಆಫೀಸರ್.
ಸರ್ವ್ ಆಗ್ಬೇಕಲ್ಲ. ಅಡ್ವೊಕೇಟ್ ಆದ್ರೆ ಏನೋ ಹೇಳ್ಬೋದು ಅವ್ರಿಗೆ ತಗೊಳ್ಳಿ ಅಂತ.
ಸೇಮ್ ಆಫೀಸರ್.
Post immediately after service of notice upon the second respondent, interim order subsisting shall continue to the next date of hearing. Registry to put up the matter for admission the moment a second respondent enters appearance. The counsel for the second respondent enters appearance. Next. Huh? ಹೌದಾ? ಕೊಡು. 1 minute. Civil rights enforcement, police, you can take notice.
No, C. Jagdish.
As the learned counsel C. Jagdish is directed to accept notice for the second respondent, Eradalu madam. 17, 18 and 18.1. C. Jagdish is directed to accept notice for the second respondent. Petitioner to serve set of papers upon counsel Shri C. Jagdish. Registry to print the name of C. Jagdish as appearing for the respondent. List the matter on 28th. Interim order subsisting shall continue till the next date of hearing.
19.
This case I have the petitioner, my lords. This case came up yesterday, my lords. Charge sheet has been filed in just 1 day, my lords. FIR registered on 10/8.
Taken 173 very.
Huh?
They've taken 173 in literal sense.
ನೆನ್ನೆ ಹೇಳಿದ್ರು ತುಂಬಾ ಸೀರಿಯಸ್ ಆಗಿ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ 173. ಯು ಹ್ಯಾವ್ ಟ್ರಾವೆಲ್ಡ್ ಬಿಯಾಂಡ್ BNSS.
Yes.
ಅದು 6 ತಿಂಗಳು ಕೊಟ್ಟು ನಾವು 6 hours ಅಲ್ಲಿ ಮುಗಿಸ್ಬಿಡ್ತೀವಿ. What sort of investigation? Yes. Anything else? But complainant ಯಾರು?
Sumotamal police.
Somota. We close it? ಏನು ಈಗ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದೀರಾ ಅಂದ್ರಲ್ಲ ಏನು?
I'll verify any other antecedents against this.
ಆಯ್ತು ನೋಡಿ, ನಾಳೆ ಬೇಡ. Thursday, yes. List on Thursday, interim order subsisting shall continue to the next date of hearing.
20.
But I appeal for the petitioners. The petitions are the daughters of the respondent. Proceedings initiated under section 125 of CRPC. But chapter 9 of CRPC is not applicable in case of the daughters, my lord. If the respondent has got a son to be taken care of, my lord, the proceedings.
ಏನು maintenance act?
Maintenance.
Why daughter should not maintain the father, is it?
But when the son is there.
What has happened to the son?
But he is living with his mother.
Hmm.
And my lord, one of the property has been jointly
Oh,
sold by the respondent and his son.
So what?
But
Daughters
other
daughters also have a duty to maintain.
But there are other properties, my lord, available for the joint family property.
Who's the respondent here?
My mother, our mother.
Sir, your mother ಕೂಡ ಕಷ್ಟನಾ?
Allah, when the son is there, my lord, and there are joint
Let's
family
see,
properties.
you serve on
available.
the council who represented the respondent. Petitioner
Notice has been served. my lord.
ಆದರೂ ಸರ್ವ್ ಮಾಡಿ. Petitioner ಸರ್ವ್ ಆಗಿದೆ, ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್?
No, my lord, warrant has been issued to the petitioner.
Correct.
But
So what?
pray for the stay of the,
Wait, sir. ಎಷ್ಟು arrears, sir?
but as on today, my lord, it comes to 6,60,000.
Deposit money.
My lord, daughters are not,
No, that
they have
will
got,
cease.
they were married in long back, not
That
25
will
years
cease,
ago.
that will
And they are living with the husbands.
Property ಯಾವ್ದು ಬೇಡವಾ? Ancestral
But
property.
a suit has been filed by the petitioners here and I produced the copy of
For
the,
what? Suit for what?
for partition, my lord.
Why do you want the property?
But one of the property, joint family
Why do,
property has
yes,
been
sir,
sold for a
maintain,
partition sum.
you for maintaining the mother, you don't want to maintain, but property you want.
But they have got the income to be, they are getting 10,000
Yes,
rupees
yes,
per month
sir.
as the rent. And there are
Deposit,
agriculture, there
deposit
are
3 lakhs.
agricultural properties, my lord.
Deposit 3 lakhs, sir. Or you have nothing to do with the mother.
But,
180. We'll post it next week.
pray for stay of the,
Stay under deposit.
but I will deposit.
I will decide whether daughters are liable to pay or not or whatever.
Please.
The liability has not sprung yesterday. What is the date of the order?
The date of the order, my lord.
Revision dismiss ಆಗಿದೆ.
Revisionally,
ಮತ್ತೆ?
but the grounds for dismissal of the revision that.
That
my lord,
will see.
I will have to approach.
Sir,
this
you have
court
lost
under
before both the
section
fora.
126.
You have lost before both the fora.
My lord, we were placed ex parte before the trial court. I have produced the copy of the order. sheet, my
Revisional
lord.
court ಅಲ್ಲಿ ಕೇಳಲಿಲ್ವಾ?
ಅಲ್ಲ, ಇದರಲ್ಲಿ I have produced the copy of the order sheet.
No
In 2
problem.
days, my lord, the proceedings came to be,
You deposit, I will stay. You want to seek instructions? Seek.
I may be.
Deposit
I may
in
be
the-
permitted to deposit 2 lakh rupees.
All right, deposit. There shall be an interim order of stay of any kind of warrant that is issued against these petitioners, subject to the condition that they deposit 2 lakhs, 2 weeks?
Before the trial court,
No, before this court.
please.
Before this court in the next 3 weeks. List this matter on 3rd September,
And 4 weeks,
4th September,
4 weeks.
3 weeks. List the matter on 3rd September in the fresh matters list. Yes. Next.
21.
For the petition, my lord. Offenses under section 465, 420.
ಇದೆ 4 petition.
Allegation is same, my lord. The petitioner has given a false marks cards to the accused number A1 to A1 to A3, my lord. And he getting.
Charges as framed, my lord, on 27/9/2018.
27/9?
2018, and almost 6 witnesses have been
My
examined.
lord, your lordship has quashed, my
The
lord.
petitioners
My lord,
are before this court calling in question.
kindly come to the annexure, my lord.
No, sir.
Sir, your lordship has quashed the A4, my lord.
ಯಾವ್ದು ಕೊಡಿ?
Another same allegation, my lord.
Not in this crime, my lord.
In this crime, another crime, my lord. Annexure G, my lord, page number 61, my lord. After framing of the charges, my lord.
Framing of charge ಆಗಿರ್ಲಿಲ್ಲ ಅಲ್ಲಿ. Charge sheet ಮಾತ್ರ ಆಗಿದೆ.
No, my lord, same, my lord, I will produce the
No,
order
no,
sheet, my lord. I will produce the order sheet.
No,
my
no,
lord.
no. I am not going to entertain this petition. This is a different crime, sir. How did you say same crime accused number 4?
Kindly see, my lord, for a moment, my lord.
No, no. Is it the same crime?
No, my lord, different. But accused are same, my lord.
Yes. The crime, the petitioners in all these cases call in question the proceedings in CC 88 of 2017, which arose out of crime number 159 of 2013 for several offences. The learned counsel appearing, learned HCGP on instructions would submit that the charges have been framed. Idya 4-5 order idiyalla, what is this?
Yes, my lord.
Yes, government?
My lord, this is with respect to this different crime, my lord.
Different crime allegation.
And
are same,
accused
my
are different, my lord, where the honorable court was pleased.
No,
to-
crime number 158 ಅಂತಾನೆ ಇದೆ.
lord. In annexure G, my lord, he is a A2, my lord.
No, that's because coordinate bench had
Bench,
quashed, I
yes,
followed that.
Pleased, my lord, that is,
No, no. First, your lordship has passed the order, my lord. Thereafter, coordinate bench has followed the order.
No, no, coordinate bench has first quashed.
No, no, December, my lord.
first,
Nಮ್ದೇನಾ?
annexure is the first order, my lord.
Annexure G,
Was
my lord.
followed
Kindly see, my
subsequently.
lord.
Then see if it is
In 24/8/2020.
identical ಅಂದ್ರೆ, that's crime number 159. What is quashed? This is 158.
In another 4 connected matter already listed in the coordinated bench, ma'am.
ಅದು ಕ್ವಾಶ್ ಆಯ್ತಾ?
No, my lord, this, it to come, my lord. Last week as this time, my lord, but not.
ಒಂದ್
available.
ಕೆಲಸ ಮಾಡಿ, ಅದನ್ನ ಕ್ವಾಶ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬನ್ನಿ, ಆಮೇಲೆ ಮಾಡ್ತೀನಿ. ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚಲ್ಲಿ ಕ್ವಾಶ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ. Yes. List the matter on 22nd. Yes.
Please.
22nd, but 28th.
Please do. Lots of substantial offense alleged is under section 7, 8 of POCSO Act and section 324 IPC. The lordship will kindly look at the complaint, my lords. The lordship gets the complaint at page.
Yes, sir.
Page 13.
What is the allegation against you?
The allegation, my lords, is ನನಗೆ 8th line from bottom, my lords, at page 13. ನನಗೆ ನೀರು ಸಿಕ್ಕಿಲ್ಲವೆಂದು Salma, that is petitioner, ಅವರ ತಮ್ಮ
ಇದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವಾ?
ಅಲ್ಲ ಇದು POCSO Act, it doesn't attract POCSO Act. There is no
That will see,
sexual
charge frame ಆಗಿದ್ರೆ I will not
Like
entertain.
20, FIR is 2020.
2022.
4.
ಮತ್ತೆ ಇದ್ಯಾವುದು this page
The earlier
15?
complaint filed by the
14
same,
person has
earlier complaint
filed.
filed by the same complaint.
14 person has filed, it's all properly focused.
Yes, sir.
Let's offense under section 7 of POCSO Act doesn't arise because there is no sexual intent contained. It, that ingredient is absent in the complaint.
ಅಲ್ಲೂ ನೀರಿನ ಜಗಳ, ಇಲ್ಲೂ ನೀರಿನ ಜಗಳ.
Huh?
ಯಾವಾಗ್ಲೂ ನೀರಿನ ಜಗಳ, ಈಗ್ಲೂ ನೀರಿನ ಜಗಳ.
Oh, this is water tank.
Water tank.
Yes. Yes, sir. Stay ಮಾಡಿದ್ದೀನಲ್ಲ.
Yeah, please. And 324 also doesn't attract because it's all, there's no intention to commit the offense.
Oh, this 14% appeared.
14%.
Okay, now you are, ನನಗೆ ಗೊತ್ತಾಗ್ಲಿ ಯಾವ್ದಿದು. All right, yes. Notice complaint, notice ಆಗಿಲ್ವಾ? Emergent notice to the respondent, the learned counsel XM Joseph appearing for the petitioner. Emergent notice to the additional SPP accepts notice for the first respondent. Emergent notice to the second respondent returnable by the 11th of September. There shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Okay. ಮುಂಚೆ ಬರೀ not to take coercive steps ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ. Yes.
Okay.
Lord, fear for petitioner. Matter related to the release of the ultrasound machine, my lord.
Yes, sir.
Really, they have not,
Renewal ಆಗಿದೆ ಎಲ್ಲಿ provision you said?
my lord, kindly see page number 33, my lord. Lord, the rule 8 of the PCPNDT rules is very clear. When a applicant file an application for renewal of the license within 30 days.
1 minute, sir. Page 33.
33, my lord, this is
Application.
renewal application, my lord,
Yes.
that I have filed within 30 days.
All right.
Lord,
Which
rule
rule is
8,
that?
rule 8 of the PCPNDT rules.
Now, what is the allegation against you?
My lord, that the only basis on which my ultrasound machine has been seized, that the license has not been renewed. My lord, kindly see rule number 8.6. Lord, may I read it?
Yes, sir.
In the event of failure of the appropriate authority to renew the certificate of registration or to communicate the rejection of application for renewal of the registration within a period of 90 days from the date of the receipt of application for renewal of the registration, the certificate of registration shall be deemed to have been renewed. My lord, kindly see my.
What is the date of the application?
My lord, date of the application is 26/9/2023, my lord.
26/9?
26/9/2022. My lord, kindly see my license in page number 29. My lord, the first paragraph, that's the last one, it prescribes the license, the period of 5 years ending on 29/10/2022.
All right. ನಿಮ್ಮ application ಯಾವತ್ತು?
My lord, I filed an application on 26/9.
22 or 23?
23, my lord.
Date of the application, sir.
My lord, that is in page number 33. Kindly see the acknowledgement, my lord, in the last.
1 minute. 22, 23, 23
ಅಲ್ಲಲ್ಲ,
ಅಂತ ಇದೆ.
acknowledgement ಕೆಳಗಡೆ acknowledge seal ನೋಡಿ sir.
26/9/23 ga.
ಹೌದು sir.
Why did you file 1 year later?
ಅಲ್ಲಲ್ಲ, 22, sorry sir, 22. 22 sir. I'm sorry.
So 1 month ಮುಂಚೆನೆ ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದೆ. Reject within
ಇಲ್ಲ
90 days.
ಆಗಿದೆಯಾ?
No.
ಎಲ್ಲಿದೆ?
Com-
Communicate
I
ಮಾಡಿದ್ದೀರಾ?
have not received any communication, my lord. The seizure is not with respect to non-registration. Seizure is with respect to violation.
No, my lord, there is, my lord, this law has been enacted to prevent the sex detection, sex determination
Correct,
and the
that's right.
female feticide, my lord.
Yes.
But there is no such allegation in the complaint, my lord. That the only basis on which,
ಅವ್ರ ಅದ್ರಲ್ಲೆಲ್ಲ ಅಲಿಗೇಷನ್ ಇದ್ರಲ್ಲಿ ಸೈಕ್ಲೋಸ್ಟೈಲ್ ಆರ್ಡರ್ ಇದೆಯಾ?
ಇಲ್ಲ,
ನೋಟಿಸ್ ಇದೆಯಾ?
page 6, sorry, para 6, my lord, page 16, complaint. Page 15, my lord, para 6. Like, this is a much detailed complaint, my lord, than last complaint. These are the violations found on inspection.
my lord, kindly see para 8, my lord.
Center's registration has expired on 29/10/2022. ಒಂದು
Yes,
ಆಯ್ತಾ? ಆಮೇಲೆ
they also accepted they are not maintaining records with regard
it is
to
for this complaint respectfully ಎಲ್ಲಿದೆ?
6E, my lord. 6E, my lord, para 6E.
Accepted, who has accepted?
They have
ಸುಮ್ನೆ
accepted.
ಹೇಳದ?
My lord,
Where is it
my
accepted?
lordship, I see D, my lord, on
My
inspection
lord,
of the
this is the
machine.
practice everywhere.
On inspection of machine, it was found that no images and patent details were not found, and it was not stored
Same,
in any.
ಎಲ್ಲ, no referral slips, form 2F, where are the records? Give the records.
I'll pay.
ಕೊಡಿ.
They have not registered in Karnataka Private Medical Establishment Act.
No, that license has been renewed, my lord.
Cyclostyle notice, cyclostyle ticking. No allegation of any kind, images ಇಲ್ಲ ಅಂತ ಎಲ್ಲಿದೆ?
This is how threatening all the ultrasound clinics, my lord, even the
Inspection of the
medical
machine.
practitioners.
Wait,
On inspection of the machine.
where is it? Where is the Panchanama or the master drawn of what you have done? ಇದಕ್ಕೆ ಗೈಡ್ಲೈನ್ಸ್ ಫಾಲೋ ಮಾಡ್ಬೇಕು.
My lord, there is
ಇವೆ,
a guidelines.
ಅದರಲ್ಲಿ-
My lord, there is a guidelines from
Records
the,
ಅದ್ರಲ್ಲಿ ತಗೊಂಡಿದ್ದೀನಿ. Friday will pronounce that.
Yes.
Yes, sir.
my lord, my ultrasound machine needs to be released, my lord. My lord,
Yeah,
that the act
forthwith-
is so draconian. My lord, once the charge has been framed,
Draconian.
Draconian, my lord, once the charge has been framed by the trial court, that the medical registration certificate issued by the Karnataka Medical Council will be suspended, my lord.
Allegation is that he has not have the place those Karnataka Private Medical
ಏನು?
Education Act registration
ಅದು
for him.
ಎಲ್ಲಿದೆ registration?
My lord, I have a registration, my lord.
Where?
Not place those material.
I have not produced it, my lord. I'll produce it.
But scanning machine, you permit him to operate.
Like without the license.
Which license?
The
It is
Karnataka Private
statutory
protection
Private
that
Medical
needs to be
Education.
extended.
Which license?
Karnataka Private Medical Education Act mandates that he should be registered there.
Huh.
Only then the
Where is that registration? Why have you not
My
produced?
lord, I have not produced it because
Produce it.
I'll produce
Produce
it, my
it
lord.
tomorrow.
Yes, my lord.
ಇದು records ಇರ್ಲಿಲ್ಲ. Yes, produce it tomorrow. Not a speck of allegation in anything.
I've told them, my lord, that to
What is
stop
this?
having that
Cyclosphere
printed
copy.
form of
Printed format ಸುಮ್ನೆ tick ಮಾಡ್ತಾ ಹೋಗೋದು, ಈ allegation, ಆ allegation. What do you think? You only harass these people.
I've instructed now because they have said that they have not implemented this act effectively. Only now they have started implementing. Therefore, all
Now the
this,
medical practitioners care to conduct the ultrasound scans, my lord.
ಒಂದು ನಿಮಿಷ. Yes.
There's a clear guidelines from the
No guidelines, sir. That is why I am laying down.
ಅಲ್ಲಲ್ಲ ಸ್ವಾಮಿ ಇದು
Friday I'll pronounce
Yes.
that. Yes. 3002 I'll pronounce that. Yes.
in fact,
ಇನ್ನೊಂದ್ರ ಜೊತೆಗೆ ಮಾಡ್ತೀನಿ.
fact,
Original
that is-
records ಅದ್ರಲ್ಲಿ ತಗೊಂಡಿದ್ದೀನಿ.
in fact, that is even worse than this.
Worse.
Adral-
ಅಲ್ಲ ಅದರಲ್ಲಿ you have seized the entire, closed the unit, seized everything. Notice ಕೊಟ್ಬಿಟ್ಟು you have seized everything. For what purpose did you give notice?
At least in the complaint also ಇದ್ರಲ್ಲಾದ್ರೂ ಸ್ವಲ್ಪ ಬರ್ದಿದ್ದಾರೆ ಜಾಸ್ತಿ, ಅದ್ರಲ್ಲಿ ಅದನ್ನು ಬರ್ದಿಲ್ಲ.
ಅದು ಬರೀ ಇಷ್ಟೇ ಟಿಕ್ ಮಾಡ್ತಾ ಹೋಗಿರೋದು ಅಷ್ಟೇ. ಅದು ನೋಟಿಸ್ ಕಂಪ್ಲೇಂಟು ಅಲ್ಲ.
Even PCR filed before the court. Even there, my lord, it is
Horrible it is. Yes. ನಾಳೆ ಕುಡಿಯೋದು. Will permit you to run the machine.
much of it.
Anyway, Friday you will get that order where all guidelines will be there. Yes.
For the petition. 86 and 87 of Karnataka Forest Act, my lord, without served summons issued NBW. Kindly page
Page?
page 19.
Without survey?
ಸರ್ವ್ ಆಗಿಲ್ಲ.
ಏನ್ ಸರ್ವ್ ಆಗಿಲ್ಲ?
Summons
Proclamation ಆಗಿದೆಯಾ?
proclamation issued, not followed.
82
The
not
82.
followed, yes. Then additional SPP is directed to accept notice for the
I will surrender before trial court and same
Respondent.
date consider.
The proclamation order shall remain stayed, subject to the condition that the petitioner would appear before the concerned court on the next, ಯಾವತ್ next date?
Separate split of ಆಗಿದೆ ಸ್ವಾಮಿ.
On the next date of hearing. ಆಮೇಲೆ will take up.
3-9 ಗಿದೆ.
3-9.
3-9 ಗಿದೆ.
IE on 3-9-2024.
Separate kits registered.
Split charge sheet ಗೊತ್ತು. First ನೀವು appear ಆಗ್ಬಿಟ್ಟು ಬನ್ನಿ.
ಆಯ್ತು.
List the matter on 5th September, 4th September. Yes. Next.
Same day recall the NBW. Recall ಆಗಿದೆ. same.
ಅದಲ್ಲಿ ಮಾಡ್ಲಿ. Yes. Stay application ಹಾಕಿಲ್ವಾ?
Pay application.
ಯಾಕೆ? ಆಯ್ತು appear ಆಗ್ಬಿಟ್ಟು ಬನ್ನಿ first and. The petitioner is directed to appear before the concerned court on the next date of hearing, i.e. on 3-9-2024. The court shall not direct any coercive steps to be taken against the petitioner. If any application is filed seeking recall of the order of proclamation, the concerned court shall pass necessary orders in accordance with law, notwithstanding the pendency of this petition before the court. Yes.
Much obliged.
List on 5th.
25.
I'm for the respondent to your lordship.
My lord, is a case of snapping of the zip cable, my lords. Now.
304A.
Please, 304A, my lords. But they have registered for 304, that's a grievance. Of course, in the present case now, we have approached, my lords, for an amicable settlement. Talks are going on, my lords. We wish to close it. We have also advised, my lords, as I submitted on.
304 ಬರಲ್ಲ, 304A. Please deliberately ಮಾಡ್ತಾ ಇದ್ದೀರಾ. Afternoon I'm pronouncing a few matters. Deliberately you invoke 304 so that it gets squashed. In cases which are clearly 304A. Yes.
Please, my lords.
ಆಯ್ತು ಮಾಡಿ.
Pray in the pending that consideration, my
2
lords,
weeks.
may kindly be placed to grant an interim order of stay for 304A, 304A only, not for 304A. Only for 304.
304A ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ 304 ಇದೆ, 304A let them continue.
337 ಇದೆ ಅಷ್ಟೇ.
304 ಮಾತ್ರ.
ಅಲ್ಲ 337 ಇದೆ.
337 and 304A may continue.
37 is okay, negligence. Yes, sir.
In fact, I'll verify, my lord, that whether any other incident happened in the same
ಇಲ್ಲ.
place.
I am submitting my lot.
ಅದಾಗಿದ್ರೆ viral ಆಗಿದೆ.
ಇಲ್ಲ ಇಲ್ಲ
ನೀವೇ
ಯಾವ್ದಾಗಿಲ್ಲ.
ನೋಡ್ಲೇಬೇಕಾಗಿಲ್ಲ.
ಇಲ್ಲ ಸರ್ ಇದು.
Your investigation is come down because every other investigation.
My learned friend ಬೇರೆ ಕೇಸಲ್ಲಿ IPC ಗೆ ಬೇರೆ ಕೇಸಲ್ಲಿ ಇದ್ದಂಗೆ
No,
ಕ್ರಿಮಿನಲ್
same
ಆಂಟಿಸಿಡೆಂಟ್ಸ್
place in-
ಇದ್ರೊಳಗೆ.
ಅಲ್ಲ ಅದ್ ನೋಡ್ಲಿ ಸೆಟಲ್ ಮಾಡಂಗ
ಆಗಿಂದ.
ಮಾಡ್ಕೊಳ್ಳಿ.
Not
We'll
set.
see. Yes. The council for the, whether it can be, it's settleable or not, I will say
That I do
later.
concede, my lord. We will report it. Now talks are going on.
ಆಮೇಲೆ I will not on, I am not directing any settlement.
No. It's between us, I do concede, my lords, but
The learned senior counsel PP Hegde submits that the talks of settlement between the parties are on and would report such settlement if any. It is made clear even after the settlement, the matter would be considered whether the matter is settleable or otherwise. List the matter on 10th September in the fresh matters list. Till such time further proceedings where the petitioner on the aforesaid reason shall remain stayed.
great.
Yes.
Obliged.
For the petitioner in this matter.
Awaiting police report.
Your lordship, may I make a, parties have entered into an amicable settlement. Part payment is also made.
What payment?
Yes, your
Yes,
lordship.
offense.
Initially, there was a complaint with respect to petitioner is a second
Offense
buyer,
ಏನು madam?
second buyer of a property. So there was a crime registered by the first buyer with respect to that. And now they have arrived at a compromise in that. Subsequent to that, he has lodged a complaint that he has allegedly trespassed into the property. This is that petition which has been stayed by your lordship. Now they have entered into a compromise and part payment is also made. So
ಏನ್ ಬೇಕೀಗ?
21st ಹಾಕೊಂಡ್ರೆ ಅಲ್ಲಿ file
September 21st.
August 20.
August. At the request of the learned counsel appearing for the petitioner list on 21st, the adjournment is sought on the score that the talks of settlement between the two are on and part payment has been made to the complainant. The submission is placed on record. Yes.
Remodel kind.
Interim order subsisting shall continue till the next date of hearing.
27.
Incident was occurred in the college premises. This yesterday it was seen, and this is accused number 1 is the petitioner. Charge sheet is filed for the both the parties in this case. It's technical ground as well as the merits. As per the charge sheet
We'll
itself.
answer this, yes. List this man. You take, accept notice.
Yes.
Whether contributory negligence will be applicable or not. Additional SPP 1, emergent notice 2, returnable by the 11th of September, list on 11th of September in the fresh matters list. Till such time, quay the petitioner, further proceedings in CC 3720/2023 shall remain stayed.
28.
138 proceedings, my lord. Application for a recall of warrant 70 clause 2 was filed. It came to be rejected.
Yesterday's matter.
Please, my lord.
Huh.
Now the issues lordship may kindly see is, he met with an accident and he has, there is an injury, it's major injuries for his spinal cord.
Page,
Page 48, my lords.
certificate,
Certificate is also page number 50, my lord. C3 and C7.
again ಬೇಕು.
Lordship, you can kindly see the warrant may be recalled. Permit me to work, I'll continue with there are two accused persons, there's accused number 2. I have no intention to procrastinate the matter. Since the warrant is pending, court did not proceed with the matter.
The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner is accused number 2. In a complaint registered by the respondent, the proceedings are pending before the concerned court for offense punishable under section 138 of the Negotiable Instruments Act. The non-appearance of the petitioner before the concerned court has led the court to issue a non-bailable warrant against the petitioner. It is the issuance of the said non-bailable warrant that the petitioner then approaches the concerned court filing a application to recall the NBW issued against the petitioner. That comes to be rejected on the same day on the score that the matter is posted for 313 statement of the petition. How do they record the statement now?
With the video can be done.
No.
Lordship, he is not.
You are an
resident,
accused, sir.
He's a resident of Andhra
Maybe.
Pradesh, Hyderabad.
I will only permit some time, that's all. The learned counsel for the petitioner has produced a medical certificate to demonstrate that he has undergone a surgery for C3 and C7 and C2-D1 fixation, an orthopedic surgery. The certificate so issued reads as follows. The certificate is dated 3/7/2024. Therefore, the petitioner had valid reason for not appearing before the concerned court, and the concerned court ought to have taken note of the fact that he had undergone surgery and was on a post-operative care. In that light, I deem it up. When do you appear, sir? I can't
As per the
exempt
record,
appearance at all.
3 months, my lord.
Huh?
As per the records, 3 months.
Tell you that 3 months, 3 months.
Request for
3
the 3
7.
months.
The certificate supra would indicate that he is unfit to travel and requires rest for 3 months. Therefore, the concerned court shall record the statement of the petitioner after about 8 weeks from today. After 8 weeks from today, any other application that is filed by the petitioner shall be considered on its merit owing to the ailment of the petitioner and his inability to travel. For the aforesaid reasons, for the present, the order dated 25/6/2024 issuing a non-bailable warrant against the petitioner stands recalled with the rider that he shall appear before the concerned court after 8 weeks from 8 weeks from today. Yes.
Petitioner.
Interim order there.
I've served the notice for the advocate, my lords.
List on 3rd September. Interim order subsisting shall continue till the next date of court.
Please, my lord.
ಇಲ್ಲ. ಅಷ್ಟೇ ಬಿಡು. The aforesaid observation, oh, disposal, correct. Ordered according.
30.
Lords, in
Okay,
this
for
matter,
respond number
for the
2.
petition.
This is a complaint filed with the DRA. When they went.
DRI.
DRA. May I pass on the instructions? I will file it on the as a statement of objections. That's for the background in which this information was lodged before the police for registering the FIR and for investigation.
ಏನಿದೆ? Objections ಹಾಕಿ.
Acting.
ಬಿಡಿ, ಇದು ಯಾಕೆ? File your objections. I'll take it in the first week of September. Yes. Learned counsel Sri M.N. Kumar submits that he has received instructions and he will file his statement of objections if 10 days time is granted. List the matter on 28th, on 4th September. Objections, if any, by then interim order subsisting shall continue till the next date of hearing.
My lords, on the last date, office objections were overruled, my lords, or the same is not.
Office objections, overall ಆಗಿದೆ ನೋಡ್ಬಿಡಿ ಕಾವ್ಯ ನೋಡಿದ್ರೆ. Office objections have already been overruled. The registry to verify the same. Yes,
And
next.
one more submission, state may be directed to say the status of the investigation. This is 2021.
Also, the learned additional SPP to secure the investigation papers and submit quay the stage of investigation. Yes.
Please, great.
ಆಗಿಲ್ಲ, overrule ಏನಾಗಿಲ್ಲ. Comply ಮಾಡಿ.
State, the first half it was overruled, my lords. However,
First half it was overruled, next half?
second half, the matter was
Is again
taken up for
restored.
consideration, but
Yes. ಏನ್ comply ಮಾಡಿ, what is the problem?
my lord, the office objection is that the court name is there is a mismatch in the court name, my lords.
Correct
However,
it,
recently, my lords, the courts have been termed as CJM, my lords.
redesignated. Fine.
Please.
All right, office objections overruled ಅಂತ ಇವತ್ತು ಮಾಡಿ. Yes, next.
Great.
31.
For petitioner, my lord.
138.
Under section 138 has been initiated, my lord.
No
The
ground.
agreement, my lord, was executed in the year 2018, my lord, in Andhra, my lord. The
Serve on the
petitioner also
council will
residing
see.
in Andhra, my lord.
Serve on the council, will see. Yes. Otherwise, no ground.
My lord, immediately, my lord, he files a complaint under 138, my lord, saying the full amount has to be paid,
Petitioner
my lord.
to serve on the council who represents the respondent in the trial proceedings and file an acknowledgement. List the matter on 14th.
Till then, my lord, proceeding,
No,
my lord.
Avat, get him, yes.
32.
Calling application was rejected, my lord.
PW one.
PW one and what is the? Pokso
376, my lord.
ಮತ್ತೆ PW one PW one ಮತ್ತೆ.
Even,
Huh?
it reject ಮಾಡಿದ್ದಾರೆ. Reject
If how 376 is facing, sir.
What happened, my lord? It is further cross examination was rejected, my lord.
What is rejected is further cross exam.
Further cross
Correct.
examination.
So what?
I produced the document exhibit D1, my lord. With regard to that, my lord, after the Trivanti statement, I produced exhibit D1, that is the social media conversation between the petitioner and the victim girl, my lord. That has to be confirmed only for that purpose, my lord. Even I cross-examined on the very same day, my lord.
ಅದನ್ನ ಹೇಳಿದಿರಾ ಇಲ್ಲಿ?
ಹೇಳಿದೆ. ನನ್ನ application ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ.
The petition will allow it. Jagdish.
Yes, my lord. And we cross-examined on the very same day, my lord. And that last occasion also we cross-examined on the very same day.
The petitioner is before this court calling in question an order dated 4/7/2024 passed by the concerned court in SC 39 of 2021, whereby the concerned court rejects the application filed by the petitioner under section 311 for recall of PW1 and PW17 for further cross-examination. Heard so and so. The petitioner gets embroiled in a petitioner is the accused, number one, the second respondent, the complainant. The petitioner gets embroiled in a crime having been registered on 17/10/2021 for offences punishable under section 328, 342, 376 of the IPC. The police, after investigation, file a charge sheet against the petitioner for the aforequoted offences. The issue in the list does not concern the merit of the matter. On 11/6/2024, on certain circumstances, the petitioner prefers an application under section 311 of the CRPC, seeking recall of PW1 and PW17. The concerned court rejects the same on the score that that PW1 and PW17 have been extensively cross-examined and there is no warrant to recall them for further cross-examination. The rejection of the application is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that there was a need to file the application in the light of the defense, in light of a document, DW?
One, my lord.
In the light of a document, DW allada. What document was it?
That is Instagram.
In the light of the exhibit D1, which was certain chats between the complainant and the petitioner. According to the learned counsel, that would cut at the root of the matter for the offense under section 376 of the IPC. Therefore, it was imperative for the court to consider the application favorably in favor of the petitioner. The learned additional SPP would refute the submission to contend that the matter is of the year 2021 and the petitioners, the only reason for filing the application by the petitioner is to drag the proceedings. I have given my source, therefore narrated facts. The application so filed by the petitioner, insofar as it concerns document exhibit D1, is as follows, reads as follows. Parish Matra, page 10 and 11. On the strength of the document exhibit D1, the application is filed that it would, the application was filed that the petitioner and the complainant were acquaintances and therefore the offense of 376 of the IPC were acquaintances and therefore he had to cross-examine the witnesses, witness PW1 and P17 yaru?
17, there is a call between the allegation that, my lord, he was confined by the petitioner, my lord. In between, there is a call between the complainant and the PW17.
So, all right.
That is with regard to CTR, my lord.
He had to cross-examine the witness PW1 and PW17. PW1 is the victim. PW17 is the one who receives the call between 5:10 to 5:25 PM on the day of the incident. The petitioner is facing a trial for offense punishable under section 376(1) of the IPC, which can lead to life imprisonment. Therefore, the court ought to have considered the application filed under section 311 of the CRPC, as the spirit of 311 of the CRPC is at any stage of the proceedings. The interpretation of section 311 of the CRPC need not detain this court for long or delve deep into the matter. The apex court in the case of Varsha Garg versus Union of India, so and so, has reported in 2022 SSC Online SC page 986, has held as follows, para 31 to 40 you extract. If the rejection or order of rejection, if the application, the objections, the order of rejection is pitted against the findings of the, pitted against the elucidation of the apex court in Varsha Garg, the application deserves to be allowed for the aforesaid reasons, the following order. The petitioner, the application filed by the petitioner is allowed. The court shall direct, the petitioner is permitted to further cross-examine PW1 and PW17. The cross-examination shall conclude on the day on which the concerned court would fix for such cross-examination. It is made clear that this would be the last straw of opportunity to the petitioner to further cross-examine PW1 and PW17.
Last occasion, one stage only cross-examined.
Ordered according.
Notice to R2 may be dispensed.
R2 cross-examine.
Party madidini, not necessary.
First ever notice to R2 is dispensed with. Heard so and so ಮಾಡ್ತೀವಲ್ಲ ಅಲ್ಲೇ ಮಾಡಿ. Yes, sir, you got time to come from the civil court? Huh?
Sorry, my lord.
ಎಲ್ಲ 4 ವಾರ ಅಡ್ಜನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ನಾನು.
Direction matter was there.
Yes, sir.
Lord, no, FLW was issued
Correct ಆಗಿದೆ.
without considering the fact that I have deposited 20% of the amount.
So
And the police are trying to arrest me in a FLW which is not permissible.
ದಳ್ವೆ ಅವರೇ ನಿಮ್ದು ವೇಟ್ ಸರ್. ಇದು ನಾಡಿದ್ದು ಬರಲಿ, ಏನು ಅರ್ಜೆನ್ಸಿ?
13th is the appearance. The
13th.
procedural defect is.
13th ಅಲ್ವಾ?
not
ನಾಡಿದ್ದು MPML ಡೇನೆ ಬರಲಿ.
It was listed on Thursday, Lordship.
No, let it come on 8th. 8th in the list on 8th in the fresh matters list. No, you said there was some problem on 8th, and so I thought list on 8th in the fresh matters list. Yes. ಈಗ ಬನ್ನಿ.
The court has issued the FLW.
ಈಗ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಅದರಲ್ಲಿ initially they have
Sir,
filed an application.
138 ಅಲ್ಲಿ proceedings are over now.
Oh, I will make it.
ಹೇಳಿ.
It was filed an application for completing the offense. The court has convicted, which was under challenge before the session court. In session court, my lord, the appeal was allowed. And the court said that you can recover the amount only under section 421.
421.
So the court, whatever the amount I have deposited without taking into consideration, is simply the court has issued a finally be warrant and the police are trying to arrest me in FLW.
Anyway, you serve on the complainant, will settle things here itself.
But till then,
The petitioner to serve on the counsel who represents the respondent in the trial proceedings. List list all these matters on 21st in the fresh matters list. Till such time, warrant of any kind hanging on the head of the petitioner shall remain stayed. Yes. You get it? Whatever settlement has happened, you close it here. Yes.
all other corrected matters.
All, ಎಲ್ಲೆಲ್ಲಿದೆ ನಿಮ್ದು? Numbers ಕೊಡಿ. 34, 35, 38, 39, 40, 41. Yes, all these. ಇದು ಅಷ್ಟೇ, ಥರ್ಸ್ಡೇ ಬರ್ಲಿ. ಅರ್ಜೆನ್ಸಿ ಏನು?
ಪ್ಲೀಗ್ ಇದೆ ನೋಡಿ.
ಹಾ?
ಥರ್ಸ್ಡೇ ಪ್ಲೀಗ್ ಇದೆ ಅಲ್ಲಿ.
ಏನು ನಾನ್ ಕಾಗ್ನೈಸಬಲ್?
ನಾನ್ ಕಾಗ್ನೈಸಬಲ್.
ಏನು ಒಫೆನ್ಸ್?
ಅಫೆನ್ಸ್ ಏನಂದ್ರೆ ಇನ್
ಎಲೆಕ್ಷನ್
ಒಂದು ಮೂರ್ತಿ, ಬಸವ ಮೂರ್ತಿಗೆ ಹೋಗಿ ಹುನರ ಹಾಕ್ತೀನಿ.
ಹಾ.
ಅದ್ರಲ್ಲಿ ಬಿಜೆಪಿದು ಇದಿದೆ, ಶಾಲ್ ಇದೆ. ಇಷ್ಟಕ್ಕೆ ವೈಲೇಷನ್.
ಬಸವ ಮೂರ್ತಿಗೆ ಹಾರ ಹಾಕ್ಬೇಕು, ಬಿಜೆಪಿ ಶಾಲ್ ಹೊಲಿಸ್ತಾರೆ.
ಅಲ್ಲ, ಬಸವ ಮೂರ್ತಿಗೆ ಹಾಕ್ಲಿಲ್ಲ, ನಾನ್ ಬಿಜೆಪಿ ಶಾಲ್ ಹಾಕೊಂಡ್ ಮಾಡಿದೆ. ದಟ್ ಈಸ್ ಒನ್. ಅಂಡ್ ಸೆಕೆಂಡ್, ಐ ಕಾಸ್ ರಾಂಗ್ಫುಲ್ ರಿಸ್ಟ್ರೈಂಟ್.
ನೀವು ಎಲೆಕ್ಷನ್ ಟೈಮಲ್ಲಿ ಯಾವಾಗ್ಲೂ ಶಾಲೇ ಇರ್ತೀರಾ?
ದಿಸ್ ಇಸ್ ಇಂಥದಕ್ಕೆ ದೇ ಹ್ಯಾವ್ ಸೆಡ್ ವೈಲೇಷನ್ ಆಫ್ ಮಾಡೆಲ್ ಕೋಡ್ ಆಫ್ ಕಾಂಡಕ್ಟ್.
ಕರೆಕ್ಟ್. ಆಯ್ತು, ಥರ್ಸ್ಡೇ ಬರ್ಲಿ, ಏನ್ ಪ್ರಾಬ್ಲಮ್?
ಆವತ್ತು ಪ್ಲೀಗ್ ಇದೆ ಅಲ್ಲಿ, ದೇ ಹ್ಯಾವ್ ಟು ಅಪಿಯರ್ ಮಾಡಿ.
Yes,
that is the only offense.
List the matter on Thursday. The petitioner is exempted from the concerned court shall defer its proceedings that are slated to be that is slated to be listed on Thursday.
Please
list on Thursday in the fresh matters.
Please. Next, second one is
same ಅದೇನೆ,
ನಾನ್ ಕಾಗ್ನಿಸಬಲ್. ಇದು ನಾನ್ ಕಾಗ್ನಿಸಬಲ್.
ಅದು ಅಷ್ಟೇ, ಅದು ಅವತ್ತೇ ಬರ್ಲಿ. ಅದೇನ್ ಪ್ಲೀಗ್ ಇಲ್ವಲ್ಲ?
ಅದನ್ನು ಅವತ್ತೇ ಇದೆ.
ಅದು ಸೇಮ್ ಆರ್ಡರ್.
Yes.
Thursday will pass appropriate order.
Please. Oblige.
Yes.
8 to 41, I did 42.
498A,
492. A1 and A2.
A1, 2 and 3. Yes. What is the urgency?
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ 90ಗೆ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿದೆ
ಹಾ.
ಅಂಡ್ ಇಟ್ ಹಸ್ ರೀಚ್ ಟು ದಿ ಎವಿಡೆನ್ಸ್ ಲೆವೆಲ್. ಸೊ ಇವಾಗ
ಎವಿಡೆನ್ಸ್ ಸ್ಟೇಜ್
ಹೌದು
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ sir.
ಮತ್ತೆ ಯಾಕೆ ಬಂದಿದ್ದೀರಾ ಈಗ?
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದು ಕ್ವಾಶನ್ ಯಾಕಂದ್ರೆ
ವಾಷಿಂಗ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಬರೋದೇ ಇಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ
ಏನಾರು ಇರ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಕಾಸ್ಟ್ ಮಾಡೋದೇ ಇಲ್ಲ.
because there are some certain submissions in domestic violence matter, Swami.
No problem, madam.
So are
That
there-
you use that in the trial.
Yeah, we are already using that in
Using
trial.
it, then the court will consider your usage.
But the accused number one, the petition number one is a government servant, Swami.
So what?
Every three weeks ಗೆ ಅವ್ರಿಗೆ continuously ಇದ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಎಲ್ಲಿಗೆ?
There are certain
3 weeks ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
dates ಕೊಡ್ತಾ ಇದ್ದಾರೆ, Swami.
ಹಾ, so
So there are certain documents also.
government
already
servant
is the effort.
government servant separate CRPC.
No, nothing.
ಮತ್ತೆ?
ದಯವಿಟ್ಟು ಸ್ವಾಮಿ ಇದು
No,
consider ಮಾಡಿ.
charge frame ಆದ್ಮೇಲೆ I will not interfere.
ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿನೇ 2 days
ಏನಾದ್ರು.
ಬ್ಯಾಕ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು ಸ್ವಾಮಿ.
ಯಾವತ್ತು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು?
ಆಲ್ಮೋಸ್ಟ್ 2 days ಬ್ಯಾಕ್ ಸ್ವಾಮಿ. 2 days ಬ್ಯಾಕ್ ಆಗಿದೆ.
2 dates, date ಬೇಕಲ್ಲ. There is some reason why I am asking. Petition ಹಾಕಕ್ ಮುಂಚೆ ಆಗಿದೆ ಅಲ್ವಾ?
25,
ಪಿಟಿಷನ್ ಹಾಕೋಕಿನ ಮುಂಚೆನೆ
ಮುಂಚೆ.
25, 1, 24, my lordship.
25/1/24, long ago. Yes.
ಬಟ್ ಸ್ವಾಮಿ ದೇರ್ ಆರ್ ಸರ್ಟನ್
No, no.
ಅಂದ್ರೆ ಅಡ್ಮಿಷನ್ಸ್ ಇದೆ ಸ್ವಾಮಿ, ತುಂಬಾ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
That is those admissions are to be tested in trial, madam.
ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಆಗೋಗಿದೆ ಸ್ವಾಮಿ. So
ಪರವಾಗಿಲ್ಲ,
ಅದ್ರಲ್ಲಿ
ಎಲ್ಲ
it's
ಆದ್ಮೇಲೆ
already
482 ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ಮೇಡಮ್? No. ಈ ಮೇಡಮ್ ಮೀನಾಕ್ಷಿ ಬಾಲ. Yes, permitted to urge all the contentions before the concerned court. There is no reason to disbelieve that the concerned court would not consider the same at an appropriate time.
ಸ್ಟೇ ಮಾಡಿಸಬಹುದು.
Stay.
ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
Disposed, madam. Yes, I will not entertain after the charges are framed. Yes, next.
43.
ಇದು Thursday ಬರ್ಲಿ. What is the urgency?
Is that the petitioner herein is working with the state government in Orissa and Lucknow, who are now stalling the lake restoration work there on the count that
All right.
there's an
in
allocation. That's all I'm saying.
Thursday in the fresh matters list. Yes.
I appear for the respondent BBMP in this matter, my lords.
BBMP.
Taking a short accommodation in this matter.
Where is Vikram?
He's on his legs before Court Hall 1, your lordship.
Pass over madla.
A short day.
Milord, may I request for a passover, Milord?
Let him, ask him to come after
Please.
he finishes all the work. We'll finish this. How long to keep this?
Oblige, your lordship.
Please, Milord.
What criminal case have you registered against these people? Because they filed writ petition seeking money, you have registered crime against them.
Your lordship, it's not in connection with those proceedings, your
Then?
lordship. Here we are alleging impersonation of booth level officers.
Oh, that's all
Detailed
right.
written
We'll see.
submissions have been filed on behalf of the
Pass over,
BBM.
pass over, madam.
Oblige, your lordship.
Grateful.
Oh, that's right. This is, I think.
In
last
respect
year
of
we
this-
considered this, correct. You are
Same
right.
elections, Milord.
No, impersonation, Vikram Holigod had submitted. We'll see.
Please,
Pass over.
grateful.
The main argument would be, as an election officer, a complaint to the magistrate, not by the police.
That's the only submission. That's will.
Section 23 of the RP Act.
All right. Pass.
Lordship, as of this morning. Krishna, that's there are certain developments, Milords.
There are
Serious
proposals which have been
development.
made. Serious
No,
development.
it is, Milords. And I'm just being.
To the
Milords,
positive or to the negative?
Milords, to the. Milords, I would- that we can't. Milords, we give an offer last 2 weeks ago. And Milords, I am the one who's talking with the counterparts. And Milords, they give me an offer back saying that I do not accept this offer. This is my offer. and I say that, I give the second offer on last Friday, my lords. That, my lords,
again, talks ready.
my lords, the talks are going on only with me as an advocate on record, as instructed by my client.
It's all right.
But today, what they as of today, I have not received any proposal, my lords. And my lords, they have not even reached out to me. It's more than 10 days. They have not reached out to me.
As of this morning, my lord, my instructions are that there are certain persons in Hyderabad who are trying to sort out the issue. Those are my instructions this morning, and that's the
Lords,
same.
when I am,
Okay, I'll take it. I'll take it on 14th or 19th, whatever you want.
that's my only request, my lords. I understand what my lords are. If they're really intending to settle, my lords, I am making a statement across the bench, my lords, that I am the one across the bar, I'm sorry, across the bar. I was thinking this side. Across the bar, my lords, that I am the one who gave the proposal on behalf of my client. And my lords, there is no event my client has engaged anybody back in the Hyderabad to go talk with the respondent. Now, my lords, if they have any kind of a proposal.
No, I'll give you one opportunity.
Yes, my lords.
If you don't settle it, I will pass orders on merits. That's all.
May I request a day after, my lords?
We are still there.
My lords,
May I
if
request
it
it
has
on the
to settle, if it has to
Okay,
settle, my lords.
I'll take it on Monday.
Very well.
That's
Very well.
Monday, that's my
Tuesday.
next matter.
All right. Tuesday. Better Tuesday.
Very well.
Monday we won't be this relaxed.
Yes, yes.
Very well.
List on Tuesday. Should I record?
Yes, yes.
The parties to the list, the matter was heard and later adjourned on the score that the parties to the list are in the talks of settlement of the dispute between them. The learned counsel for the petitioner submits that the talks of settlement are not taken forward by the respondent, which is disputed by the respondent. Therefore, list this matter on 13th. In the event the talks of settlement would not in the event the talks of settlement would not come to a logical conclusion, the matter would be answered on its merit.
Very well.
Yes.
Fresh matters.
So fresh matter.
Lord, appealing for the petition in this matter. The respondent negotiated and it is, virtually we have agreed to the terms. Day after tomorrow, we'll file the joint memo.
Learned counsel for the petitioner submits that the settlement talks are concluded and would file a report of settlement on the next date. List on Thursday at 2:30 PM to report settlement, if any.
Grateful.
Yes.
47,
For the petitioner.
Yes, pass over.
48,
Petitioner advocate, my lord. Will make two submissions. One is with respect of my lord.
Jagdish Shelly. Yes.
The statement made by the co-accused, my lord, which has been basis for the initiation of proceedings against me and implicating in this case. I request my lords to kindly take page number 65, my lord. This is the statement which is recorded by the police.
65.
Yes, my lord, page number 65. And this is the statement which, my lord, there is a reference to with reference to accused number 2, who is petitioner, page number 67, my lord. Last paragraph, my lord, I will not read. And this particular portion is hit by Tufan Singh, my lord. And the judgment which my lords have rendered on 19th, I'm relying upon that particular judgment. I will place it on record. This is one aspect, my lord, which I am arguing with reference to whether I can be implicated. If they have pursuant to this particular self-serving statement, if there is any recovery or corroborative material, my lord, of course, my lord, the proceeding has to continue. In this particular charge sheet, there are no material, my lord. So the proceeding has to be quashed as far as accused number 2 is concerned.
Only on that ground.
No, that is one
So
aspect.
Manohar Lal Badwa.
No, now I will come to Manohar Lal.
If
my
that
lord.
is there, why do you want Manohar
No,
Lal?
my lord. The reason why Manohar Lal is required is this, my lord. I request my lords to kindly take Manohar Lal 1, my lord, first.
No, if you are succeeding on this, leave it.
No, my
We'll
lord,
decide
that
it
is connected with the Manohar Lal. The reason is this, my lord. The Manohar Lal 1, 2, and 3. What Supreme Court says that this particular materials.
Jagdish, now the submission is that it is only on the statement of the co-accused. There is no corroboration at all. If that is so, then it goes. My latest judgment of mine.
Every day new submissions.
Huh?
Every day news
ಈ
submission.
Manohar Lal ಇಂದ he shifted.
No, I am not shifting. Now I will connect with the
But
Manohar
leading
Lal.
ಇದೆ, leading is there.
Manohar Lal, I will connect with the Manohar Lal. Last judgment, my lord, that is the judgment rendered by this court.
Paritosh.
Yes, my lord. Tufan Singh has been referred to, my lord.
Yes,
The other
all-
judgment, I don't want to argue on that because it is a well-settled law, my lord. Now I request my
No,
lord,
it is-
how the Manohar Lal can be connected with this case.
Corroboration ಇದೆಯಾ ಇಲ್ವಾ ಅಷ್ಟೇ?
I'll answer that.
You'll answer it.
Manohar Lal first, my lord.
I'll answer that next day.
Next date ಆಯ್ತು ಹೇಳಿ.
My lord, Manohar Lal first, my lord. April 11, 2012, my lord. I request my lords to kindly take.
Manohar Lal one.
Yes, my lord.
ಎಲ್ಲಿ?
There are 3 Manohar Lal judgment. It is
All right, where is first one?
just now I have given, my lord.
ಇದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, ಇನ್ನೊಂದು ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು.
ಎಲ್ಲ ಇದೆ ಇಲ್ಲಿ. ಕೊಡಿ.
Yes, my lord.
2012 7 SCC.
Yes, my lord. First judgment is delivered on 11/4/2012, my lord.
All right.
I request my lords to kindly take para number 2, my lord. The 52A is incorporated in the act, my lord, with twin object to treat the sample as a primary evidence. The second object is disposal has to take place, and the disposal has to be reported to the court also. The object, my lords, can be seen, para number 4, my lord.
Yes.
I will just read para number 4, my lord. We have been taken through the contents of standing order, also which prescribes the procedure for such disposal and destruction of the seized contraband. We are not, however, very sure whether the said procedure is being followed as it ought to be. The pilferage of contraband and its return to the marketplace for circulation, in our opinion, a major hazard against which the system must guard at all costs, if necessary, by making suitable changes wherever the same are called for. Before any exercise to that end is undertaken, it is necessary to examine whether the procedure is being followed in letter and spirit. The 52A, whether it has been followed or not, that was the question. This was delivered on 11/4/2012, my lord. Then, my lord, I request my lords to kindly take Manohar Lal 2, my lord, that is on July 3rd, 2012.
Citation.
I request my lords to kindly take para number 10, my lord. There is a judgment, the submission of the Mr. Senna with reference
Yes.
to UNO convention, my lord. Then the vulnerability of such contraband or theft or negligence, all those things have been discussed. Then, my lord, para number 11, my lord. Next page, my lord, page number 716. Third line I will read, my lord.
It is equally
Yes,
important.
my lord. It is equally important to ensure that the quantities that are seized by the police and other agencies do not go back in circulation on account of neglect or apathy on the part of those handling the process of seizure, storage, and destruction of such contraband. There cannot be anything worse than the society suffering on account of the greed or negligence of those who are entrusted with the duty of protecting it against the menace that is capable of eating into the vitals. My lord, in this particular case, my lord, the statement of the accused number 1 is recorded when he was in custody. Thereafter, he was implicated. My lord, after these 2 judgments, my lord, the notices were issued to all the concerned officers who are handling with this particular narcotic substance, my lord. Then, my lord, Manohar Lal 3, my lord, which is part of the compilation which I have filed on 21/6/2024.
ಯಾವುದು ಕಂಪೈಲೇಷನ್?
21/6/2024 ಹಾಕಿದ್ದು.
6-8 ಇದು ಇವತ್ತು ಕೊಟ್ಟಿದ್ದು. ಹಳೇದು ಯಾವುದಿಲ್ಲ.
I had argued on the.
I know
first
you
yes,
had, but yes. ಹೇಳಿ ಇದಿಲ್ಲ.
I will just give you the Manohar Lal first copy.
ಇದೆಯಾ ಮಾಡಿ. It's here. Yes, yes.
Yes, my lord. I request my lords to kindly take the para number 27, my lord. After there are so many submissions which have been made by all the states, my lord. And those submissions can be seen from para number 5.1, my lord. It starts from the Andhra Pradesh.
Which paragraph you want?
Page number, in page number 14, my lord. The 14, 1-4. Then how much has been destroyed? What is the quantity seized? All those difference in that, all those things have been recorded.
Yes.
Then, my lord, after discussing all these aspects, my lord, the disposal aspects has been, with respect to disposal, my lord, from para number 27, the court has laid the law.
Disposal of drugs.
Disposal of the drugs. In the interregnum, my lord, a notification came to be issued in the year 2015. When the Mohanlal 1 and 2 was issued, thereafter, my lord, realizing the importance of 52A, the 2015 notification came into issued by the appropriate authority, my lord. In that particular notification, my lord, the forms have been given. 2 forms have been given. One is inventory which required to be certified. And the other one is another certification with reference to treating a sample as a primary evidence. Then, my lord, there is one more requirement of law as per that notification, that disposal has to be reported to the court. All these 3 things has to take place.
That is referred here.
Yes, my lord, that has been referred to. Now, my lord, in this particular case, there is only one particular certificate, which is not part of the charge sheet, but it is part of a judicial order. If it is a judicial order, my lord, if a pre-trial disposal has been conducted in the form of a enquiry, that is a judicial enquiry, I should be made present, it should be conducted in my presence. Otherwise, it is hit by section 273 of CRPC. Conspicuously, my lord, in the charge sheet, my lord, there are no certificates. And even today, we are not aware whether that has been disposed of or not. That particular drug is disposed of or not. Now, my lord, I am connecting how I have been implicated in this case. So there is no material to show that as first certificate with respect of inventory.
What is the sampling that is done in the case at hand?
Yes, my lord. I request my lords to kindly take the petition, my lord.
Page?
Yes, my lord. The page, my lords, would find at page number 71, my lord. This is the inventory which has been prepared, my lord.
71.
Yes, my lord.
Yes.
The relevant, the sampling application, my lords, would find at page number 69. Then, my lord, 71 is the inventory. This inventory also should comprise of a certificate. That certificate is not available here.
Of the quantity of drugs?
Yes, my lord. He has to what is the inventory which is produced, and the certificate it should comprise of one particular certificate.
Certificate by whom?
Certification by the magistrate, my lord, judicial magistrate. That is not available.
So there is no certification here?
There is no certification here.
Yes.
Then, my lord, there is one more annexure 2, my lord, page number 73. That is the certification of the.
No, this is communication to the magistrate.
Yes, my lord. That is a communication. But the moment that particular communication reaches him, my lord, as per the requirement of this notification, there should be a certificate. That certificate is
Even
not
here,
available.
certificate is not there.
But in the format, they provide a certificate.
Which is that format?
That is in 2015 notification, my lord.
Where is the format is not here?
It is not in accordance with the format, my lord.
What format are you talking of now?
Yes, my lord. Yes, my lord. Madam, sorry. My lord, annexure 1 is inventory of seized narcotic drugs, my lord. Annexure 1.
All right.
That is as per the notification, my lord.
Yes.
The top portion, my lords, can be found at page number 71, my lord. There is a certification, my lord. The certification by the magistrate under subsection 3 of the section 52A of the NDPS Act 1985. This particular certificate should be part of the page number 71. That particular certificate is not available in page number 71.
So it's not available at 71 or not available at all?
It is not, my submission is that it is not available at all. And it is in the, what they are contending that there is a judicial order which has been passed. If a judicial order has been passed, my lord, in my absence, a judicial order could not have been passed. Then, my lord, the second certificate, my lords would find at Annexure 2, my lord. I request my lords to kindly consider that particular certification, sorry, that Annexure 2, which is available in the Act.
Disposal of seized narcotics.
This is with respect of the treating the sample as a primary evidence. That certificate, my lords would find in next page, my lord. This is a certificate issued again by the learned magistrate. Again, that particular certificate is not available in this charge sheet paper, my lord.
Yes.
However, there is a judicial order. They say that the page.
Where is the order?
Yes, my lord. The order, my lords, on last date of hearing, my lord,
Or Kotra.
They have placed on record.
Oh, that's the one. Yes. Wapas Kotra. So judicial order could not have been passed in your absence?
My submission is that, my lord, if it is a certificate, my lord, it is as per the notification. He has conducted a mini trial. If he was conducting a mini trial at the pre-disposal stage, even before the filing of the charge sheet, in the teeth of section 273, I should have been called upon. In my presence, it should have been done.
Yes, sir.
I'll answer, my lord, let me.
All right. Yavat, Friday? Friday, yesterday, no.
My lord, after this particular certificate, after this notification, my lord, the one more notification has been issued, but that notification may not be applicable to this case because earlier to that itself, my lord, this charge sheet has been laid, my lord. But I want to place that particular notification
All right.
also on.
Anyway, on the day of his reply, you can place.
Yes.
All these certification which my learner friend is talking about are there in the record. He is not placed it, but it's there in the record. His contention.
It should have been in his presence.
No, in that sense, my lord, entire investigation has to happen in his presence. Collection of samples.
The order passed by the magistrate.
It is not an order.
Inventory order that is passed by the magistrate should have happened in his presence.
No, that's the inventory.
That's
is
the order
correct.
here.
That's correct now. Collection of
Inventory
samples.
order should have been passed in his presence. Because there is no certification here.
No, there is certification.
No, where?
No, in the,
with
he's
this,
not placed it.
no, with this inventory that the investigating officer has
Yes,
drawn.
it's there. Their certification is there.
Where is the certification?
In my record, it's there, my lord. It's not. He has not placed it.
All right, ಅದನ್ನ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ಹೇಳಿ
Yes,
apply ಮಾಡಿದೆ.
Yes,
Yes.
In the charge sheet, it is not there, my lord. It is the charge sheet.
No,
is
they
a-
have also.
It is not a part of the charge sheet material?
No, it is not part of the charge sheet. I have applied once again, my lord, after hearing the matter. In the charge sheet, it is not available.
Yes.
And now they have to also inform, my lord, where is the final disposal?
ಹೌದು ಎಷ್ಟು drugs ಇದರಲ್ಲಿ?
Literally more than 10 grams, my lord, ecstasy tablet.
MDMA. MDMA and access. ಎಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರಿ?
I'll verify that.
My lord, the reason is that, my lord.
Heard the learned counsel Madhukar Deshpande appearing for the petitioner. The learned additional SPP seeks time to submit his reply. List on Friday. What date is Friday? 9th, list on Friday. At 4 PM. Yes.
Lord, in this matter, my lord, I seek for some adjournment, my lord. I need to file objection.
ಯಾವ್ದ್ರಲ್ಲಿ?
The 49, my lord. I have informed the other side also, my lord.
49.
Yes, my lord.
ಏನಿದು?
This is that matter where consequent to FIR, investigation was initiated by them. And during investigation, they exceed the case, a criminal case
Oh,
itself.
ECIR.
ECF, page 130.
ಈಗೇನಾಗ್ತಾ ಇದೆ?
I need to file objection, my lord. I need some time, my lord.
You file
It has to be, what I'm saying is this much may be detached and the rest of the case.
Let him file his objections then. Heard the learned senior counsel, he Javli appearing for the petitioner. The learned counsel Madhukar Deshpande representing the enforcement directorate seeks 10 days time to file a statement of objections. List on 22nd, 21st objections, if any, by then. Sakala?
Yes, ma'am.
26th beka. 26th is a holiday.
26 happens to be a Krishna Janmashtami, my lord.
27.
27,
27th, yes. That's a holiday, is it?
not holiday.
Yes, 27th, yes, list on 27th.
Much.
Petitioner, the accused number 7
Madam?
in a private complaint filed by the respondent. And he has filed a complaint before the
ಏನು
two,
ಮಾಡ್ಬಿಡ್ತೀನಿ ನೀವು ಮಾಡಿ. ನೀವು correction ಮಾಡಿ. ಹಾ,
one complaint before the 4th Additional CMM Court Bangalore
ಹಾ.
on a similar allegation. Another complaint before the
What happened to the first complaints?
first complaint, summons was issued, she has appeared and taken bail. But accused one
Which is this page 64 order?
that is the one, first complaint, the accused have one, first accused came and before this honorable
It is
court
stayed.
stayed. Now the
Tag, madam. Page 64 ಅಲ್ಲಿ. ನೀವು accused number?
7 in this CMM
The
court. at
petitioner
Bangalore.
is accused number 7. Que accused number 1. This court has granted an interim order of stay which reads as follows. Page 64 interim order copy. In the light of the interim order subsisting que accused number 1, there shall be an interim order of the kind that is granted therein in favor of the petitioner as well. List the matter after 2 weeks. Yes. ಏನಾಯ್ತು? ಬೇಲ್ ಕೊಟ್ರಾ?
ಇಲ್ಲ ಅದು ಪ್ರಾಬ್ಲಮ್, ದಿ ಆರ್ಡರ್ ವಾಸ್ ನಾಟ್ ಅಪ್ಲೋಡೆಡ್ ಟು ಕಮ್ಯುನಿಕೇಟ್.
ಅವತ್ತೇ ಅಪ್ಲೋಡ್ ಮಾಡಿ.
ಆಗಿಲ್ಲ.
ಈಗಲೂ ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ನೋಡಿ ಮೇಡಮ್.
Therefore we could not
No,
communicate.
ಅವತ್ತೇ ಅಪ್ಲೋಡ್ ಮಾಡಿದೆ, ಅವತ್ತು ಸಾಯಂಕಾಲನೇ ಮಾಡಿ.
Usual courts, my lord. It is
ಸಾಯಂಕಾಲ.
always generally done.
Yeah, no.
Will immediately
No,
communicate.
generally it's not done, but that day this was done.
ಇಲ್ಲ ಅದ್ರೊಳಗೆ ಇಲ್ಲ, ನೆಟ್ಟಲ್ಲಿ ಇಲ್ಲ, ಹುಡುಕಿದ್ದಾರೆ ಇನ್ನೂ ಕೂಡ
ತೊಗೊಳ್ಳಿ.
ಹುಡುಕಿದ್ದಾರೆ.
ನಂಬರ್ ನೋಡಿ, ಇದು ಅಪ್ಲೋಡ್ ಆಗಿದೆ ನೋಡಿ.
Therefore,
Wait.
please, I am sorry, my lords.
Sorry.
That's apart from this, my lord, there has been some trend in some of the honorable session judges, my lord, to grant restrain arrest, which is legally impermissible, my lords. This is a case where there is a stay of restraint of arrest.
Restraint of arrest.
ಹೌದು.
ಬರಲ್ಲ. Correct.
ಬರೋಲ್ಲ, ಅದೊಂದು ದಯವಿಟ್ಟು. There is repeatedly, my lords, some of the trial courts.
That we'll see.
Please, my lords.
That what Jagdish says, it's permissible.
I mean, that Jagdish was probably saying that interim bail can be, that I also don't dispute, but one problem is.
Interim bail is a different.
ಹೌದು, interim
Not to arrest is not.
can never be done because there is a, I pointed out, my lord, one decision of the Honorable Supreme Court.
Yes,
also
I have
considering-
quoted that.
Where your lordship had, my lords, considering that.
ಆಗಿಲ್ಲ ಮೇಡಮ್. ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತಾರೆ? ನಾನು ಅವತ್ತೇ ಸೈನ್ ಮಾಡಿ. BVK ಕೇಳಿ ಯಾಕೆ ಮಾಡಿಲ್ಲ? Maybe you're correct. Yes.
I'm
ಏನಾಯ್ತು
sorry.
ಅವತ್ತೇನಾಯ್ತು ಕೋರ್ಟಲ್ಲಿ?
ಅಲ್ಲಿ adjourn ಆಗಿದೆ ಈಗ.
Adjourn ಆಗಿದೆ. Yes. List tomorrow. In the fresh matters list.
Please. Would it be day after? My lord, please.
It's day after.
Please. Great. Interim order to continue.
Interim order subsisting shall continue till the next date of.
Please.
Sign ಮಾಡಿದ್ರು. BVK ಕೇಳಿ ಯಾಕೆ ಮಾಡಿಲ್ಲ? ಚೇಂಬರ್ ಇಂದಾನೆ ಮಾಡಿದ್ ನೆನಪು ಮೇಡಮ್.
Petitioner was working as, my lord, assistant executive engineer in
7A.
7A. Lord, the work was completed on 28 to
List on 8th. BB Patil ಆಗಿದೆ notice. First time.
Fresh matter, my lord.
Counsel for the petitioner is directed to serve on counselship BB Patil, representing the Lokayukta with the requisite set of papers. List the matter day after tomorrow in the fresh matter, in day after tomorrow on Thaki, sir. Yes. List on 9th, 8th, alla? 8th, yes.
In similar matters, my lord,
8th, sir.
in the fresh matters list, my lord, they are likely to file charge sheet, my lord. The
List
sanction-
day after tomorrow, sir. ಎಲ್ಲ fresh matter ಇರುತ್ತೆ.
ಆಯ್ತು.
When is the account frozen, sir?
But sir, the accounts are frozen subsequent to 17/7/24.
Why?
With my lordship's leave.
Why are they frozen?
Not, sir, because there was a dispute between the father of the petitioner and the respondent number two. Previously, my lords, it had led to a filing of a dishonor, 138 case, my lords, under the Negotiable Instruments Act, which came to be quashed against me. Annexure B 26.
That I have seen.
These my lords. Now, consequent to this, my lords, an FIR has been lodged by the Sen, with the Sen police, my lords.
For the accused?
I am not the accused. It's an order, my lords, falling under 106 BNSS.
Let's see. The learned HCGP is directed to accept notice for the first respondent. Secure instructions as to why the account of the petitioner has been frozen despite the order passed by the coordinate bench in criminal petition 200733 of 2023. List the matter on Friday in the fresh matters list. Yes.
54. Order 54.
Appeal for.
Office
petitioner,
objections
my
in the statement of, yes, Balraj.
lord. My lord, I appeal for the respondent, my lord. There is an
Interim
office
order there.
objection. I'm for the petitioner. Interim order is there, my lord. Interim order.
A week's time is granted to comply with the office objections in the statement of objections filed by the respondent.
My lord, we have filed, my lord. We have filed the statement of objections, my lord.
Yes, ಅದರಲ್ಲೇ ಇರೋದು objections. List the matter immediately after compliance with the office objections. Interim order subsisting shall continue to the next date of hearing.
Date may be given.
On the vacating stay, the madam, list on 28th.
Please.
55.
Lord, I represent the person.
Isn't connect ಆಗಿರೋದು ಎರಡು?
Lord, this is with regard to the,
Why is BMTC?
Lord, KSRTC was the complainant in this case.
KSRTC complaint.
Yes. Lord, the point
Stay
involved.
ಕೊಟ್ಟಿದ್ದೀನ.
Yes, stay there, my lord. But the matter is old matter, my lord.
Old matter.
Yes, my lord. The
2023 matter, sir.
crime is of the year 2008, my lord. The second round litigation.
ಅದಕ್ಕೆ ಸ್ಟೇ ಕೊಟ್ಟಿರೋದು. CC of 2009.
Yes. That point involved is whether they have followed the procedure prescribed under section 340 of CRPC or not is the question.
But respond ಬರ್ಬೇಕಾದ್ರೆ.
It is
And it is
served.
in, it is in orders.
It is served on them, my lord.
Covered.
Served on.
ಎರಡು ಗೊತ್ತು. Yes. ರೇಣುಕಾ ಅವ್ರಿಗೆ ತಗೊಳ್ಳೋಕೆ ಹೇಳೋದು ಅದಕ್ಕೂನು.
Yes, yes, maybe.
Counsel Srimati HR Renuka is directed to accept notice for the respondent KSRTC, either 55 ಅಲ್ಲಿ madam. In the light of wakalat being filed in favor of KSRTC in 55.1, petitioner to serve set of papers in 55 as well to the said council. List on 28th, interim order subsisting shall continue till the next date of hearing.
Both the cases, my lord.
Both. ಎರಡಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ.
House.
56.
The petitioner, my lord. Matter of this, my lord.
Huh?
Not coming.
Not coming.
Like after service of notice, my lord, list the matter.
Police report awaited in respect of R2. Yeah, MA filed ಅಂತಿದೆ.
ಅದು earlier, my lord, matter is moved for settlement, my lord.
376
ಅಲ್ಲ 306, my lord. After that, my lord, I withdraw the petition. And again. file
Stay
contempt.
ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ?
ಇದೆ, my lord.
List the matter on 5th, on 4th September. Interim order subsisting shall continue till the next date of hearing.
57.
Petitioner understand the matter. Petitioner is the accused number 3, challenging, my lord, proceedings wherein charges have been framed for 404, 201, 120.
Framed already?
Yes,
When did you file it?
this was filed, my lord. in
Before the
23.
framing of charges.
After the
Then
framing,
how was it?
my lord, there's a judgment, my lord, which says that even
ಕೊಡಿ.
after framing. the charges.
ಅಷ್ಟು ಕೊಟ್ಬಿಟ್ರೆ ಸುಮಾರು ಕೇಸಸ್ ಎಂಟರ್ಟೈನ್ ಮಾಡ್ಬೋದು ಕೊಡಿ.
My lord, page number, this is a division bench of the Honorable Apex Court, AIR 2013, SC 506.
Apex Court Division Bench.
I'm sorry,
Ah.
page 5, para 15, my lord.
Hmm.
From bottom 5th line, However, if so warranted, such power would be available for exercise not only at threshold of a criminal proceeding, but also at a relatively advanced stage thereof, namely after framing of the charge against the accused. In fact, the power to quash proceeding after framing of charge would appear to be somewhat wider, as at that stage materials revealed by investigation carried out usually comes on record, and such materials can be looked into not for purpose of determining the guilt or innocence of accused, but for purpose of drawing satisfaction that such materials, even if accepted in entirety, do not in any manner disclose the commission of the offence alleged against the accused. My lord, in this case, my lord, petitioner is accused number 3, allegation is accused number 1, and the paramour accused number 2 murdered the husband of the paramour. The allegation simply against me is criminal conspiracy and common intention on one single ground, that on the night of the murder, the husband had come back home and slept.
Let's see, I'll look into this. Because I'm rejecting all petitions where charges are framed.
I do understand.
Let
that.
me see this.
Records-
Anything subsequent to that, we'll see. Another,
Records.
early.
My lord, the previous,
But
roster-
anyway, 482, I can always, discretion,
Yes, my lord.
yes. Intermodal idea,
No interim order, my lord. Hence,
but the stage, let me see, list on Friday,
grateful, my lord.
yes.
58.
Respond number 2 is the Tahsildar, my lords, correct to Tahsildar. State may be directed to take notice. My lords. And 58.
Steps ತಗೊಂಡಿಲ್ಲ?
Respond number 2 is the Tahsildar, my lords.
Learned HCGP is directed to accept notice for the second respondent. Petition, copy ಕೊಟ್ಟಿದ್ದೀರಾ? Copy ಇದೆಯಾ madam?
Copy them.
Yes, 58.1, ಅದೇನು?
Same. your lord.
Same, arising of same
Intermodal ಇದೆಯಲ್ಲ?
interim order.
58.5, your lordship, I have filed NOC Wakalat as against.
1 minute, sounds. 58.5 ಅಲ್ಲಿ, register to delete the name of Chandrasekhara K and print the name of Abhinaya. What's your full name? Abhinaya K as appearing for the petitioner. List the matter. We'll take it on the first, we'll list the matter on 10th September. Interim order subsisting shall continue to the next date of hearing. ನಿಮ್ದು ಯಾವ್ದು ಶಶಿಧರ್?
8.2.
ಅದ್ರಲ್ಲೂ ಇದೆಯಲ್ಲ? ಎಲ್ಲದ್ರಲ್ಲೂ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದಾರೆ. ಯಾರು ಹಾಕಿರೋದು? ಸ್ಟೇಟ್ ಹಾಕಿರೋದಾ? 10th, yes. Hmm.
59.
Petitioners, please. Section 6 of the POCSO Act.
Compounding.
Please, my lord. As on the date of marriage, victim was 16 years, 10 months. My lord.
9th. All these matters on 9th.
I would have withdrawn the matter, my lord. The only concern here.
Withdrawal ಆಗಲ್ಲ.
No, the only concern before my lords is even the witness turns hostile, the lower court, the judges express that he's gonna convict. That is the only intention.
All right. Yes.
Please.
9th. 60 withdrawal in terms of the memo. 61 also.
62.
On compliance of office objections.
Only with respect
respondent.
to verifying affidavit, I should file along with the
ಯಾಕೆ
statement.
ಹಾಕಿಲ್ಲ?
I'm appearing for respondent report. Affidavit has not been filed accompanying a statement of objection. That is
The
the,
counsel for the second respondent seeks a week's time to comply with the office objection, square the statement of objections.
Submission, my lord.
In the event they stand complied, list the matter on 21st, interim order subsisting shall continue till the next date of hearing. Yes, next.
Yes, sir. Interim order to be continued.
Huh?
Interim order to be
ಇಲ್ವಾ?
continued.
ಇದ್ದಂಗಿದೆ?
ಅದು ತುಂಬಾ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ರು.
Order dated 3/7/24 shall continue.
Not to my lord.
not to receive.
ಅಷ್ಟೇ ಸಾಕು, ತೊಂದ್ರೆ ಇಲ್ಲ. ಏನ್ ತೊಂದ್ರೆ ಆಗ್ತದೆ?
307 is there, my lordship.
Huh?
There are almost 7 accused persons are there. 307 is there. The heinous of the offense is very serious with respect to the property.
ಇಲ್ಲಿ ಅವ್ರು
ನೀವು
ಹೇಳ್ತಾರೆ-
objections ಹಾಕ್ಬಿಡಿ.
Yes, I have filed the objection.
we'll
Only
decide
Mr.
it.
Much obliged.
ನನ್ಮೇಲೆ ಇರೋದು ನಾನು ಸುಪಾರಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ.
ಸಾಕು.
ಇಲ್ಲ 4 months is already over. Any malad material is there malad. I
Let
will not
them-
press
let
the
them
petition
produce.
malad.
The learned HCGP
ಅವ್ರಿಗೆ
shall produce
ರಿಪೋರ್ಟ್
the
ಕೊಟ್ಟಿದ್ದಾರೆ ಬಂದು.
charge sheet ಆಗಿದೆಯಾ?
Charge sheet
Charge
might
sheet
have
ಆಗಲಿ
been
ರಿಪೋರ್ಟ್
filed.
ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ
Maybe.
4081.
ಇದೆಲ್ಲ.
The learned HCGP to secure the investigation papers and place it before the court. List on 21st. Yes. The order dated so and so shall continue ಅಂತ ಮಾಡಿ madam. Order dated 3/7/24 shall continue till the next date of.
Plus, number 59. 59, apologies. Matter is set down for charge on 9th, my lord. Though my lords have deferred framing of charge, the learned.
There is an order, is it?
Please, my lord.
One minute, ಅದು ಕೊಡಿ file ಕೊಡಿ madam. 59 ಕೊಡಿ ಒಂದು ನಿಮಿಷ.
The learned session judge has said that.
When was it posted?
That,
My order is 28/6/24. It is prior to that or after that?
prior to that. No, but the interim order was extended, my lord.
It's all right, prior to that.
Please.
After that, if he has passed some order, tell me.
In the last occasion, the judge has explained that he is going
The
to frame
learned-
charge on 9th.
The learned counsel for the petitioner submits that despite the order dated 28/6/2024, the concerned court has listed the matter for framing of charges. This court on 28/6/2024 has passed the following order. It is ununderstandable as to how the court would post the matter for framing of charges when this court has directed the matter to be deferred at the stage of framing of charges till the issue is decided by this court. It is decided by Ashsak, yes, so and so. The order continues till the next date of hearing. Madam, 59 ಗೆ ವಾಪಸ್ 59. Yes, Manmohan?
61 ಮೇಲೆ 61
ಮತ್ತೇನ್ ಶಶಿಧರ್?
59 ಕರೆದ್ರೆ ಅವ್ರು ಇದರಲ್ಲಿ 61
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದೀರಾ ಅದಕ್ಕೂ ಬೇಕಾ ಸಬ್ಮಿಷನ್
ಫೈಲ್
ಮಾಡಿ
ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್
ನೀವು ಮೆಮೋಲ್ ಏನ್ ಹೇಳಿದೀರಾ ಅದು ಅಷ್ಟು ಮೆಮೋಲ್ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿಲ್ಲ.
Lord, this relates to Lord downloading Lord of Telegram, Lord. I get a message, but saying that Lord Kannada moves.
Granted an interim
Yes,
order.
Lord, so granted it. So the second respondent, Lord, is only Lord the formal complainant under section 15(1) of the IT Act. Folks, Lord, is required to Lord give a formal complaint. Notice only to him.
50 rupees ಕೊಟ್ಟಿದ್ದೀರಾ?
Out.
Yes, comment. Why is it come now?
Shown as process, Lord, to the
Second respondent ಯಾರು?
second respondent, Lord, is the complainant.
Who is that complainant?
He is the one, Lord, who makes the allegation against Lord the prime accused. That is not
then
one,
Let him be served.
he is only not a formal complaint under 15(1) Lord of the POCSO.
Ah.
Anybody who
If you want,
notices.
if you want quashment of this, yes, we'll see. He won't appear. Let him not appear, we'll see. Post immediately after the notice being served upon the second respondent without a memo from the without a memo being moved before the court. Interim order subsisting shall continue till the next date of hearing. Yes.
Please.
Before. 498 AM, my lordship, mother-in-law,
Post immediately after,
mother-in-law and mother-in-law sister, my lordship, for this court.
interim order ಇಲ್ವಾ?
No, my lordship.
ಯಾಕೆ? Allegation ಇರುತ್ತೆ.
No, allegation is with ಬೈದಿದ್ದಾರೆ ನೀನ್ ಛಲವಾದಿ ಅಂತ ಅಷ್ಟೇ ಇರೋದು my lordship complaint ಅಲ್ಲಿ ಹೊಡೆದಿರೋದು ಅವ್ರ husband.
It can't be that.
Complaint, can I read it?
It's my order, madam. 17.
Page number 28, my lordship.
No, yes, I have clearly said, yes, post immediately after service of notice upon the second respondent. Complainant, yes, next.
Date may be fixed, my lordship.
Immediately after service of notice, registry to put up the matter. Once the notice is served without a memo being moved before the court. Yes, next.
55, appearing for petitioner, your lordship, awaiting police report.
Post immediately after service of notice upon the respondent. Interim order subsisting shall continue to the next date of hearing.
56,
Non-compliance.
Lords, in the criminal appeal, Lords, Lords, it is offense under Lords, section 498 Lords. Lords, after acquittal, Lords, the state has filed an appeal. And as Lords, the complaint has also filed an appeal, Lords. Lords, during the pendency of the appeal, Lords, the parties have
Settlement.
settlement, Lords. And the part, Lords, the complaint is not cooperating, Lords, in spite of settlement, Lords. Kindly see, Lords, the.
I know, I've seen the settlement here.
Yes, Lords.
Yes. Stay ಮಾಡಿದೆಲ್ಲ.
Stay is there, Lords. And service is also complete, Lords.
Let's see. Service complete.
Yes, Lords. First, in the second matter, Lords,
Office objections, maintainability stands overruled. Office objections at serial number 2 to 6. Adeno. What is that?
Lords, address of the Lords complainant.
Telling, office complaint ಮಾಡದ್ ಕಷ್ಟನಾ?
Lords, she is not available, Lords. She is not receiving any notice from the Lords, from the court. Lords.
Correct offenses in the prayer to be mentioned, all that is difficult, is it?
I will make it, Lords.
Yes, office objections, adu 66 ಅಲ್ಲಿ madam. Office objections to be complied with by the next date of hearing. 66.1 ಅಲ್ಲಿ, office objections maintainability of the criminal petition stands overruled. List the matter on 3rd September. Interim order subsisting shall continue till the next date of hearing. We'll close it. Yes.
Petitioner, my lord. 498 A and 306
Sufficiency of service.
has been served upon the art.
The report indicates that yaar is the son, that on behalf of Rajesh Jain, the respondent, who has taken,
Son of the.
have you not seen the cause list?
I have seen. Lord,
Where is it? Yes, so and so son has taken, therefore registry to print the name of the complainant and show him as served. This the matter of 2 weeks. Yes.
That's a date may be given.
List the matter of on 4th September. Next.
Please.
Post immediately after service of notice upon the second respondent. Interim order there.
See, only with respect to petition number 2, my lord.
Interim order subsisting shall continue till the next date of hearing.
Please.
Same order,
Lord, interim order is there, my lord.
continued. 70, same order. Same order. Interim order ಇದ್ರೆ continue ಆಗುತ್ತೆ.
Date may be.
Yes, next. Compliance with office objection 72.
For responding. I appear for first informant.
No representation behalf of the petitioner. ನಿಮ್ದೇ office objections comply ಮಾಡ್ಬೇಕಾಗಿರೋದು.
First
Statement of objections, yes, sir. 72 alva.
please.
Counsel for the respondent seeks a week's time to comply with the office objections, square the statement of objections. List the matter after 2 weeks. Interim order ಇದೆಯಾ?
ಇಲ್ಲ.
So, next.
Ref.
ಮೇಲೆ no representation behalf of the petitioner ಅಂತ. ಆಮೇಲೆ ಇದು ಮಾಡಿ. Yes, Ravishankar. Post immediately after service of notice upon.
91 application. I have also served to the council.
We'll see post immediately after service of notice upon the respondent, interim order subsisting shall continue to the next date of hearing. 74 same, ಅದು connected with ಯಾವ್ದದು? 3-4 ಇತ್ತಲ್ಲ ಮೇಡಮ್. Tag this petition along with serial number 34. ಅದು ಯಾವತ್ತು ಹೋಗಿದೆ? ಯಾವತ್ತು ಹೋಗಿದೆ? 21st. Yes. List on 21. 75 settlement.
Petitioner.
An offense.
498 A.
Yes. For time. The petitioners are before this court. Calling in question the proceedings in CC so and so registered for offences punishable under section 498A inter alia. The ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿರೋದು?
What case?
Mediation ಅಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ.
The parties to the list during the pendency of the petition in separation.
ಇಲ್ಲ ಇಲ್ಲ. Living together.
Reunion.
Living together.
The parties to the list during the pendency of the petition have settled the dispute amongst themselves and have decided to live together. And in furtherance whereof an application is preferred under section 320 of the CRPC seeking compounding of the offence. The application and the joint affidavit. Application reads as follows. In the light of the offence being the one punishable under section 498A inter alia and not being against the state, I deem it appropriate to accept the application seeking compounding of the offence and close the proceedings against the petitioner. more so in the light of the reunion of the husband and the wife. For the aforesaid reasons, the following order. The criminal petition stands disposed. The crime so and so against the petitioner stands quashed. Next,
26.
For the petitioner in this case.
post immediately after service of notice upon the respondent. Intermota diya.
There is no interim order date. Maybe.
Post immediately after service of notice upon the respondent. Next,
As please, wait service.
notice serve agli.
ಆಯ್ತು.
Intermota unta.
ಉಂಟು. There is a
The-
contractor, my lords, 304A. Contractor of the road, actually.
That
accident
type
that-
grant, yes.
Please, your lordship.
Post immediately after service of notice upon the respondent, interim order subsisting shall continue to the next date of hearing.
Great.
Heard the senior counsel and Thakbut made.
Great.
78.
What is this, Vignesh?
No, it's not a very my lord. This honorable court, my lord, granted an interim order in subject of my lord, taking the possession and my lord, my lord handed over back to my lord, the respondent herein.
Other crime, stay koಟ್ಟಿರ್ಬೇಕಲ್ಲ.
Stay ಕೊಟ್ಟಿದ್ದೀವಿ. But in fact, my lord, connected also with that petition, today that matter is not got against the authorization of my lord and good.
ಯಾವ್ದು?
One more matter, my lord.
Number ಕೊಡಿ.
Number 6367 of 2024.
ಅದು dispose ಆಗಿದೆ.
Dispose ಆಗಿದೆ, they filed an IA for my lord, extension of time for payment of
Oh,
money.
that Sandhya Prabhu. All right.
Same.
Other, that is already disposed.
Dispose.
Anyway. R2 ಯಾರು?
To my lord, that.
She will take notice?
Like, in fact,
ಅಲ್ಲ ಇವರಲ್ಲ.
she took my lord the other day, my lord, she undertook to file
The
wakalat.
registry to print the name of Sandhya Prabhu as appearing for the second respondent. List on 22nd, interim orders of 23rd.
Till disposal ಇದೆ ಅದೇನು?
Interim, ಇದೆಯಾ? List on 23rd.
Great.
Heading on IA. 39.
CMP.
My lord, only submission is regarding the timelines prescribed under the act, my
I
lord.
have not been able to go through your judgments. Let's see.
Yes, my lord.
Thursday ಹಾಕಿರ್ತೀನಿ. Yes. Let's see, we'll finish it off on Thursday.
What, my lord? ಏನಿಲ್ಲ timelines ಹೇಳ್ತಾರೆ.
No, 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 no.
Under 24 subclause 3 and
See, we'll see.
29.
I'll have to answer that, we'll answer it, yes.
The Calcutta High Court has emphasized on that.
I have not been able to see that, I'll see that and
Agli.
Thursday I'll answer. Yes.
Public.
And with file ಕಳ್ಸಿ ಮನೆಗೆ. Yes,
Thursday, my lord.
Thursday,
First, public.
fresh matters.
Eighty.
Impleading. Oh, you said that this court is in several locations.
Lord, in the declaratory suit filed by him, he's been declared not the owner and that RFA has been now allowed.
Objections
the
ಹಾಕಿದ್ದೀರಾ
honorable
ಇದಕ್ಕೆ?
ನಾವು ಹಾಕಿದ್ದೇವೆ.
Impleading application.
RFA, ಹೌದು, impleading.
All right.
RFA order ನ ಹಾಕಿದೆ.
ಹಾ.
Along with the statement of
ಕಾಪಿ
objection.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅದು ಕೊಟ್ಟಿದೆ. ಅದ್ರ ಜೊತೆಗೆ there is an order passed by the LGC, which is also been challenged. Some of the parties have been.
Who is the complainant?
Complainant is BDA. Complaint has been lodged by the BDA
Who
at
appears
his
to-
instance.
Who appears for the BDA? No, at his instant complaint is lodged by the BDA.
Yes, he moved the BDA and BDA thereafter claimed that it has the ownership. And he executes a relinquishment deed with respect to which he filed a declaratory suit which has now been
No, if
dismissed.
it is at his instance, who suit alla irli,
Ah.
the crime we will consider, it may become necessary to be heard.
Now, since he has been declared not the owner and that order becoming final, at least in the first appeal.
Let the BDA come. BDA is
May
not,
I suggest one thing, Lord?
BDA is not notified?
Either they've been issued notice. Your lordship may.
Serve on Murugesh Charati.
ಆಯ್ತು.
Counsel Shri Murugesh Charati is directed to accept notice for the respondent BDA. Petitioner to serve set of papers upon the said counsel forthwith. Will list it on Monday or Tuesday.
Interim order to continue.
List the matter on Tuesday 13th. Interim order subsisting shall continue till the next date of hearing. ನಿಮ್ಮ ಅವತ್ತು ಕೇಳ್ತೀನಿ.
13th.
13ಕ್ಕೆ.
Sir, I'm filing I filed my appeal petition in the Supreme Court
ಹಾ.
against that RFA.
Which order?
Against
It's the same.
RFA.
RFA order.
Against
ಏನಾಯ್ತು?
RFA.
ಏನಾಯ್ತು ಅದು?
I filed, he is bringing objection upon RFA 1495 2012. For that, I filed appeal petition in the Honorable Supreme Court.
ಆಯ್ತು ಅದಿರ್ಲಿ, ಈಗ 13ಕ್ಕೆ ಬನ್ನಿ, ಲಿಸ್ಟ್ ಆನ್ 13th.
Yes.
13ಕ್ಕೆ.
13.
Yes.
Interim order to continue.
Interim order subsisting will continue to the next date. Yes, next.
Sir, ಇದನ್ನ ಕೊಳ್ಳ ಸರ್.
ಇಲ್ಲಿ ಬೇಡ, 13ಕ್ಕೆ ಕೊಡಿ.
Supreme Court.
13ಕ್ಕೆ ಕೊಡಿ.
13. Thank you.
I appear for first informant this matter.
ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿರಲಿಲ್ಲ ಇವರು.
Last time ನಾವು direction ಕೊಟ್ಟಿದ್ರಿ, ಅವ್ರು ಫೈಲ್ ಮಾಡಿರೋ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿ ಅವರು.
ಅವ್ರು ಫೈಲ್ ಮಾಡಿರೋದ? ಇದೆಯಲ್ಲ 81.1.
No, my lord. They were.
Asked for the records.
What's the offense?
420, 419.
Muthoot Finance.
No, IKFM. But the case where all the accused have impersonated the previous owner, my lords, and they have availed loan. And the EMI is paid, the amount is transferred from one of the accused to the petitioner, and the petitioner pays the EMI.
Let them, there is no representation. We have the petitioners as a last chance. List the matter on 14th. In the event they would not be present, appropriate orders would be passed on the petition. Yes.
82.
My lord, for the husband in the present case, my lords, there is, this is against the orders passed on 311. One more petition, my lord, where video conferencing was sought and that has been dismissed. One petition is pending before this honorable court in criminal petition number 7567 of 2024, which has not come before the honorable court, my lords.
ಏನ್ ಹಾಕಿದ್ದೀರಾ?
My lord, an application was, one is 311 application dismissed, which has come before this.
ಇದರಲ್ಲಿ ಏನ್ ಇದು?
In
what
this
is
311, my lords.
311.
311. Another case, my lords, for video conferencing, because he is in Canada, application was filed, that has been dismissed. That is also challenged before this honorable court.
ಮಾಡಿ.
Same proceedings, my lord. I pray that that also may kindly be,
All right.
please.
Yes.
Criminal petition 7567.
Tag this petition along with so and so ಬರ್ಕೊಡಿ.
One request, my lord.
Friday.
There is, I undertook that I will not precipitate the matter. That's the reason. Some urgency.
Your undertaking will continue till Friday. So,
Please.
yes, list on Friday in the fresh matters list.
Please, my lord. And one more aspect, my lord, subject to what my learned friend says. Now, my lord, as for the video this is a DV Act. We had for sought an application for video conferencing. My lord, between the same parties under the Family Courts Act, my lord, so there is one proceeding for divorce, where my lord, the same prayer is made. That has also been disallowed, my
We'll
lord.
see, we'll see.
One more writ petition is pending before another.
ಹಾಕಿದ್ದೀರಾ?
No, not, it is before another coordinate bench. Question is same, my lords. I pray that both as per the, may kindly be called together because there is WP number 50503.
ಏನದು FC ನಾ?
FC.
Oh, the FC,
ಅಲ್ಲೇ ಇರು.
as my lord pleases.
My lords can
Question is
decide
same,
here
my
and we
lords.
can produce it there.
Question of law, in already, both the
Independent.
cases is the same.
Oblige.
Yes.
Please, read.
One 164.
ನಂದಾಗೋಗಿದೆ, ಅವ್ರು ಹೇಳ್ಬೇಕು.
Kindly pass over, my lordship, Jagdish.
ಇದರಲ್ಲಿ probably I may have to invite my lord's attention to a full bench judgment of the Supreme Court. Not in
ಎಲ್ಲಿ?
my compilation
ಹಾ.
at ink page 1.
You took me to this order.
I'm
ಹೇಳಿದೆ.
sorry.
ಇದು ಆರ್ಡರ್ ರೆಫರ್ ಮಾಡಿದ್ರಲ್ಲ?
ಅಲ್ಲಲ್ಲ, ಅದರಲ್ಲಿ ಡ್ರಾಫ್ಟ್ ರೂಲ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
ಹೌದು.
ಡೈರೆಕ್ಷನ್ ಟು ಆಲ್ ದಿ
There are-
ಕೋರ್ಟ್ಸ್.
There are many other directions,
Yes.
even including 207 application.
Yes, 19.1 ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ಸ್.
Yes.
May I request your lordship to kindly have a look at the,
All courts to take expeditious steps.
kindly turn to page 12 or in page 12.
Yes.
They will keep 161 and 164 in juxtaposition with each other. Can I 10 minutes?
Yes,
In
sir.
page 12.
Yes.
During cross-examination, the relevant portion of the statements recorded under section 161 CRPC used for contradicting the respective witnesses shall be extracted. If it is not possible to extract the relevant part as aforesaid, the presiding officer in his discretion shall indicate specifically the opening and closing words of such relevant portion while recording the deposition through distinct marking. ಅದು ನಾವು ಡ್ಯಾಶ್ 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 ಹಾಕ್ಬಿಟ್ಟು ಪೂರ್ತಿ ಎಂಟೈರ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ರೀಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ ಮುಂಚೆ ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಫಸ್ಟ್ ವರ್ಡ್ ಲಾಸ್ಟ್ ವರ್ಡ್ ಹಾಕೊಳ್ಳಿ. In such cases where the relevant portion is not extracted, the portions only will be distinctly marked as prosecution or defense exhibit as the case may be, so that The other inadmissible portions of the evidence are not part of the record. In cases where the relevant portion is not extracted, the admissible portion shall distinctly be marked as prosecution or defense exhibit, as the case may be. Well, this will be important. The aforesaid rule applicable to recording of the statements under section 161 shall mutatis mutandis apply to the statements recorded under section 164 whenever such portions of prior statements of living persons used for it. Omissions, omnibus markings of the entire statement under section 161, 164 CRPC shall not be done. ಇಲ್ಲಿ
entire statement ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ statement
Contents are being marked.
ಅಲ್ಲ. First, he rejects the request of the
ಹೌದು,
prosecution.
rejects the request.
So instead of, the learned judge does not allow the prosecution to mark it. ಆಮೇಲೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ backdoor method ಅಲ್ಲಿ, may I just request you
Yes, sir.
kindly turn to that
Sir.
part of the evidence which my lord gets.
Jagdish should come, is it? Let him come. Jagdish ಬರ್ಲಿ. Pass over ಮಾಡಿರ್ತೀನಿ. Pass over ಇವತ್ತು, I don't know whether it reach tomorrow.
Please, this is ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಬೇಕಾದಷ್ಟಿದೆ, 3:30, 4:30. I don't know whether we stand a chance or not.
ಒಂದ್ ನೆನ್ನೆ ತರ 6 o'clock ವರ್ಗು ಕೂತ್ಕೋಬೇಕು.
6 o'clock ಆಗ್ಬಿಟ್ರೆ ನನ್ ಕಮೆಂಟ್ಸ್ ಆಗಿದೆ 6 o'clock.
Yes.
ಆಮೇಲೆ ನಾಳೆ the trial court has posted, I don't want stay of recording of further proceedings. No, madam. Because I am more interested in coming out immediately consequent to the order which came to be passed by the Supreme Court. I should not seek an adjournment. ಇದು
ಯಾವತ್ತಿಗೆ ಹಾಕಿದೆ next?
ಅಲ್ಲ, ನಾಳೆ ಇದೆ. This part of the order permitting the prosecution to make the witness say.
No, that is interfering in the trial. Pass over, I will decide it. We'll see, yes.
ಬೇಡ, ನಾಳೆ ಹಾಕೋಬೋದು, ಏನ್ ತೊಂದ್ರೆ.
ಅಲ್ಲಿಂದ
ಪರವಾಗಿಲ್ಲ, ಏನಾಗಲ್ಲ.
ಅಲ್ಲಿ ಕೇಳಿ ಟೈಮ್ ಕೊಡ್ತಾರೆ. Yes.
ನಾಳೆ ಹಾಕು.
Yes, yes. ನಾಳೆ ಹಾಕು.
ನಾಳೆ.
Tomorrow. List tomorrow in the fresh matters list. So that will pass some more.
For the second respondent in this case, my lord, I have filed an application for vacating of the
Yes, sir.
interim order, my lord. The facts of the case is only this, my lord. The present petitioners are father and daughter. The second respondent is the co-brother of the first petitioner. The wife of the first petitioner, 76 years. He was 88 years. He was addicted to drugs. He was consuming a tablet. The wife did not handed over the tablets to him in time. Out of rage and frustration, he pushes the wife. She falls down and she dies.
Falls down. ಹೇಳಿ.
ಅವ್ರು ಸತ್ತೋಗ್ತಾರೆ ಹೆಂಡತಿ. ಆ ಸಂದರ್ಭದಲ್ಲಿ they does not inform anybody. Within a period of 2 hours, the cremation takes place. Later on, his sister tells the brother-in-law, this is what has happened. FIR has been registered. My humble submission is this, my lord, investigation has to take place. In the process of the investigation, the true story will come out. What exactly happened and who is responsible for the death. He has confessed to the present second respondent about the act done by him. No doubt he is 91 years old now. And it is a fact that he is addicted to that particular drugs. So it is all there in the complaint, my lord. My humble submission is, let the police investigate the matter. What has happened is, other 2 daughters are there. One lives in America and other one lives in India.
So why after 7 months?
The sister Lata did not tell me.
Oh.
See, and everything happened in 2 hours. 2:30 ಗಂಟೆಗೆ ನಡೆದಿದೆ, 3:30-4 ಗಂಟೆ ಕ್ರಮೇಶನ್ ಮುಗ್ದೋಗ್ಬಿಟ್ಟಿದೆ. This is the reason, my lord. Now,
yes, sir.
Not the matter requires to be heard. Now, therefore, see, without even vacating stay application, matter some other day matter may be taken up and
We'll take it at 2:30.
but ಸ್ವಲ್ಪ inconvenience. That is the reason. Otherwise, they would not have asked.
Sir, we will take it on 21st then. List on 21st in the fresh matters list along with the application seeking vacation of the interim order. Interim order subsisting shall continue to the next date of hearing. Yes.
Complainant, your lordship. Your lordship, there's awaiting notice for R2, the
Post immediately after service of notice upon the second respondent, interim order subsisting shall continue to the next date of hearing.
86.
vacating stay. Passover.
ಸ್ವಾಮಿ ಇವತ್ತು ಒಂದೇ ಒಂದು ಸಂಬಲ್ ಸಬ್ಮಿಷನ್
Passover. ಬೇಡ್ವಾ?
ಗೊತ್ತಾಯ್ತು ಬರ್ತೀನಿ ಸ್ವಲ್ಪ ಇವತ್ತು ಒಂದು ಆರ್ಡರ್ ಕೊಡ್ಬೇಕು ತಾವು.
ನೋಡೋಣ.
ಯಾಕಂದ್ರೆ 3-4 ಸತಿಯಿಂದ ಹಿಂಗೆ
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್. ಎಸ್.
Admission 87.
2021 ಇಲ್ಲಿ.
For the petition, I may seek a password.
Yes, sir, you ready?
I'm ready.
And why is this 2021 matter connected?
My lord, case and counter case, my lords.
Oh, sorry.
It's purely a civil dispute, my lord.
It's Passover.
88.
Lord, I think for petitioner in this case.
Yes, Srinivas.
Lord, this is 498A case, Lord. The petitioners before our lordship are the sisters of the husband who have been implicated in this case, Lord. Lord, may I just pass on the wound certificate, Lord, observing which the interim order was passed. May I just pass on the wound certificate, Lord.
Admission ಗೆ ಬಂದಿದೆ ಅಲ್ವಾ?
Petition ಗೆ ಬಂದಿದೆ.
ಹೇಳಿ.
Lord, the complaint, if your lordship can kindly come to page number 15.
Your sisters.
Sisters, my lord, sisters of the husband.
Accused number 2 and 3.
2 and 3.
What is the overt act against you?
My lord, in the complaint, she makes an allegation that ಪರ್ಕೆಯಿಂದ ಹೊಡೆದಿದ್ದಾರೆ ತಾರಾಶ್ರೀ ಅಂಡ್ ಚಾಕುವಿನಿಂದ ಇರಿದಿದ್ದಾರೆ, ಅಂಗಾಲಿ ಕುಯ್ದು ರಕ್ತ ಗಾಯ ಮಾಡಿಸಿದ್ದಾರೆ, ಜುಟ್ಟು ಹಿಡಿದು ಎಳೆದಿದ್ದಾರೆ. So this is the allegations in complaint, my lord, page number 16.
ಅಂಗಾಲಿಗೆ ಚುಚ್ಚಿ ಗಾಯ ಮಾಡಿದ್ದು ಆರೋಪಿ 3
ಗಾಯಪಡಿಸಿ
ಪರ್ಕೆಯಿಂದ ಮೈ ಕೈಗೆ ಹೊಡೆದು ನೋವು ಉಂಟು ಮಾಡಿದ್ದು.
ಪರ್ಕೆಯಿಂದ ಹೊಡೆದಿದ್ದಾರೆ.
307 ಯಾಕೆ ಪರ್ಕೆಗ?
My lord, your lordship may last while granting interim order, your lordship.
ಕಬ್ಬಿಣದ ರಾಡಿಂದ ಹೊಡೆದಿದ್ದಾರೆ.
ಕಬ್ಬಿಣದ ರಾಡಿಂದ?
Please, my lord,
ಯಾರು ಇವರಿಬ್ರು?
my lord,
ಹಸ್ಬೆಂಡ್ ಹೊಡೆದಿದ್ರೆ ಬೇರೆ, A1 ಹೊಡೆದಿದ್ರೆ that's a different. ಇವ್ರು ಬ್ರೇಕ್ ಮಾಡಿದ್ದಾರೆ ಹೇಳಿ.
They are residing in the same house, my lord.
No,
The
no,
sister's house only, my lord. Husband and his wife, and they have assaulted and they have harassed. Your lordship may kindly see the complaint itself, my lord.
Wait sir, ಅವ್ರು ಹೇಳಿ.
Complaint itself, my page number 15 maybe.
Page
15, that's
ಚಾರ್ಜ್ ಶೀಟ್
complaint.
ಆಗಿಲ್ವಾ ಇದರಲ್ಲಿ?
Charge sheet.
ಆಗಿದೆಯಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಬನ್ನಿ
Charge-
ಇದಕ್ಕೆ.
Your lordship may kindly page number 13 maybe.
ಪೇಜ್
kindly see.
25 ಬನ್ನಿ. ನೀವು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಗ್ಲೋರಿಫೈ ಮಾಡಿ ಏನೇನು ಹೇಳಿರ್ತೀರಾ, ಚಾರ್ಜ್ ಶೀಟ್ ಬನ್ನಿ.
May I read this? ಉಂಗುರ ಮತ್ತು ಇದು
ಅಯ್ಯೋ ನೀವು ಅದೆಲ್ಲ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇಂದ ಹೋಗ್ಬಿಡಿ.
ಇಲ್ಲ ಇಲ್ಲ.
ಅಕ್ಯೂಸ್ 2 and 3 ಏನಿದೆ ಅದು ಹೇಳಿ.
ಆರೋಪಿ 1ರ ತಂದೆ ಮೃತಪಟ್ಟಿದ್ದು, ಶವ ಸಂಸ್ಕಾರಕ್ಕೆ ಆರೋಪಿ 1ರ ಮನೆಗೆ ಕರೆದುಕೊಂಡು
ನೋಡಿ,
ಬಂದಿದ್ದು.
ಆರೋಪಿ 1 ಕುಡಿ ಹಾಕಿ ಸೋಣ್ಸೋ ಹೊಡೆದಿರೋದೆಲ್ಲ ಆಯ್ತು.
ಮನೆಯಲ್ಲಿ
ಆರೋಪಿ 2, 3 ಏನ್ ಮಾಡಿದಾರೆ ಹೇಳಿ ಸರ್?
ಅವಾಚ್ಯ
ಆರೋಪಿ 2 ಚಾಕುವಿನಿಂದ ಅಂಗಾಲಿಗೆ ಚುಚ್ಚಿ, ಆರೋಪಿ 3 ಪರ್ಕೆಯಿಂದ ಮೈ ಕೈಗೆ ಹೊಡೆದು ನೋ ಗಾಯ ಉಂಟು. ವೆರಿ ವುಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್.
My lord, may I just pass on, my lord.
ಯಾಕೆ ಇದಕ್ಕೆ ಹಾಕಿಲ್ಲ?
May kindly see the photos, my lord. Wow, how
ಕೊಡಿ.
she has suffered.
ಒಂದೊಂದ್ ದಿನ ಒಂದೊಂದು ಇಂಜುರಿ ಹೇಳಿರ. 6/7/2022 ಒಂದು
Near
ಇಂಜುರಿ.
6 days she has taken the treatment, my lord.
ಒಂದು ಇಂಜುರಿ.
ವೇಟ್ ಸರ್, ಇದೆಲ್ಲ ಹಸ್ಬೆಂಡ್ ಮಾಡಿರೋದು
ಅಲ್ಲ, ಹಸ್ಬೆಂಡ್ ಅಲ್ಲ, ಚಾಕುನಿಂದ ಚುಚ್ಚಿ ಕಾಲಿಗೆ ಚುಚ್ಚಿರೋ ಸ್ವಾಮಿ. ನೆಕ್ಸ್ಟ್ ಫೋಟೋ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಫೋಟೋ ಇಸ್ ದೇರ್, my lord.
ನಿಮ್ದು ಫೋಟೋ ಇರ್ಲಿ ತಗೊಳ್ಳಿ. ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಿದೆ? ವುಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಿದೆ? ಒಂದು ನಿಮಿಷ.
6/1/2022 there is one injury, my lord.
Both upper limb, lower limb, and by broomstick. Are simple in nature. But ಯಾಕೆ ಹೊಡೆದ್ರಿ?
ಅಲ್ಲ ನಾವು ಹೊಡೆದಿಲ್ಲ ಅಲ್ಲಿ, my lord. If
ಯಾರು
lordship
ಹೊಡೆದ್ರು?
may kindly see.
Yes.
And
She is
date
a
it is
M.Com
first, my
graduate,
lord,
my lord. She is
complaint is allegation
wait,
is
sir.
on 9/1/2022. Complaint filed on 23/1/2022. Delay not explained. And moreover, my lord, injuries ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Though he states 1 to 5 are simple in nature and no.
No, we may
injuries
not
can be
hold
16.
307 against you, but other offenses 323, 324 definitely.
My lord, broomstick ಇಂದ ಹೊಡೆದಿದ್ದೀವಿ ಅನ್ನಕ್ಕೆ, my lord, except her oral statement, my lord, broomstick ಇಲ್ಲ ಅಲ್ಲಿ.
Broomstick recover ಮಾಡ್ಬೇಕಾಯ್ತಾ?
And she is a B.Com, M.Com graduate, my lord. She-
ಯಾರು?
That is second respondent.
So
She is well
how does
educated.
that
She is well educated, my lord, and they have suffered like this, my lord. May kindly see. She has admitted, taken treatment 4 days, my lord.
Also not attract, my lord.
Yes, sir.
because they are not, they are residing separately, my lord.
307 we may quash against both of you, but
But even 498.
against the husband, yes.
My lord, 498, my lord, I am no way involved, my lord. I am not
320,
residing, I am residing with my husband.
323, 324 will definitely become applicable.
So,
ಏನ್ ನಾನ್ ಕೇಳ್ದಂಗೆ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? So
sorry, my lord.
Huh?
My lord,
So-
498A.
So petition will meet its dismissal.
But 498A will also not.
2:30, 2:30.
Please.
Yes. We'll continue at 2:30.
Lordships kindly, my lord.
Serial number
My
90.
apologies, my lords. Morning I was not present, my lords, to Pune.
You are in some other court where memo is not taken.
No, my lords. Orders matter, first matter was there.
ಹೇಳಿ.
My lords, the petitioner before your lordships, my lords, is the official liquidator, my lords. He is appointed, my lords, under order of the NCLT, my lords, in an IBC proceedings. The creditor, my lords, goes before the BMTF police station and lodges a complaint. Now the BMTF police, my lords, have summoned the official liquidator, my lords. The crime is not registered.
ನಾಳೆ ತಗೊಳ್ಳಿ.
Grateful.
Serial number 89.
96.
Page wise ಕರ್ಬಿಡಿ madam.
Serial number 96.
Wait, I'll adjournments ಬೇಕಾದ್ರೆ will grant.
Page 15, 90 to 96.
90, my lord.
96.
Respondent
1 minute, 90.
respondent number 2 out of station ಇದೆ sir. ಅದರಿಂದ
BS Prasad is seeking time.
I am for the petition.
Settlement ಅಂತ ಇದೆ.
Yes, your honor. ಇದ್ರಲ್ಲಿ settlement ಆಗಿದೆ.
List on 22nd.
Criminal petition, connected petition ಒಂದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
ಕೊಡಿ ಅದು. Tag this petition along
21.
with so
25, 26.
ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬನ್ನಿ.
ಸೀನಿಯರ್ ಬೆಂಚ್ ಇಲ್ಲ ಅಲ್ಲಿ ಕೊಡಕ್ ಹೋದೆ ಅವ್ರು ಸೀನಿಯರ್ ಬೆಂಚ್ ಮುಂದೆ ಮೂವ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೋಸ್ಕರ
Tag this petition along with so and so. Post the
25,
matter,
26
post both these matters on 22nd for settlement.
26 maybe your honor.
26th.
96.
26th. 26 ರಜಾ ಇಲ್ಲ ಮೇಡಮ್. 27th.
much.
92.
For petitioner.
Yes, Faiz. Entry ಮಾಡಿದ್ಯಾ? Entry ಮಾಡಿದ್ಯಾ? Respondent ಹೇಳಿದೀರಾ? Reach ಆಗುತ್ತೆ ಇಲ್ಲೇ. Learned counsel with the petitioner seeks a week's time. List the matter on 11th September.
96, my lord.
Entry matter subsisting shall continue till the next date of hearing. Yes.
96, my lord. I engage one of the matter. Difficulty in the afternoon.
96 batch matter.
Batch matter.
It is, the
Dharnesh,
petition is not
Dharnesh
maintainable.
there, wait.
Speak, my lord.
I've been waiting. Last whole day we have waited for me and it is not maintainable.
96 reach ಆಗುತ್ತೆ. Reach ಆದಾಗ ನೋಡೋಣ. If attainment is to be. Yes.
Some difficulty I have, my lord. Therefore, I'm waiting.
No problem, sir.
I was very much here. I waited.
No issues in half an hour or you can tell him if he is agreeing, I don't have, I have no problem. There is objection, yes. 95.
Counsel on record is not well, your lordship. Seeks adjournment.
Petitioner or respondent?
Petitioner, Swami.
ಪರಲ್ವಾ? Yes. At
My
the
lord,
request of,
time ಆಗ್ಲಿ Swami.
Huh?
2 weeks.
2 weeks. At the request of the learned counsel appearing for the petitioner, list the matter. Vacating stay there?
ಇದೆ Swami.
List the matter on 4th September in the 4th September under the caption interlocutory application. Yes.
My lord, serial number
Interim
89.
order subsisting shall continue to the next date of hearing. Yes, next.
Serial number 89.
Page 16.
I appear for petitioner, my lord, praying for 2 weeks.
89.
Yes, my lord.
ಏನಾಯ್ತು?
I appear for petitioners, my lord, praying 2 weeks time. Maybe listed for 2 weeks, my lord. Interim order-
Settlement ಅಂತ ಇರೋದಲ್ಲ 89, what is this?
No, my lord.
Connected matters.
Connected
matters.
matters. All right, yes, list on 6th, 10th September, yes.
My lord's interim order may be extended.
Interim order subsisting shall continue to the next date of hearing. Next,
Grateful, my lords.
if the other side objects, then I will take it up.
I'll be here.
Yes,
Page 16, 97 to 102. Page 17, 103 to 112. Page 18. 113 to 117. Page 19. 118. Page 20. 119 to 126. Page 21, 127 to 137.
My lord, 130.
Bill number 115, my lord. Maybe add on 1480.
115.
115, my lord.
Interim order ಇದೆಯಾ?
Maybe extended.
List after 2 weeks, interim order granted earlier stands extended to the next date of hearing.
134.
130?
134.
ಏನಾಗ್ಬೇಕು?
Petitioner, 2 weeks time.
Respondent ಯಾರು? 130?
34. Interim order ಇದೆ.
1 ನಿಮಿಷ ಸರ್.
34.
134. 2 weeks, interim order subsisting shall continue to the next date.
May I make one submission, Lordship?
107.
Yes, Tahir?
I'm sorry to make submission, Lordship. Lordship, one review is pending since very long time, Lordship.
They should be
One
vacated.
review is pending for the order, Lordship.
All right, Friday I was not sitting, so it has not come. ಇವತ್ತು ಬಂದಿಲ್ಲ ಮೇಡಮ್ ಫರ್ದರ್ ರಿವ್ಯೂ ಇವತ್ತು ಇದೆಯಲ್ಲ?
No, review is not there, Lordship. That's other matters are there.
ಬಂದಿಲ್ವಾ? Let me see. Tomorrow ಹಾಕ್ಸ್ತೀನಿ.
Obliged.
Yes, madam. ನಿಮ್ದಲ್ಲ ಅಲ್ಲಿ VC ಇದ್ದಾರೆ, ನೀವು ಇದ್ದೀರಾ ಹೇಳಿ.
Today you said you will finish off.
Huh?
this. Today you said you will finish off this, not today.
Finish off. What finish off?
Because 482.
ಎಲ್ಲರೂ finish off ಅಂತಾನೆ ಕೇಳ್ತಿರೋದು. I will be finished off. Yes. ಏನ್ ವಿಡ್ರಾ ಇಲ್ಲ. ಮೆಮೊ ಈಗ ಕೊಟ್ರ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ. Yes. Yes.
ಸರ್ ಪಾರ್ಟೀನ್ ಪರ್ಸನ್ ಅಪಿಯರ್ ಆಗಿದೆ ಸರ್ 22nd ಪಿಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತು ಸರ್, ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ವಿಡಿಯೋ ಬಂದಿತ್ತಂತ ಸರ್ ಪೊಲೀಸ್ಗೆ, ಅದಕ್ಕೆ ನನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿ ಶಿವಮೊಗ್ಗ ಜೈಲಿಗೆ ಹಾಕಿದ್ರು ಸರ್.
ಯೂಟ್ಯೂಬ್ ಅಲ್ಲ ಯಾವ್ದಕ್ಕೆ?
ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಾನು ಲೋಕಾಯುಕ್ತ ಕೇಸ್ ಮಾಡಿದ್ದೀನಿ ಪೊಲೀಸ್ ಮೇಲೆ, ಅದಕ್ಕೆ ಅದು ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ನೋಡ್ಬಿಟ್ಟು ನನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿ.
ನೀವು ಯೂಟ್ಯೂಬ್ ವಿಡಿಯೋ ಅಪ್ಲೋಡ್ ಮಾಡಿದಿಲ್ಲ
ಸರ್, ಅದು ಲೈವ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಸರ್.
ಯಾವ್ದು?
ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಸರ್.
ಯಾವ್ದು ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ? ಈ ಕೋರ್ಟ್
ಸರ್.
ಆಯ್ತು, ಏನಾಯ್ತು ಅದಕ್ಕೆ?
ಅದಕ್ಕೆ ನೋಡಿದ್ತೀನಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗಿ ಪೊಲೀಸ್ ಮೇಲೆಲ್ಲ ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿ ನನಗೆ ಹೊಡೆದ್ಬಿಟ್ಟು DYSP ಸಾಗರ್ ಸರ್.
ಎಸ್ ಸರ್.
ಹೊಡೆದ್ಬಿಟ್ಟು ಸರ್ ನನಗೆ
ಕೇಸ್ ಹಾಕಿದೀರಾ?
ನಾನು ಹಾಕಿಲ್ಲ ಸರ್.
ಅಲ್ಲ ಈಗ ಏನ್ ಹಾಕಿದೀರಾ?
ಸರ್ ಅದು 6961 ಪಿಟಿಷನ್ ನಂಬರ್ 6964 ಎರಡು ವಿಡ್ರಾಲ್ ಆಗಿದೆ ಸರ್. ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡ್ತೀನಿ.
ಇವತ್ತು ವಿಡ್ರಾಲ್ ಬಂದಿದ್ಯಾ?
ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ರಿ ಸರ್ ನೀವು 22nd.
ಹಾ.
ನಾನು ಕೋರ್ಟಿಂದ ಹೊರಗಡೆ ಹೋಗ್ತಿದ್ದಂಗೆ ನಾನು ಟ್ರೇಸ್ ಔಟ್ ಮಾಡ್ಬಿಟ್ಟು ಇಮಿಡಿಯೇಟ್ ನಾನು ಗಾಂಜಾ ಕೇಸ್ ಅಂತ ಹೇಳಿ ಅರೆಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಅಲ್ಲಿಂದ ಮತ್ತೆ ಅಡಿಷನಲ್ ಏನೇನೋ ಸೆಕ್ಷನ್ ಸೇರಿಸ್ಬಿಟ್ಟು ನನಗೆ ಇದು ಮಾಡಿದ್ದಾರೆ ಸರ್. ರಿವಾಲ್ವರ್ ಇಟ್ಬಿಟ್ಟು ಎನ್ಕೌಂಟರ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ನಾನು ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಸಸ್ಪೆಂಡ್?
ಸರ್ ನಾನು ಗೌರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯಿ ಸರ್.
ಯಾವ ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯ್?
KPTCL ಸರ್.
KPTCL ಅಲ್ಲ, ಏನ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್ ಸರ್.
ನೀವೇನು ಕೇಸ್ ಹಾಕಿದಿರಿ?
ಸರ್ ನನ್ನ ಮದುವೆ ಫಿಕ್ಸ್ ಆಗಿ ಕ್ಯಾನ್ಸಲ್ ಆಗಿತ್ತು ಸರ್.
ಮದುವೆ ಫಿಕ್ಸ್ ಆಗಿ?
ಎಸ್ ಸರ್. ಅದಕ್ಕೆ ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ರೈಸ್ ಮಾಡ್ಬಿಟ್ಟು ಅಮೌಂಟ್ ಎಲ್ಲ ಕೇಳಿಸಿದ್ರು ಸರ್. MLA ಕಡೆಯವರು, ಕಾಂಗ್ರೆಸ್ MLA ಪ್ಲಸ್ ಈ ಪೊಲೀಸ್ ಎಲ್ಲ ದುಡ್ಡು ಕೇಳಿಸಿದ್ರು ಸರ್. ಅದನ್ನ ನಾನು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಲೋಕಾಯುಕ್ತ ಕೇಸ್ ಮಾಡಿದ್ದೆ ಸರ್. ಅದಕ್ಕೆ ನೀನು ಲೋಕಾಯುಕ್ತ ಕೇಸ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳಿ ನಾನು ಆ ಊರಲ್ಲಿ ಇರಕ್ ಬಿಡ್ತಾ ಇಲ್ಲ ಸರ್. ನಾನು ಟ್ರಾನ್ಸ್ಫರ್ ಟ್ರೈ ಮಾಡ್ತಿದ್ದೀನಿ ಸರ್, ಬೆಂಗಳೂರಿಗೆ ಆಗ್ತಾ ಇಲ್ಲ ಸರ್. ಅದಕ್ಕೆ ನಾನು
ಅದು ಆಲ್ ರೈಟ್, ನೀವು ವಿಡ್ರಾ ಮಾಡಿದ್ದು. ವಾಟ್ ಇಸ್ ದಿಸ್ ಪ್ರಾಬ್ಲಮ್ ಜಗದೀಶ್?
ಸರ್ ಈಗ 107 ಅಂತ ಏನೋ ಹಾಕಿದಾರೆ ಅಂತ ಸರ್. ಸುಮ್ಮನೆ ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಆಗ್ತಾನೆ ಇದಾರೆ ಸರ್. ಆಮೇಲೆ ಏನೋ ರೌಡಿ ಶೀಟರ್ ಆಗ್ತಾರೆ ಅಂತ ಸರ್. ನಾಳೆ ನನಗೆ ಬನ್ನಿ ಅಂತ ನಾನು ಹೇಳ್ತಿ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸರ್.
ಯಾವ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್?
ಸರ್ ಸಾಗರ ಸರ್. DYSP ಗೋಪಾಲಕೃಷ್ಣ ನಾಯ್ಕ್ ಅಂತ ಹೇಳಿ ಸರ್.
He's telling the name also.
ಸರ್
So
ನಾನು ಜೈಲಲ್ಲಿ ವಿಡಿಯೋ
ask him to encourage restraint or will haul him up. ಇಲ್ಲಿ ನೋಡ್ಬಿಟ್ಟು if this is the allegation, if the allegation is correct, he will face the music.
ಸ್ವಾಮಿ ನಾನು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಿಟ್ಟು ಹೋಗಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಕಾಪಾಡಿ.
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಿಟ್ಟು ಹೋಗಲ್ಲ.
ನಾನು
wait. ಇಲ್ಲೇ KPTCL ಹೋಗಿ ನೀವು ಕೆಲಸ ಮಾಡ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ನಾನು ಸಸ್ಪೆಂಡ್ ಮಾಡಿಸ್ಬೇಕಂತ ಮಾಡಿದಾರೆ ಸರ್. ಏನಾಗಿದೆ ಗೊತ್ತಾಗ್ತಿಲ್ಲ ಸರ್. ಹೊರಗಡೆ ಮತ್ತೇನಾರು ರೌಡಿ ಶೀಟರ್ ಆಗ್ತಿದಾರೆ ಸರ್. ನಾಳೆ
Don't worry, I've told him. ಅದ್ಯಾವ್ದು ಮ್ಯಾಟರ್ ವಿಡ್ರಾ ಆಗಿರೋದು? ಮತ್ತೆ ಕೇಸ್ ಹಾಕ್ಲಿಲ್ವಾ ನೀವು ಅದಾದ್ಮೇಲೆ?
ಇಲ್ಲ ಸರ್, ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಇದ್ದೆ ಸರ್. ಅಲ್ಲಿಂದ
ಆಯ್ತು, ಆಮೇಲೆ ಕೇಸ್ ಹಾಕ್ಲಿಲ್ವಾ ಮತ್ತೆ?
ಇಲ್ಲ ಸರ್, ಹಾಕಿಲ್ಲ ಸರ್. ನೀವು ಎಂಗೇಜ್ ಮಾಡಿದೀನಿ ಸರ್ ಕೌನ್ಸಿಲ್.
He asked me to file, but the file was here. But then by next day only they took him into custody. They have put NDPS my lords 18-1. So and then he says that they have taken signature in blank sheets.
Who, the police?
He says the
ಡೋರ್
name.
ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ಟು ಹೊಡಿತಾರೆ ಸರ್. ಎಲ್ಲದನ್ನು ಇದು ಮಾಡಿದೀನಿ.
ಆಯ್ತಾಯ್ತು, ಈಗ ಏನ್ ಬಿಚ್ಚಕ್ ಹೋಗ್ಬೇಡಿ.
ಜೈಲಲ್ಲಿ ವಿಡಿಯೋ ಮಾಡಿಸಿದೀನಿ ಸರ್. ನಾನು ಜೈಸಿ ಕೊಟ್ಟು
ಏನ್ ವಿಡಿಯೋ ಮಾಡಿಸಿದೀರಾ?
DYSP ಹೊಡೆದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಇದು ಮಾಡಿಸಿದೀನಿ ಸರ್. ಎಲ್ಲರೂ ಹೇಳಿದ್ರೆ ನೀನ್ ಮತ್ತೆ ಎನ್ಕೌಂಟರ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ರಿವಾಲ್ವರ್ ಇರ್ತಾರೆ ಸರ್ ನನಗೆ.
All this is being recorded. So let the DYSP be aware of all this. If he has really behaved like this, I will definitely direct action. Yes. ನೀವು ವಿಡ್ರಾ ಮಾಡಿದ ಮತ್ತೆ ಕೇಸ್ ಹಾಕಿಲ್ವಾ? Why you have not filed?
He was not there my lords afterwards.
All right, if
The
and if it is to be file is in the court hall, why?
Because they say that in the scrutiny it is here only in the court hall. That's what they have told it.
Yeah, madam. Scrutiny.
Withdrawal in a hotel.
Just check.
That's it.
We'll see. Yes.
ನಮ್ದು ಪರ್ಸು ಮೊಬೈಲ್ ಎಲ್ಲ ಕಸ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್.
Tomorrow.
ಮೊಬೈಲ್
ಈಗ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ನಾಳೆ ಬೆಳಗ್ಗೆ
ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿ ಮೊಬೈಲ್ ಎಲ್ಲ ಸರೆಂಡರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್.
ನಾಳೆ ಜಗದೀಶ್ look into it. Yes. ನಿಮ್ದು ವಿಡ್ರಾ ಇಲ್ಲ ಇರಿ ಸರ್. ಎಸ್.
Ma'am, case number is what? Huh? Case number is what? Madam.
With permission of the court. One fresh matter, I filed 1 week back, complied everything, even,
ಮೂವ್ ಮಾಡಬೇಕು.
I'm sorry then, it may be taken up any day, I am not resting.
ಎನಿ ಡೇಗೆ 2:30 ಯಾಕೆ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ನಾಳೆ ಕೊಡಿ.
My
ಏನ್
lordship
ಅರ್ಜೆನ್ಸಿ?
permission.
Not urgency.
1 minute, sir.
Boy is there for the past 1 year in jail. This is a POSCO case and girl is married once again.
ಪೋಕ್ಸೋ
POSCO. Sorry then.
ಅಲ್ಲ, ಪೋಸ್ಕೊಳ್ಳೋದೇನಿಲ್ಲ.
ಇಲ್ಲ, I'm sorry. ಅದಕ್ಕೆ ಕಲಿಬೇಕು, ನಾವಿನ್ನೂ ಕಲಿತಾ ಇದೀವಿ, ದಯವಿಟ್ಟು.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಹೇಳಿ.
ಆ,
ಕೊಡಿ. ಏನ್ ಸೆಟಲ್ಮೆಂಟಾ?
Settlement ಇಲ್ಲ, they are not coming forward for anything, but boy is in the jail for the
ಏನ್
past
ಮಾಡಕ್ಕಾಗತ್ತೆ?
1 year. Charge sheet is filed, everything is
ಪೋಕ್ಸೋ
over.
ಬೇಲ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ, that is crashing ಹಾಕಿದ್ರೆ ಅವ್ರು ಬರ್ತಾರೆ ಅಂತ ಒಂದು ದೃಷ್ಟಿಯಿಂದ ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ವಲ್ಲ.
ಪೋಕ್ಸೋಲಿ ಕ್ವಾಶಿಂಗಾ?
Please, my lord, let there be a notice go for on this matter because she is
No,
married
sir.
again.
Settlement ಅಂದ್ರೆ will consider if
They may come for settlement because
They
now
may
she is
ಇಲ್ಲ.
the girl is with
before
another
moving
boy.
the matter, you should contact the other side. I will not ಪೋಕ್ಸೋಲ್ ಕ್ವಾಶಿಂಗ್ ಎಲ್ಲ ಬರೋದೇ ಇಲ್ಲ.
ಅಲ್ಲ, I filed a case, but let the notice go on.
It won't even go. ಬರ್ಲಿ ಅದು ಮಂಡೇ ಹಾಕಿ.
Please.
My lord, I filed a memo today morning.
Number today? What number?
Filed FR number 8242. But this is not listed
2:30
for.
ತಗೊಂಡ್ವಾ ಅದ್ನ?
Yeah, I request for a 2:30 matter.
ಯಾರು 2:30? Nobody said 2:30.
My lord, I am from Kerala, so I don't know the practice here. That's the reason.
All right. What's the matter?
Matter is I am an accused in the customs case. That since 2017, without any evidence, they arraign me an accused.
No,
I
sir,
was
if it-
facing, I am traveling all the way.
All right, if it's a customs case.
Yes.
And pending since 2017.
Yeah.
Without hearing the other side, I will not grant any order.
Of course, my interim prayer is to stay the proceedings of the lower court.
Also, I will not grant without hearing the other side in a customs. case.
Tomorrow is the one hearing is, he has to pay at least 5,000 rupees for coming and going back to Kerala.
No problem.
Simple, there is no evidence
Where-
at all.
where is
That's
he
my
from?
problem.
Where is he from?
He's from Kerala.
5,000 rupees, yeah. Why?
So 2,500 to bus fare, my lord.
Okay.
To and fro will be 5,000 at least.
Okay. You spend
So-
another 5,000, I will take it on another day.
Another day,
Ah.
maybe 15th can be possible.
When, 15th?
Yeah. Tomorrow maybe,
Tomorrow we'll take. Yes.
afternoon session, my lord.
Why you want afternoon?
No, I have
You want
to
to go
appear
to
in the
Kerala and
customs
come
court.
back?
Tomorrow, if the case is posted, I have to attend
We'll
there
take it on Thursday.
Thursday. Yes.
You
yes,
finish your court and stay
Yes, my
here. On
lord.
Thursday, we'll take it.
Yes, my lord.
Yes, the
Obliged.
number ತಗೊಳ್ಳಿ.
Serial number 175, my lord. Settlement gittu, the parties were supposed to come here before the court, but our farmers ಆಗಿರೋದು agriculture activities ಸ್ವಲ್ಪ
ಆಯ್ತು ಸರಿ,
ಜೋರಾಗಿದೆ.
ಯಾವತ್ತು ಬೇಕು?
It may be posted next Tuesday, my
ಆಯ್ತು, next Friday.
Friday ಬೇಡಿ ಸ್ವಾಮಿ.
ಯಾವತ್ತು?
13th. Next
13th
Tuesday, 13th Tuesday ಬಿಡುತ್ತೆ.
ಏನು offense ಏನು?
ಅದೇ ಇದು 307.
ಅದೇ 307. ಏನು 504, 506 ತರ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಅದನ್ನ? ಹಾ.
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ವಿ ಆರ್ ಪ್ರೆಸೆಂಟ್ ಹಿಯರ್. ದಿ ಇಂಜುರಿ ಆಫ್ ದಿ
ಅಲ್ಲ, ಆಯ್ತು,
ಬಾಡಿ
we'll see.
ಪಾರ್ಟ್ ಇಂಜುರಿಗೆ ಹೇಳಿದ್ದೆ.
ಆಯ್ತು,
citation.
20ನೇ ತಾರೀಕು ತಗೊಂತೀನಿ.
20ನೇ ತಾರೀಕು.
ಹಾ,
ಮಚ್ಚ
20th.
25. Judiciary matters listed, all the matters listed tomorrow, madam.
ಯಾವುದು ಸರ್?
125.
ಏನದು?
Judiciary, that several matters listed tomorrow.
What?
Judiciary home.
Unishare.
Yes.
All right, yes.
Tomorrow. madam.
ಆಯ್ತು, ಬಂದಾಗ ಮಾಡೋಣ. ನೀವೇನ್ ಇರೋದ್ ಬೇಡ. Yes.
Stay is there, stay may be carried.
That will be extended.
Milords, serial
Yesterday-
number 167, Milords.
Ah.
The Honorable Court had directed us to make a mention when the matter was listed.
167.
Garbage tender matter, Milords.
ಒಟ್ಟು ಅದು ಇದೆಯಾ ಇವತ್ತು?
Yes,
ಆಯ್ತು, I'll take it up. Let's see.
yes, Milords.
First pronounce ಮಾಡ್ತೇನೆ.
Morning, I'm sorry, I was not there for serial number 44. Let's go to the next matter, if my lords could, I informed.
ಅಲ್ಲ, ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದೀನಿ.
And it's passed over. Could your lordship consider 13th, my lords, ಅದು ಇವ್ರಿಗೆ.
Petitioner ಯಾರು?
ಹೇಳಿದ್ದೀನಿ. Prithvish is there.
ಪ್ರಿತೀಶ್ ಹೇಳಿದ್ದೀರಾ? ದಟ್ ಚಿಲುಮೆ. All right.
I'm so sorry, morning I was held up.
ಯಾವತ್ when do you want?
13th, my lords. 13th.
13th or 14th will have it. 14th.
13th ಆದ್ರೆ.
ಆಯ್ತು, 13th ಇರಲಿ. ಅನೌನ್ಸ್ಮೆಂಟ್ ಕೊಡಿ. ಧರಣೇಶ್ ಇದ್ರೆ.
Till number 1.
Dismissed.
My lordship, is this list
Yes.
number 2?
List
Yes.
number, yes, madam.
For the petitioner, your lordship.
Dismissed.
Till number 2.
Obliged. My lordship, one submission. If direction can be given to the trial court for having it completed within a period of time.
That is in the body
Because-
of the order I've observed. It need not be in the operative portion. Yes.
Much obliged, my lordship.
Dismissed.
Number 3.
Petitioner.
Criminal petition is allowed. The crime in so and so stands quashed. The quashment of the proceedings will not come in the way of any mode of resolution of the dispute to be instituted by the complainant against the petitioners. The observations made in the course of the order is only for the purpose of consideration of the case of the petitioners under 480 of the CRPC, which would not bind, guide, or influence any pending or to be instituted proceedings before any fora between the parties.
Number 4.
Dismissed. All 304 years dismissed. The 304.
Not 304, my lord.
ಇದು ಯಾವ್ದಿದು?
So 506 324 is a private complaint by advocate against the
Advocate.
ಓ ಇದು ಮಟನ್ ಸ್ಟಾಲ್.
Mutton stall.
ಹಾ,
sanction.
ಮಟನ್ ಸ್ಯಾಂಕ್ಷನ್ ಯಾಕ್ಬೇಕು? ನೀವು ಮಟನ್ ಸ್ಟಾಲ್ ಅಲ್ಲಿ ಗಲಾಟೆ ಮಾಡಿದ್ರೆ ಅಫಿಷಿಯಲ್ ಡ್ಯೂಟಿನ ಅದು. ಎಸ್.
Okay.
Number 5.
I represent the petitioner counsel.
President's medal. Writ petition is allowed, proceedings in so and so stands quashed.
Great.
I'm grateful.
Number 6.
Good argument. Good argument, I said.
There will
But
be
difficult.
little more contentions in this.
No. ಅದೆಲ್ಲ Supreme Court ಅಲ್ಲಿ ಮಾಡ್ಕೊ.
What the relevant.
Writ
judgment
petition,
was.
you see the order. Writ petition stands rejected. It is for the petitioner to avail of such remedy as is available in law at the appropriate time before the appropriate fora and at the appropriate stage. But good submission.
My lord, but if the seizure is not reported before magistrate, I
You
do
just
not have any
see
alternative.
the orders. Yes. Yes.
7.
Writ petition is allowed in part. The offense that is laid against the petitioners under section 304 of the IPC stands quashed. The petitioners are charged with the offense under section 304A of the IPC, along with 149 of the IPC in place of section 304. The concerned court shall try the petitioners for offense punishable under section 304A in accordance with law. It is made clear that the observations made in the course of the order are only for the purpose of consideration of the case of the petitioners under 48 of the CRPC would not bind or influence the proceedings against them before the concerned court.
Number 8.
Dismissed.
9.
ಇದು ಅಷ್ಟೇ, ಸೇಮ್ ಕ್ರೈಮ್. ಇದು dismissed.
10.
Reject. Dismissed.
65B.
Huh?
65B matter.
65B, dismissed.
Please.
It would not vitiate the certificate can be given later. 230 ಸ್ಪೆಸಿಫಿಕ್ ಯಾವ್ದಾರು ಇದೆಯಾ? ಯಾವ್ದು ತಾಹಿರ್ದು ಇದೆಯಲ್ಲ, ಏನಿದೆ 230 ಕರೆದು ಬಿಡಿ ಅಲ್ಲ.
Fresh matter at 2:30 PM, 173.
ಎಸ್ ತಾಹಿರ್, ಯಾವ್ದು ನೆನ್ನೆದಾ?
Yes, Lordship. This Lordship, my submission is that.
It's a 2023 crime. What is the problem now?
Not 22, 24 Lordship.
24 ಏನ?
24
ಕೊಡಿ
Lordship.
ಮೇಡಮ್.
It is- Same Lordship has dealt with the same matter. It's fine, we filed for quashing. Our ground is that 411 and 413 will not be applicable against us, even though we admit that we have purchased the gold. But for 411 and 413 is knowledge is important, Lordship. Relying on the judgment of Apex Court
Yes.
on this aspect, Lordship.
ಆಯ್ತು, ಬರ್ಲಿ, ಫ್ರೈಡೆ ತಗೊಂತೀನಿ, ಸ್ಟೇ ಮಾಡಿರ್ತೀನಿ ಅಲ್ಲಿವರೆಗೆ. The learned additional SPP is directed to accept notice for the respondent.
They pass over my lord. He's on his next.
ಆಯ್ತು, ಪಾಸ್ ಬರ್ಲಿ ಬಿಡಿ.
The one is
I will
legal
stay it
aspect.
anyway because 411, 413, we'll consider it. Yes, we'll answer it.
Please.
ಅವರು ನೀವು ಅಂದ್ರೆ ತುಂಬಾ ಇಷ್ಟ, ಅದಕ್ಕೆ ಬರ್ತೀನಿ. ತಾಹಿರಲ್ಲ, petitioner, prosecution.
No, 40 cases got quashed, that time they are not allowed.
ಏನ್
Now
ಮಾಡೋದು?
they want it.
What happened to that? That I closed it ಅಲ್ಲ?
Yeah, that closed.
Ah.
It was on 169.
Yes.
So now we filed this for quashing. Next is matter for compromise.
Settlement, ಏನಿದು?
Yes, Lordship. This case and counter case, 447, dispute related to
447, ಕೊಡಿ.
boundaries and
Both
civil
parties
cases
are
pending.
there?
Yes, parties are.
Parties are present before this court, my lord.
Both case petition number 2 is the complaint in a respective case, Lordship.
The petitioners are before this court, ಎರಡರಲ್ಲೂ madam, calling in question so and so. Madam, this is serial number 174. So and so. Registered for offences punishable under so and so. The issue in the list is case and a counter case. both for offences punishable under section 447, 448 of the IPC inter alia. During the pendency of the petition, the parties to the list have settled the dispute amongst themselves by drawing up certain terms of settlement. According, in furtherance whereof, a application under section 320 of the CRPC to compound the offence is preferred. The affidavit in support of the application.
And the submission. The trumps, they will agitate their dispute in a OS proceeding.
ಇಲ್ಲಿ ಏನ್ ಬರ್ದಿದ್ದೀರಾ ಅದು? So the terms of the settlement so drawn in the affidavit reads as follows. In the light of the settlement arrived at between the parties and the offences alleged not being against the state, I deem it appropriate to accept the application seeking compounding of the offence, compound the offence and obliterate the crime against the petitioners. ಯಾವ್ದು ಮೇಡಮ್ ಅದು? All the three madam. ಯಾವ್ದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಲ್ಲ ತಾಹೇರ್?
ಆಗಿಲ್ಲ but that is by
ಅದು ಮೇಡಮ್ ಫಸ್ಟ್ ಅದು ಬಾರ್ಡರ್ ಬರ್ಕೊಳ್ಳಿ. DD ಫೈಲ್ ಇದೆಯಲ್ಲ 10245. The subject petition is dismissed by the registrar on account of non-compliance of office objections. The same stands recalled. The petition is restored to file ಅಂತ ಬರೆದ್ಬಿಟ್ಟು ಆಮೇಲೆ
Application is there.
ಕೊಡಿ. ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಾ? ಹಿಂಗ್ ಮಾಡಿ. Dismissed by so and so. The petitioners have preferred an application seeking recall of the said order for the reasons indicated in the affidavit accompanying the application. The same stands recalled, restored to file, ಆಮೇಲೆ settlement. Yes, sir. ಇನ್ಯಾವುದು? ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ ಕರ್ಕೊಂಡು ಎಷ್ಟಿದೆ ಮೇಡಮ್?
Settlement 172.
ಇದರ
For the petitioners, 324, 323.
376.
323, 324.
ಹಾ.
504, 506. 7. W6 and CW1, CW6, CW1, both are the victims.
ಏನ್ CW6, CW1?
CW1 is a de facto complainant. CW6 is also another injured. In page,
Smoke a cigarette.
page 27 is the summary of the charge.
27. ಅದ summary ಇರಲಿ. Settlement ಎಲ್ಲಿದೆ? ಮೇಡಮ್ 456 172 ಇದು ಸೇಮ್ ಹೇಳ್ಬೇಕಾ ಮೇಡಮ್? ಇಲ್ಲ ಸಿಗ್ನೇಚರ್ ಅದು ಫಸ್ಟ್ ಸಪರೇಟ್ ಆರ್ಡರ್ ಶೀಟ್. Learned counsel so and so enters appearance for the respondent, registry to print the name of so and so. Yes, next.
Order sheet signature. Quoting settlement 176.
I'm for the respondent, my lord.
Parties are settled the matter.
Offense
138, my lord.
138. 3 months ಅಲ್ಲಿ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಒಂದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಹಾಕ್ತೀವಿ. ಮ್ಯಾಟರ್ ಮೇ ಬಿ ಕೆಪ್ಟ್ ಪೆಂಡಿಂಗ್. Meanwhile, we will make payment, this undertaking will be taken.
Amount is agreed, my lord. Only they want within 3 months.
Payment is.
ಆಯ್ತು. ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಮಾಡೋದು ಬೇಡ, ಬರ್ಕೊಂಬಿಡಿ ಮೇಡಮ್. The matter is moved to report settlement. The settlement is in fact arrived at between the parties. The only request is that they may be granted 3 months' time to comply with the terms of the settlement by paying the entire amount. The learned counsel for the respondent has no objection if they would adhere to the timeline of 3 months. Therefore, 3 months' time from today is granted to the petitioners to fulfill the terms of the settlement.
It is agreed that 31st of October is their last day, my lord.
August, September, on the 5 dina paravilla bide. So list the matter for further hearing on October 15th
ಮೆಮೊ ಅಂತ ಹಾಕಿದ್ದೀನಿ.
ಏನ್ ಮೆಮೊ?
Memo of undertaking.
Memo for undertaking. They could be placed on record.
The submission of the petitioner is placed as an undertaking before this court, breach of which would be viewed seriously. ಅಷ್ಟೇ sir.
Stay may be kindly.
Interim order subsisting shall continue till the next date of hearing.
But
With order sheet, madam. 15th October for the hearing.
One seventy-seven.
for the petition.
Corresponding filing
324, my lord.
323, 324. Learned counsel so and so undertakes to enter appearance for the respondent. Registry of so and so is appearing for the respondent. Good evening.
Parties are the friends,
Parties?
are the friends, my lord. Petitioners and the complainant. Respondent.
Decided to live happily.
They are the relative brothers, my lord. Brothers also.
All right, yes, madam. Ella copy next week. Yes. Yes. 213 ಯಾವ್ದಿಲ್ಲ? Continue the list.
Continue. 191.
91 ಬಂದಿದೀವಾ? ಶ್ರೀನಿವಾಸ್, ಅದೇ ಅವ್ರದ್ದೇ ತಗೊಳ್ಳಿ. 8, he was on legs ಅಲ್ವಾ? 88.
Blood, 307, they have not been charge sheeted for 307 at all. They have been charge sheeted for 342, 324, 323, 504 and 498A, 34 of IPC.
506 has been added, my lord. We should make a
You know?
charge sheet. 506 has been added.
I was.
That as, Lord, a wound certificate, your lordship may kindly see which is a
Sir,
document. number
simple
5.
in nature, no problem. But there is a wound.
That 498A would also not attract, my lord, because they are not residing, they are sisters, my lord, they are residing separately along with.
But
their
other offense, 323, 324, 504, 506 will be tried. 498 I will quash and 307 in Madilva.
307 ಇಲ್ಲ,
ಆಯ್ತು,
307 ಇಲ್ಲ. Lord, 1 second, my lord, may I point out your lordships to the wound certificate.
Simple in nature.
Simple in nature, no significant, no mark seen. Wound. But in that case, my lord, 324 will also not attract. 324.
That the court will decide.
323, my lord, my lord, wounds ಅಲ್ಲಿ ಒಂದೊಂದು ದಿನ ಒಂದೊಂದು wound ಹೇಳಿದ್ದಾರೆ. My lord, your lordship may kindly.
ನೀವು ಒಂದೊಂದ್ ದಿನ ಒಂದೊಂದ್ ಪರ್ಕೆಲ್ ಹೊಡೆದಿದ್ದೀರಾ? That is the allegation.
The complaint doesn't say it started on 6/1/2022 and ended on such and such a day. The complaint says on 9/1/2022. The complaint and the further evidence, further statement also reveals like that. My lord, in the further statement, she withdraws her allegation as against another accused also, where she made allegations against in the complaint against the daughter of the second petitioner. Now, my lord, your lordship may kindly see the wound certificate for 1 minute
Sir,
document.
it is simple in nature, no doubt about it.
ಅಲ್ಲ ಒಂದೊಂದು ದಿನ ಒಂದೊಂದು wound ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ. Now, my lord.
Hit the face by hands and feet by so and so.
22 around 8:30 PM for the first time by her husband, first elder sister.
ಅದೆಲ್ಲ matter of trial.
My lord, ಒಂದೊಂದು ದಿನ ಒಂದೊಂದು wound ಹೇಳಿದಾಗ, my lord, it is highly unbelievable, my lord, because ಒಂದೇ.
Sir, you may not believe anything. Trial court ಅಲ್ಲ.
My lord, 498A
That
there is
time.
no material.
That time. Yes, sir.
Please.
324 ಏನಿದೆ?
Lordship may kindly, last photo may be kindly.
Photo ನೋಡಿ
ಅಲ್ಲ
324.
ಕಾಲ್ ಬೇರೆ ಕಟ್ ಮಾಡಿರೋದು ಹೇಗಿದೆ? ಲಾಸ್ಟ್ ಫೋಟೋ ನಲ್ಲಿ.
ಕಾರ್ ಕಟ್ ಮಾಡಿದ್ದಾರೆ.
ಲಾಸ್ಟ್ ಫೋಟೋ ಮೇ ಬಿ kindly see.
Wound certificate.
ಅದು ಕಾಲ್ ಕಟ್ ಮಾಡಿರೋದಾ?
ಹೇಗೆ ಗಾಯ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಬಿಟ್ಟು.
ಅಲ್ಲ.
ಸರ್ injuries are in simple.
No,
but pain is
323,
exorbitant, my lord.
504, 506, no problem.
Injuries are simple, my lord, but pain is exorbitant, my lord. How?
Exorbitant.
That too, she is a M.Com graduate, my lord.
I am also
She
a
highly
noted
educated,
for government
highly
servants
educated.
residing in Bangalore.
ಅದೇ
She-
ಪರ್ಕೆ ತಗೊಂಡು ಎಲ್ಲಿಗೆ ಹೋಗಿದ್ರಿ ಮತ್ತೆ ನೀವು ಹೊಡಿಯಕ್ಕೆ?
My lord, there is no such incident. It was death of my father. We were visiting, my lord, she admittedly on the complaint, when she makes allegations, my father died. We were all in our native place, look, my lord, after the 3 days ceremony, we have attended. That's all, my lord.
ಆ ಸೆರೆಮನಿಲಿ ಇಷ್ಟೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
Ceremony ನಲ್ಲಿ ನಾವೇನು ಮಾಡಿಲ್ಲ ಅದು, my lord,
All unceremonious things in the ceremony.
she has subsequently, she has filed a 125 proceedings as against my brother. Now, my lord,
We'll
she
close
makes
it.
no allegations in that, even against my brother.
Where is the charge sheet?
Lord, your lordship, I kindly find, Lord, charge sheet at page number 17, my lord.
498A will go. 324, grievous hurt.
342 also, my lord. Now unlawful confinement, there is nothing from our end.
ಅಲ್ಲ, ಇದು ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ?
Please.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಗಲಾಟೆ ಮಾಡಿ ಕಬ್ಬಿಣದ ರಾಡಿನಿಂದ 2 ಕಾಲಿಗಳಿಗೆ ಹೊಡೆದು ಸಾಮಾನ್ಯ ಸ್ವರೂಪದ ಗಾಯ. So, yes, the petitioners are accused number 2 and 3. Both sisters-in-law of the second respondent complainant. ಈಗ husband ಇಲ್ವಾ?
Husband illa, husband is not, he has not filed for.
He is accused number 1.
Accused number 1.
The petitioner, the accused number 1 and the second respondent complainant are husband and wife and are facing husband and wife. It transpires that on 6/1/2022, the second respondent's father-in-law died, and at the funeral, certain altercations happened between the petitioners and the complainant. It is alleged that after 3 days of the funeral, on 9/1/2022 at about 10:30 AM, the accused number 1 is said to have assaulted the complainant with an iron rod on her legs. So does the accused number 2 by a knife, causing bleeding injuries and pulling her hair. The accused number 3 is said to have assaulted the complainant, respondent number 2, by a broomstick all over the body. Based upon this, a complaint comes to be registered by the second respondent complainant on 23/1/2022 for the incidents that happened on 6/1/2022. The police conduct investigation and file a charge sheet against all the accused for
No, not against all the accused.
against accused 1 to 3, 2 of whom are the petitioners before this court. The charge sheet, while filing the charge sheet, the police drop offense punishable under 307 of the IPC and retain the other offenses. Filing of the charge sheet is what has driven these petitioners accused 2 and 3 to this court in the subject petition. Heard so and so. The learned heard so and so. Heard so and so. The learned counsel appearing for the petitioner would vehemently contend that there is no allegation that would touch upon the offenses either punishable under section 324, 498A or 342 of the IPC against these petitioners. At best, it was a wound that is caused, which is also depicted to be simple in nature. Therefore, he would seek quashment of the entire proceedings on the score that the petitioners accused 2 and 3 never stayed with the complainant or the couple and have nothing to do with the family. Per contra, the learned counsel appearing for the second respondent complainant would refute the submissions, contending that the police, after investigation, have filed a charge sheet. In the charge sheet, the allegations are clear that the second accused number 2 has, with a knife, tried to impute injury upon the feet of the complainant. And the third and accused number 3 has, by holding a broomstick, hit the complainant all over the body. He would seek to place some photographs on record. depicting the wound against the accused, against the complainant accused number 2. Therefore, it becomes necessary. The submissions align, no? I have given my so and so. The learned counsel submits that it's a matter of trial for the petitioners to come out clean. I have given my actions so and so. The aforenarrated facts are not in dispute. The relationship between the petitioners accused 2 and 3 and the complainant, being the sisters-in-law, is also not in dispute. The incident gets triggered on 6/1/2022 when the father-in-law of the complainant dies and the ceremonies were being attended to by the parties to the list. On 9/1/2022, the accused number 1 inflicts injuries upon the complainant by hitting her with iron rod. The accused number 2, the first petitioner, is also alleged of using a knife and causing bleeding injuries upon the complainant, and the accused number 3 causing injury throughout by hitting her with a broomstick. That this incident becomes a complaint. The complaint so registered against the petitioners reads as follows, page 15 and 16. The police, after investigation, have filed a charge sheet. The summary as obtaining in column number 17 of the charge sheet reads as follows. A perusal at the summary of the charge sheet would indicate horrendous offenses committed by the husband, accused number 1, while the offenses against accused number 2 and 3 are that they have assaulted the complainant. The accused number 3 is said to have assaulted with a knife which has caused bleeding injuries on the feet of the complainant. The wound certificate also depicts the same, but describes it to be simple in nature. For an offense under section 498A or 342 of the IPC, there is not even a speck of ingredient that is necessary for permitting further proceedings against these petitioners to continue. Therefore, the offense under 498A requires to be on the face of it, is on the face of it loosely laid against the petitioners. For the said reason, the offense under section 498A and 342 would stand quashed against these petitioners. The other offenses alleged are the ones punishable under section 323, 324, 504, and 506 of the IPC. Insofar as the first petitioner, accused number 2, is concerned, the allegation is that she has used a knife to cause bleeding injuries upon the complainant. Therefore, the offense under section 323, 324, 504, and 506 is sustained against accused number 2, the first petitioner. Insofar as the second petitioner is concerned, second petitioner hyphen accused number 3 is concerned, what is alleged is she has hit the complainant by a broomstick. This would not mean that usage of dangerous weapons for usage of dangerous weapon against the complainant, as a broomstick cannot be termed to be a dangerous weapon for it to become an offense under section 324 of the IPC. Therefore, insofar as the second petitioner, accused number 3, is concerned, section 324 also gets obliterated for the aforesaid reasons, the following order. The writ per criminal petition is allowed in part. Insofar as accused number 2 is concerned, the offense under section 323, 324, 504, 506 stands sustained. The offense under section 342 and 498A stands quashed. Insofar as the accused number 3 is concerned, the offense under section 323, 504, 506 stands sustained. The offense under section 324, 342, 498A and 3 and 4 of the DP Act stands quashed. Ordered accordingly.
ಅದರಲ್ಲೂ 3 and 4 of DP Act.
ಅದರಲ್ಲೂ first one, accused number 2, 3 and 4 of DP Act. IO ಇದೆಯಾ?
Petitioner, my lord, is accused number 9.
ಹಾ,
In Sessions case 961, 2022. But he is in custody from 31.
Accused number?
Accused number 9. my lord.
All right.
Because of this case, my lord, he has not been granted remission in other case. Lord, the case of prosecution, my lord,
ತಿಳಿ ಸರ್,
please,
ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ.
please. Sir. My lord, the case of prosecution, my lord, during the intervening night of 23/8/2021. Accused number 1, 4, 5 and 6 and others, my lord, kidnapped CW1 and CW2 who were traveling in the car. And my lord, they threatened him, they threatened CW1. And on their threat, my lord, an amount of rupees 10 lakhs was transferred to the account of accused number 10.
Yes, sir. Who appears to the complainant?
My lord, since he is abroad, notice has been dispensed to him.
Who is abroad? Complainant?
Complaint.
Yes, government. Counselor ಇದಾರೆ?
ಇಲ್ಲ ಯಾರಿಲ್ಲ.
ಇದಾರೆ. ಮೊಹಮ್ಮದ್ ಯಾರು ಹಾಕಿದಾರಲ್ಲ?
ಹೌದಾ?
ಆಯ್ತು. ವಕಾಲತ್ is filed, sir.
Please.
Mohammed Shaheen Hamza.
That's the name of the complaint, my lord.
Name of the complainant.
That's the name of the complaint.
For R2 ಅಂತ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes, mistake.
My lordship, he is accused number 9, my lordship, in the present complaint, and he was a convicted, life convicted prisoner, my lordship, in other cases.
All right.
And he has conspired, my lordship, according to his voluntary statement, my lordship.
Whose voluntary statement?
The present petitioner's one.
Voluntary statement.
Section 75 and
The charge sheet
section-
also allegation against him is there, my lordship.
I know that last time itself, page 26 I have marked, sir.
Yes. Lordship, may kindly see that.
No,
As far as section, two sections are invoked against me.
What are they?
One section 75. That does not, is not applicable to this case. Because section 75 of IPC speaks about enhanced sentence in case of if an accused is convicted previously for the offenses.
Charge frame ಆಗಿದೆಯಾ?
ಇಲ್ಲ. For the offenses punishable under section 12, for the offenses mentioned in chapter 12 and 17 of IPC.
Where are, ಯಾವುದು chapter 12 and?
Chapter
No,
12 and
364A ಇಲ್ವಾ ನಿಮ್ಮ ಮೇಲೆ?
ಇಲ್ಲ sir, ಇಲ್ಲ sir.
395 ಇಲ್ವಾ?
ಇಲ್ಲ, I was in custody. 395 is only against accused number 1, 4, 5, 6 and others.
Recovery is also there, my lordship.
From his hands?
Please.
But how to interfere now, sir?
No, your lordship may kindly consider this. Whether these sections can be invoked against me or not, that is a moot question in this case.
Sections ಯಾವ್ದಂದ್ರೆ 75.
25
ಆಮೇಲೆ?
IPC and section 201, my lord.
Destruction of evidence.
Causing disappearance of evidence, that is what this.
It's all right. Causing disappearance. of
Yes,
evidence.
but your lordship may kindly see, it is a case of prosecution. This accused number 1, 4, 5 and 6, of course, they kidnapped CW1 and CW2 in the car. And at his instance, my lord, at the instance of accused number 1, an amount of rupees 10 lakhs was transferred to the account of accused number 10. Accused number 10 is is the wife of accused number 3. And your lordship may kindly consider, according to them, out of that 10 lakh, from the account, the wife of the accused number 10 withdraws an amount of 10 lakhs. And an 8 lakh amount is given to someone else. And remaining 2 lakhs, my lord, your lordship may kindly see. Since I am an accused who comes out of the jail for doing agriculture work, that amount was given to me and I smuggled it inside the jail. That is the allegation against me. So
It's a matter of trials.
No, but your lordship may kindly consider, to attract section 201, I must know that it is the proceeds of from the commission of an offense. Your lordship may kindly see section 201. My
Disappearance
knowledge,
of evidence, yes.
pardon, my knowledge, my lord, that I knew that it is the amount of this proceeds of the dacoity. In this regard, my lord, I would like to draw your lordship's attention. The statement of accused number 3, my lord, only on the basis of statement of accused I have been implicated.
Where is that?
Yes, I have produced, my lord, Lordship may kindly see, page number 52, my lord, I have produced the pen.
No, isn't it corroborated because your recovery is made from you, so it is corroborated.
In the sense, my lord, Lordship may kindly see, to attract to not one, my lord, whether I had knowledge that it is a
No,
proceeds
no,
of a crime.
that's all right. If you say only on the basis of the statement, 25 is out, because of 25 you would
Yes,
be
my
out,
lord,
but
yes,
27,
yes.
corroboration.
Your Lordship may kindly see, the amount was handed over to me by accused number 10 and accused number 11. So if your Lordship kindly see that if we see that statement, they don't say that we have informed accused number 9 that this is the proceeds of a crime. They don't say, just they have handed over the amount.
Let's see.
And since last 15 years, my lord, your Lordship may kindly say, I am in the custody.
That for other reasons, sir.
Maybe, but
ಮತ್ತೆ ಇದ್ರಲ್ಲಿ ಅಲ್ವಾ?
because of this case, I still continue to be in custody.
No, ಅದ್ರಲ್ಲಿ remission consider ಮಾಡಿಲ್ವಾ ಈಗ?
Because of this case, they are not ready to consider me for release. That's why I filed
Also
a
difficult.
pardon. Because
482 ಅಲ್ಲಿ.
correct, but except the statements of accused persons, there is nothing.
No, if there was no recovery from your hands, I would have taken it straight away and
The recovery, my lord, according to them, my lord, the amount was kept outside the jail and
no,
they say
whatever. That is a matter of evidence. Recovery is from your hands, so it does not stop at voluntary
Lordship may
statement.
kindly see whether this amount of 2 lakhs can be considered as evidence is also very important.
No, that is evidence.
No, can it be considered as evidence? In the sense, my lord, your Lordship may kindly see that all transfers are taken electronically. All that evidence
You
is
don't know,
available.
definitely, why was money with you? How did you take it in? Why did you keep it? All a matter of trial.
Lordship may kindly see, because of this, my lord, I am again.
Maybe, but
Then
not
your
a case
Lordship may
where
kindly- your Lordship may
quashment can
kindly
happen.
Direct the trial court to finish off the matter in 6 months or
That I will do, no problem.
or 1 year or 6 months, my lord.
Yeah, but 20, ಯಾವಾಗಿನ crime ಇದು?
21 is. ಇವಾಗ ಇನ್ನೂ ಚಾರ್ಜ್ ಮಾಡಿಲ್ಲ ಸರ್. ಚಾರ್ಜ್ ಇಸ್ ನಾಟ್.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ, ಮತ್ತೆ ಟ್ರಯಲ್ ಕನ್ಕ್ಲೂಡ್ ಮಾಡೋಣ. Charge frame.
Trial commences with framing of charge.
Framing of charge, yes.
Yes.
Charge is not yet framed. HBC ಆಗಿದೆಯಾ? ಮತ್ತೆ ಏನೂ ಆಗಿದೆ.
ಇಲ್ಲ, ನಾವು ಯಾರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕಿಲ್ಲ. But ಏನೇ 1 year or 6 months or 1 year time.
Trial court will consider at time of filing the charges, my lordship, regarding the sections.
ಅಲ್ಲ, ಈಗ HBC ಟೈಮಲ್ಲಿ ಇವೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿ ಬಿಡಿ.
Pardon.
You submit everything that you are saying. Hearing before charge ಅಲ್ಲಿ.
That also I will.
That is always open to you. ಆಮೇಲೆ you approach, we'll see. That's better instead of 482 exercising jurisdiction. You
Yes, situation
submit
is very
everything at the stage of HBC.
very extraordinary because since last 15 years I'm in.
ಆಯ್ತು, ಅದನ್ನ ಮಾಡಿ ಎಲ್ಲ impress upon the court. If it doesn't, then you come.
Then some direction to finish off the matter, at least.
ಅಲ್ಲ, ಅದು HBC ಆಗಿ ಫ್ರೇಮ್ ಆಗ್ಲಿ, ಆಮೇಲೆ ಒಂದು ಹಾಕಿ
If you hear me and decide this my HBC.
That I will do,
within
yes.
2 months.
That I will do.
For
The
trial court, I will.
petitioner accused number 9 is before this court calling in question the entire proceedings, seeking quashment of the entire proceedings registered against him for in CC in SC so and so, registered for offences punishable under so and so. The learned counsel the learned counsel would submit the matter at length, but at this juncture would restrict his submission to a direction to the concerned court to consider all the aspects or the contentions that are advanced in the subject petition at the time of hearing before charge. The said submission would merit acceptance. Before the drawing up of charge, the process of hearing before charge, at the time of hearing before charge, the petitioner is at liberty to urge all the contentions that are now urged before this court, and the concerned court shall pass necessary orders in accordance with law, answering those contentions as urged by that would be urged by the petitioner. With the aforesaid observation, reserving liberty to the petitioner to avail of such remedy as is available in law, the petition stands disposed.
If I file an application for it, let it be disposed of in a month or 2 months.
ಅದು ಮಾಡಿ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ ತಕ್ಷಣ ಮಾಡಿ. ಯಾವ ಇದ್ರಲ್ಲ,
For hearing before charge.
the concerned court shall pass necessary orders as observed herein above within 2 months, within 8 weeks from the date on which the petitioner would. Application ಏನ್ ಹಾಕ್ತೀರಾ?
Application.
Would 8 weeks from the date on which the hearing before charge would commence. ಅಷ್ಟು ಸಾಕು. ಏನು application? Next.
Great.
92 at 93.
Petitions. My lord. In this case, the petitioner won not in station on 26/1/2021. Page number, complaint, page number 55. 55.
4 ದಿನ ಡಿಲೇನಾ? 4 ದಿನ ಡಿಲೇಗೆ ಏನ್ ಸಂಬಂಧ?
Offenses 506, 504, 523.
523.
ಇಬ್ಬರು ಪಿಟಿಷನರ್ಸ್ ಒರಿಜಿನಲ್ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಇವರು CW2 ಮೇಲೆ.
ಆಯ್ತು.
ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ. ಆ ಪೆಂಡಿಂಗ್ ಇರೋ ಟೈಮ್ ನಲ್ಲಿ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಅಂತ ಹೇಳಿ ಇವ್ರ ಕೈನಲ್ಲಿ ಫಾಲ್ಸ್ ಅಫಿಡವಿಟ್ ಫಾಲ್ಸ್ ಹಾಕಿದ್ದಾರೆ. ಅವತ್ತು ಒಬ್ಬರು ಪಿಟಿಷನರ್ ಬೆಲ್ಲೂರ್ಗೆ ಹೋಗಿದ್ದಾರೆ. ಅವ್ರು ಟೆಂಪೋ ಟ್ರಾವೆಲ್ ಓನರ್ ಡ್ರೈವರು ಅವರು ಬೇರೆ ಅವ್ರು ಕರ್ಕೊಂಡು ಹೋಗಿ ಎಲ್ಲಿದೆ ಅದು ಮೆಟೀರಿಯಲ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. ಆಮೇಲೆ ಇನ್ನೊಬ್ಬ
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ. ಎಸ್ ಸರ್.
They are telling that they are not present at this spot. And what is that is a matter of trial, my lord, whether they are present or not. It has to be decided in the trial. They produced the RC book copy. RC book ಇದಕ್ಕೂಳೆ ಇವರು ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಆಗತ್ತಾ? ಬಂದು ನನ್ನ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ನ ಹೊಡೆದಿದ್ದಾರೆ, ಬೈದಿದ್ದಾರೆ,
ಬೈದಿದ್ದಾರೆ,
ಹೆದರ್ಸಿದ್ದಾರೆ.
P 23, 504, 506 ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ರಿ.
ಇಟ್ಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್. ನಾನು ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ನಾನು ಶಾಪಿಂಗ್ ಮಾಲ್ ಒಳಗಿದ್ದೆ ಅಂತ ಒಬ್ರು, ಇನ್ನೊಬ್ರು ವೆಲ್ಲೂರೊಳಗಿದ್ದೆ ಅಂತ. ಅದಕ್ಕೆ ಏನ್ ಪ್ರೂಫ್ ಏನಿಲ್ಲ.
ಮೆಟೀರಿಯಲ್ ಎರಡಕ್ಕೂ ಹಾಕಿದ್ರೆ ಒಂದು ಥರ್ಡ್ ಪಾರ್ಟಿ ಅಫಿಡವಿಟ್ ಅವ್ರು ಕರ್ಕೊಂಡು ಹೋಗಿರೋದನ್ನು ಕೋರ್ಟ್ಗೆ ಹಾಕಿದ್ದೀನಿ.
ಎಲ್ಲರೂ
ಥರ್ಡ್ ಪಾರ್ಟಿ ಅವ್ರು ಕರ್ಕೊಂಡು ಹೋಗಿರೋರು ಅವತ್ತು ಅದು ಕೂಡ ಅಫಿಡವಿಟ್ ಕೊಟ್ಟಿದೆ. ಅವತ್ತು ಅವ್ರು ಇರ್ಲೇ ಇಲ್ಲ, ಅವತ್ತು ಆ ಸ್ಪಾಟ್ ಅಲ್ಲೂ ಇರ್ಲಿಲ್ಲ, ಏನು ಮಾಡ್ಲಿಲ್ಲ. ಇವತ್ತುವರೆಗೂ ಅವ್ರು ನೋಡ್ಲೇ ಇಲ್ಲ.
ಯಾರು ನೋಡ್ಲಿಲ್ಲ? ಆ
ಕಂಪ್ಲೇಂಟ್ CW1
they have filed
ಒರಿಜಿನಲ್ ಸೂಟ್ಸ್
ಸ್ವಲ್ಪ
ಒರಿಜಿನಲ್ ಸೂಟ್ಸ್ ಪೆಂಡಿಂಗ್ ಇರೋದ್ರಿಂದ ಇವರು ಪಿಟಿಷನ್ 1 and 2 ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ CW2 ಮೇಲೆ. ಅದು ಪೋರ್ಟಲ್ ನಂಬರ್ 13 ನಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ. ಅದು ಮನಸ್ಸಲ್ಲಿ ಇಟ್ಕೊಂಡು CW2 ಇನ್ಸ್ಟಿಗೇಟೆಡ್ CW1 ಟು ಗಿವ್ ಅ ಕಂಪ್ಲೇಂಟ್. ಆ ಬೇಸ್
ಯಾವ ಪೆಂಡೆನ್ಸಿನೂ ಲೈಸೆನ್ಸ್ ಅಲ್ಲ ಅಸಾಲ್ಟ್ ಮಾಡಕ್ಕೆ. ನಥಿಂಗ್ ಇಸ್ ಎನ್ ಲೈಸೆನ್ಸ್ ಟು ಅಸಾಲ್ಟ್.
It is a false complaint. I have produced material.
All complaints are false according to accused.
My lord.
Yes.
Annexure.
Yes sir.
Annexure H. ಅಲ್ಲಿ ಹೊಸೂರಿನಲ್ಲಿ ಅವರು RTO ಆಫೀಸ್ ನಲ್ಲಿ ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದಾರೆ ಫಸ್ಟ್ ಪಿಟಿಷನರ್.
ಲಿಸ್ಟ್ ಪರವಾಗಿಲ್ಲ.
ಅವು ಇದು ಟೆಂಪರರಿ ಪರ್ಮಿಟ್ ತಗೊಂಡಿದ್ದಾರೆ, ವೆಲ್ಲೂರ್ಗೆ ಹೋಗಿದ್ದಾರೆ.
ಯಾವ್ದು ಮೂವಿಲ್ ನೋಡ್ದಂಗಿದೆಯಲ್ಲ ಇದೆಲ್ಲ. ನೀವು ಆಮೇಲೆ ಹೋಗಿ ಟಿಕೆಟ್ ತಗೊಂಡಿರೋದು ಅಲ್ಲಿ ಸತ್ಸಂಗ್ ಅಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ದು
ಇದರಲ್ಲಿ
ದೃಶ್ಯಂ 1 2
ಆಮೇಲೆ ಇದು ನಾನು ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿರೋ ಬಿಲ್ಲು ಡೇಟು ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ನಿಮ್ಮ ಮೂವಿ ನೋಡೇನೋ ಮಾಡಿದೀರಾ ಇಲ್ಲಿ?
ಇಲ್ಲ ಸರ್, ಇದು RTO ಕೊಟ್ಟಿರೋ RTO ಪೇಜ್ ನಂಬರ್ 89 ನೋಡಿ ಸರ್. RTO ಕೊಟ್ಟಿರೋದು ಇದು.
ಆಯ್ತು. ಎಸ್,
ಅದೇ ಡೇಟ್ ನಲ್ಲಿ ಕೊಟ್ಟಿರೋದು 26/1/2020 11 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಪ್ಪ ಟೆಂಪರರಿ ಪರ್ಮಿಟ್. ಈ ಅವತ್ತು ಅವ್ರು ಊರ್ನಲ್ಲೇ ಇಲ್ಲ, ಇವರು ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್
ಎವಿಡೆನ್ಸ್ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್. ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಂಡ್ಬಿಡಿ.
ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಡಿಸ್ಚಾರ್ಜ್
ರಿಜೆಕ್ಟ್ ಆಗೋಗಿದ್ಯಾ?
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಕ್ಕೆ ಇಲ್ಲಿಗೆ ಬಂದೆ ನಾನು.
ಈಗ ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಲ್ಲೇ.
ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು ಅದಕ್ಕೆ ನಾನು ಇಲ್ಲಿ ಬಂದಿದ್ದೆ.
And delay only of 4 days. It is not fatal at all.
4 days ಇದೆ.
Interim coordinate bench has granted an interim order on the ground that there is delay unexplained for 4 days. 26th incident, 30th reporting. That is not fatal at all. And whatever plea you are taking, everything should be before the court. You take all the pleas there. Yes, anything else, sir? ನನ್ ನೋಡಿದ್ರಾಗಲ್ಲ ಹೇಳ್ಬಲ್ಲ.
ಪಾರ್ಟಿ ಒರಿಜಿನಲ್ ಸೂಟ್ಸ್ ನಾನು ಹಾಕಿದ್ದೀನಿ.
ಅದು ತೊಂದರೆ ಇಲ್ಲ.
ಒರಿಜಿನಲ್ ಸೂಟ್ಸ್ ಪೆಂಡಿಂಗ್ ಇರೋದನ್ನ CW2 ಇನ್ಸ್ಟಿಗೇಟೆಡ್ CW1 ಕಂಪ್ಲೇಂಟ್
ನೀವು ಈಗ ರೀಪ್ಲೈ ಮಾಡ್ತಾ ಇದ್ದೀರಾ.
ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಅದೇ ಇದೆ. CW1 ಹೇಳಿ
you want to sit and settle with him, settle.
ಅಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದಕ್ಕೆ ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
ಪರವಾಗಿಲ್ಲ. ಸೊ you want to sit and settle, I'll give an opportunity. ನಿಮ್ಗ ಜೊತೆ ಅಲ್ಲ ಸರ್, ಕಂಪ್ಲೇಂಟ್ ಜೊತೆ.
ಅದೇ 100%.
ನಿಮ್ ಜೊತೆ settlement. Yes. I'll post it next week, we'll dictate.
ಇಲ್ಲ ಸರ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗೋದಿಲ್ಲ ಯಾಕಂದ್ರೆ ಸಿವಿಲ್ ಕೋರ್ಟ್
Settlement ಅಲ್ವೇ ಅಲ್ಲ. List the matter on Friday. Yes, and the fresh matters.
one submission ಮೇಲೆ
We'll dismiss it on that day.
one submission ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಒಳಗೆ ಇಂಜೆಕ್ಷನ್ ಆರ್ಡರ್ ಸಿಕ್ತು ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ವೆಕೇಟ್ ಮಾಡ್ತು ಆಮೇಲೆ ಹೈಕೋರ್ಟ್ ಅದು ಅಪೆಲ್ಡ್ ಆಯ್ತು ದಟ್ಸ್ ಒನ್
ಅಂದ್ರೆ
ನಾನು ಕನ್ವರ್ಟ್ ಮಾಡಿದೀನಿ ಬೇರಿಂಗ್ ನಿಮಿಷನ್ ಸೂಟ್ ಇತ್ತು ಡಿಕ್ಲರೇಷನ್ ಕ್ಯಾನ್ಸಲೇಷನ್
Friday will dictate.
ಅದು ಅಮೆಂಡ್ ಆಗಿ
ಪರವಾಗಿಲ್ಲ.
ಪೆಂಡಿಂಗ್
Friday. Yes, 3:30 ಮಟ್ಟ ತೊಗೊಳ್ಳಿ.
Admission at 3:30 PM. 178.
I'm respondent to.
Come a little this side, sir. Ah, yes. Sorry. Yes, sir.
Complaint is filed by the second respondent.
Enter ಮಾಡಿದ್ಯಾ? ಏನಿಲ್ಲ ಅಲ್ವಾ? Yes. What's the offense?
Offense under for section 420, my lord.
Huh.
The allegation is that amounts of money was given by the second respondent to the developer, my lord. Developer and me, I'm the landowner.
Tripartite agreement ilva?
Illa, sir.
Who are you?
I'm the landowner, my lord.
All right.
Into a JDA, the developer, for putting up certain construction. Lord, he stops midway, my lord, and he's absconding. Lord, I initiate arbitration proceedings against him. CMP is pending before this honorable court. Lord, he approaches, he's one of the buyers.
Home buyer.
Home buyer from the developer share. Not even my share, I produced a sharing agreement. He doesn't, all his allegations, the complaint are that he has paid the developer money in Dubai. And the developer had promised him that he will give him a constructed apartment in 2016. And he has failed to do so. The only reference to me is that I'm the GPA holder, my lord, and the landowner. I'm the, I've given a GPA to the developer.
Charge sheet ಹಾಕಿದಾರಾ?
ಇಲ್ಲ sir, ಇನ್ನೂ ಆಗಿಲ್ಲ. Then
ಯಾವಾಗ ಕ್ರೈಮ್ ಇದು?
he is, Lord, in 2023, my lord.
Yes, why charge sheet ಹಾಕಿಲ್ವಾ ಇನ್ನು? 15/12/23 was too early for a charge sheet.
420. Lord, the second respondent, he's also initiated RERA proceedings against the developer. And he himself has stated in his complaint that he has procured an order against the developer. Lord, for recovery of 60.
Yes, sir.
I will speak. Page number 47 of the.
Where is your complaint?
I have asked for.
Where is your complaint? Which page?
I have submitted a summary of memo.
First tell me which page is your complaint. You have registered a complaint?
ಹೌದು.
ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಈ ಮೆಮೋದ ಫ್ರಂಟ್ ಪೇಜ್ ಅಲ್ಲೇ ಇದೆ.
ಮೆಮೋ ಫ್ರಂಟ್ ಪೇಜ್. ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಗೊತ್ತಿಲ್ವಾ?
ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಅವ್ರು ಹಾಕಿದ್ದಲ್ಲ.
ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ವಾ ಕಾಪಿ?
ನನಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಏನಿದೆ?
ಹೇಳ್ತೇನೆ.
ಹೇಳಿ.
ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 47 ನಲ್ಲಿ 47 ನಲ್ಲಿ they have authorized the developer to collect money from the apartment buyers. Page number 47.
Transfer of developer share.
ಮತ್ತು ಅದರಲ್ಲಿ 62% ಅಲ್ಲಿ they cannot define where is their 38%. If they can define 38%, I will take my share from 62%. Can they define? No. Plus they are increasing by 10 apartments. So my undivided share of land gets reduced.
How does it amount to 420? You tell me.
Because the developer has collected money on instruction.
From whom?
On instruction by the landlord from me, and he has.
Go against the developer.
Sorry?
Go against the developer.
I have gone against developer and his brother plus trespasser. RERA included landlord's name because the contract mentions contract between the developer and landlord between us. I will show the page number of the contract. Oh, just give me. Okay, page number 1 of 28. The contract signed between us and the developer, it says Anita Reddy, Pallavi Reddy, Yashwardhan Reddy are a part of it, plus he is the general power of attorney on their behalf. Page
Yes.
number 1 of.
How
20
much money have you paid to the developer?
About 34 lakhs in 2015, March, liquidating our FD from State Bank. And according to
What is the
RERA,
proceeding that you've initiated against the developer?
I have proceeded. and,
Which case?
I will tell. The judgment copy is given. First day of December 2023, complaint 239/2023.
What has happened to that complaint?
The RERA has.
Not RERA, you have not registered a crime against the developer?
I have in 420, sorry, on 15,
Criminal complaint register
15,
ಮಾಡಿಲ್ಲ ಅವ್ರ ಮೇಲೆ?
15/12/23, I have
ಅದ್ರಲ್ಲಿ ಅವ್ರು
registered
accused ಆ?
complaint against developer and landlord
Okay, okay.
as per the judgment made by RERA.
Where is the judgment made by RERA?
Here it is. I have given the copy to you.
Page,
Can you, madam?
page, ಇಲ್ಲಿದ್ರೆ page ಅಲ್ಲಿ ಹೇಳಿ.
ಅದರಲ್ಲಿ ಮೆಮೋದಲ್ಲಿ it is, ಹೇಳ್ತೇನೆ.
Where is the order of RERA?
But he has produced a memo, my lord, for this honorable. court.
ಅದರಲ್ಲಿ ಮೆಮೋದಲ್ಲಿ ಇದೆ, I will tell you.
Not
It is,
given any page number, my lord, I'll.
my lord, 1st of December judgment was made.
Where is the judgment?
ಅದು ಮೆಮೋದಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಸ್ವಲ್ಪ ಕೊಟ್ಟಿದ್ದೇನೆ, ನಿಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಹಾ,
May I pass on?
Wait, ಇಲ್ಲಿ ಹಾಕಿಲ್ವಾ?
ಅದರಲ್ಲಿದೆ.
Our memo ಇದೆ, but he is not page numbered it, my lord.
Which memo?
ನಿಮ್ದ್ರಲ್ಲಿ ಉಂಟಲ್ಲ. I will just search.
What has RERA directed?
But they directed the developer to pay along with the landowners. no?
ನೀವು ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳಿ.
Sum of 60 lakhs is directed to be paid to
To
the,
whom?
to the complainant.
By RERA.
Please.
What has happened to that order?
Lord, he has not sought to enforce that order, it appears. Lord, I had no notice of this as well.
Can I mention one thing?
Have you sought enforcement of that order, 60 ಲಕ್ಷ?
I will give the reason for it. RERA is not a court. As per the contract, I have to approach the court and there is no.
You know, orders of RERA can be executed by method in law?
Yeah, but the thing is, it doesn't include my liquidated damages and legal.
We'll see later. ಅದಕ್ಕೆ crime is not the remedy.
No, okay. I am ready to sit with them and reach a resolution if they are all.
Do that. If you
6
want, you
people.
can do that.
Yeah, within a week, I can sit with them, all 6 people.
If you want to
and-
settle it with
And
him.
he's not absconding. He's here. I met him 3 times in Lulu High Market in last April, May, June. I offered him a resolution to settle with 65 lakhs. He didn't agree. What
Alright.
can I
You
do?
want to settle it.
I don't
Or will
mind.
pass. Will you keep quiet?
Yeah.
Yes. You
We'll
settle
try.
it. If,
But of course, from our end, my lord, we are
whatever,
not.
both of you sit and resolve. If the dispute is resolvable,
Very well.
I'm
Sir.
available within 10 days.
wait, sir.
Okay.
Yes.
Lordships could consider the interim order. my lord.
Yes, till the resolution don't prescribe. What is happening now?
Lord, what has happened is we have sought for modification of the plan sanction.
Which
Lord,
plan sanction?
The original plan sanction that was granted.
ಇವ್ರಿಗೇನ್ ಮನೆ ಕೊಡಲ್ವಾ?
We are willing to give, Lord, in fact, it's in our interest also that the entire project completes.
then
So
what?
additional
Sir,
10
sir.
apartments, Lord, were.
You want the house or money?
I will tell you, I want money as per RERA regulation because they have delayed more than 7 years.
Right, you fight that before RERA, not a crime for that.
I know. And they have diluted
Wait,
the
sir.
specification.
Also
You
residing.
sit and settle. If it is not settleable, we will handle it. Yes.
Yeah, I'm ready to settle.
I asked you to keep quiet.
Okay.
Yes.
Very well. We'll try.
Yes. The parties to the list. The the respondent in person would offer that if the time is granted, resolution of the list can happen and he is ready and willing to settle the dispute with the petitioners. Therefore, the parties to the list to explore the possibilities of a settlement. List the matter on 19th. List the matter on 19th. Settlement, if any, be reported by then. Yes.
19th, I'm back. Yeah.
No, till then, my lord.
Till then, don't, till the talks of settlement and to ease the talks of settlement, further proceedings shall remain stayed. In the event the settlement does not arrive at, the matter would be answered on its merit.
Okay, thank you.
Okay.
19th Varegal.
Yes.
Great.
One 79.
I am representing the third opponent.
179. Lordships have. There are two petitions, my lord. One is by Right Health Platter, a company, and the other one is by an individual called Dinesh Dalmia.
Senior is appearing for this. You are appearing. Yeah.
Third respondent.
For the third respondent.
Yes, ma'am. We are the informant to the police.
Yes, yes. So I saw the names here. Yes, yes, sir.
But a civil dispute has been given a criminal color.
Civil dispute?
Completely civil dispute. At best, it can be a claim, my lord, which can be made. First, and secondly, the entire transaction, even according to them, has happened in Singapore.
Singapore?
In Singapore. Nothing in Bangalore. No part of anything that has happened in Bangalore. The entire allegations, my lord, are that there are three entities. Can I request, my lord, to kindly come to page 43? 43. Complaint, my lord, is dated 13 September 23. This is a company called Zetwork.
Zetwork.
Zetwork, my lord, who seems to have made it a habit to file complaints against everybody. And there are a large number of complaints filed with them. And anything that happens is given a criminal color and only in Bangalore. But nothing happened in Bangalore and none of the entities are really in Bangalore. Now the complaint is filed by someone called Zetwork Manufacturing Business Private Limited, which is supposed to be in Bangalore, but which was not part of the transaction, Lord, which occurred in Singapore. Would your Lordship now see page 43? The entire story, my lord, is that Avamore, a company, which is an Avamore PTE Limited in Singapore, raises a purchase order with 90 days payment terms on Zetwork. Now, my lord, I would have thought Zetwork is Zetwork India, but it's not Zetwork India. It is Zetwork Singapore. Zetwork Singapore in turn places an order on a company called Right Health Platter. Right Health Platter, my lord, supplies all its goods directly to Avamore, Singapore. Now, the allegation is Avamore is not paid Zetwork.
You are no way concerned?
I am not in this part of this transaction. Now, see, they say it's all part of a collusion. But in terms of the transaction as explained by them, Avamore, my lord, raises a purchase order with a 90-day credit period on Zetwork. Zetwork is supposed to actually supply goods to Avamore for that and receive money. Zetwork in turn places an order, my lord, on Right Health Platter. And Right Health Platter, my lord, supplies the goods directly on account of Zetwork. Now, this is the transaction even according to them. Now, my lord, they say that they received some amount of the money, about 16 million they've received, and 4 million is left. Now, this is the claim. Now, that is given a criminal color. And this has been filed. And when I ask myself, nothing happens in Bangalore. How is it that they come to court? How is it, my lord, that they come to Bangalore to file merely because some other group concern called Zetwork Manufacturing Business Private Limited, on whose letterhead this FIR is lodged, is in Bangalore. And Right Health Platter, my lord, is in Chennai.
So nothing in Bangalore?
Nothing in Bangalore. Nothing at all in Bangalore.
So that would be the threshold bar.
That's the first submission I'm making. The second, of course, my lord, is, and Lordship may kindly see page 35, how they bring it in within jurisdiction. Your Lordship has not criminal petition.
4022.
4022. Page 35. Please see, my lord, the accused, Right Health Platter is in Chennai. Sorry.
40, page 35.
35, 4012. That's the FIR. Adರಲ್ಲಿ, column 6.
Tamil Nadu.
Tamil Nadu.
Evermore Private Limited.
Singapore, Bangalore City. And
Singapore,
Bangalore City.
Oh, Singapore, Bangalore.
So Evermore Private Limited is
Singapore,
Singapore, Bangalore
Singapore
City.
ಯಾವ್ದಿದೆ?
ಅಲ್ಲ ಇಲ್ಲ ಅಲ್ಲಿದೆ. ಅದು actually it's not private limited, it's PTE. Evermore PTE Limited.
Oh, PTE.
Then Gopal Padia, Singapore, Bangalore City. Then Ramnath Arumugam, Chennai, Bangalore City. It's both, my lord. Where and then Yekulu Venkata Subbaya, Murli Babu and others, Chennai, Bangalore City. And this is how, my lord, jurisdiction comes to Bangalore.
Yes. On the merit?
On merits, my lord, this is my submission. This is an entirely civil dispute. And
Complaint is at page 45?
yes,
45 or 40?
44, please.
44.
44. That's what I was. This is the transaction I'm showing you, lordship, at page 46. They've put a diagrammatic representation.
Oh, purchase.
Transaction started in this
back
manner.
PO, right health platter supplier.
Goods directly to Evermore end customer in Dubai. Then, Lord, please see the next line. 12th January 22 to 1st January 23. Total purchase orders worth USD so and so was placed by Evermore on Zwork. Zwork in turn placed back-to-back purchase order on Right Health Platter. Payments were made to Right Health Platter by Zwork on an immediate payment term basis, but payments stopped coming from Evermore for shipments that took place in February 2023 onwards. In April 23, when Zwork realized that payments were not being made, it stopped placing purchase orders on Right Health Platter. In total, invoice of 16 million was raised by Zwork, and an amount of 4.7 million has been misappropriated through collusion between Evermore and Right Health Platter.
Yes. Ashana?
Then, Lord, they have said something about discounting, but that is HDFC should have complained about it. That there is no complaint. And, Lord, on this bill discounting, there are other emails I've placed before your lordship where they themselves say it has to be discounted.
Which are those?
Lord, I've filed a set of documents before your lordships at page 33. How you give a
What
copy to them?
documents, sir?
Give them a copy.
Page 33.
33.
Oh, yes.
This is, my lord, an email from HDFC Bank. Piyush Goyal on top, my lordship sees that. He writes an email to HDFC Bank saying, "Hi Nikita, please consider the same." The email is, "Kindly confirm on payment terms agreed by Right Health Platter as per agreement submitted. Payment terms are mentioned at 60 days. As per announced, payment terms are mentioned at 90 days. Kindly provide clarity of the confirmed and approved tenure of days."
Yes.
And in this complaint, they say they have no knowledge about all these things.
Yes, sir. Yes, sir.
May I make my submissions, my lord?
Yes, sir.
My lord,
I'll get back to you if there is anything.
Yes, yes.
my lord,
Yes, sir.
the offences that are compliant against these accused persons are under 120 capital A, 409, 417, 418, 420, 465, and 468.
Yes.
My lord, since the amount that is involved in the crime runs to hundreds of crores, my lord, after the registration of the crime at the HSR police station, Bengaluru, my lord, the Director General of Police would transfer the investigation of the case to the premier investigating agency of the state, that is the CID Bengaluru.
CID.
CID.
Yes.
Now CID is investigating the case. CID has also been made a party to the proceedings. My lord, the petitioners before your lordship, I would respectfully submit, my lord, are international fraudsters.
International fraudsters.
Yes, my lord. Yes, my lord. Yes, my lord.
Yes, sir.
My lord, I have placed for my lord's kind consideration a couple of orders and the couple of cases that are registered against them in different parts of the country.
Page.
Well, may I just request your lordship to kindly turn to the compilation of the cases which I have filed on the previous date of hearing.
There is a separate memo that was given Last time, please.
ಅಲ್ಲ ಒಂದು ವೆಕೇಟಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡೋರ್ ಅಂತ
ಇಲ್ಲ
ಹಾಕಿದ್ದೀರಲ್ಲ
ಇಲ್ಲ sir.
ಕೊಡಿ.
Well, this is what the crime branch of Tamil Nadu police would do it. In page 1,
Yes, sir.
this was in 6/4/2024, wherein the reference has been made to my establishment and the offense which they have committed as against my establishment.
Yes.
My lord, may I just request your lordship to kindly turn to ink page 6, that is sufficient for the purpose. It's only for reference, my lord, although this may not have any bearing as far as the present case is concerned.
Yes.
Just inviting your lordship's kind attention, what is the modus operandi of these people, how they do it. Kindly go to ink page 6 at the top.
I'm there.
Yes, my lord. The totaling USD, my lord, 44,58,682, INR 3.75 crores. The payment was made to Grav Trading Private Limited, which is one of the Gopal Padia's owned entities. Well, he is one of the accused, as a TWDS commission. Thus, in the above circumstances, it is transparent and clear that Mr. Dinesh Dalmia, he is one of the petition before your lordship in the other connected petition, and who is the principal accused in the case, who is a habitual offender. Mr. Gopal Padia, Mr. Ramanath Armugam, Mr. Pankaj Dalmia, and Yekulu Venkat Subbaya Murali, he is also an accused in the case, and other officials had conspired along with other directors with the intention of cheating, had deliberated a fund deal with Bureau Capital to cheaters and amass undue money, and had delivered the money to foreign accounts and with the intention to cheat us thus. I plead with you to kindly take immediate and appropriate action against Mr. Dinesh Dalmia, Gopal Padia, Ramanath Armugam, Pankaj Dalmia, Yekulu Venkata Subbaya Murali Baba, all these are the accused in this case also, and other officials for cheating, criminal breach of trust, criminal conspiracy, forgery, who had cheated us. Yours sincerely for so and so, and the crime came to be registered against them.
Yes.
But a reference also is made to me, which your lordship would get in page 5. Well, that is of no consequence. Well, what the SEBI also does, may I just request your lordship to kindly turn to page 7. Well, the order which came to be passed by SEBI, well, the operative portion of the order which your lordship would get. Well, may I request your lordship to kindly turn to ink page 26. Order. Para 4.0. Ink page 26. This is the order which came to be passed by the SEBI on 9th of September 2004.
That is said by SAT.
In the light of the above, I find that DSQ Software Limited and Shri Dinesh Dalmia have added to the detriment of the investors in the securities market, and that their actions have adversely affected the credibility and the integrity of the securities market. They have also perpetrated a fraud on investors and the securities market. I further find that Dinesh Dalmia is not a fit and proper person to be allowed to access to and be associated with the securities market and deal in securities. Therefore, it is necessary in the interest of investors in the securities market that directed under section 11 and 11B of the SEBI Act, read with regulation 11 of the SEBI, prohibition of fraudulent and unfair trade practices relating to securities market regulation 2003 are issued to DSQ Software Limited and Shri Dinesh Dalmia. Ultimately, the SEBI would pass an order. Now, the US court would also find him guilty of fraud. Well, an order also came to be passed by the US court.
Wait, yes, I'll get back to you. Yes, sir.
Indictment, not a.
Yes, it is a complaint. Well, in the US court, well, what they would say is he is guilty of the offense that is complained, and ultimately they would pass a judgment. I shall take your lordship. It is not an indictment. Kindly turn to page 29.
Yes.
Well, what the US court would say is, may I request your lordship to kindly go to the operative portion that is sufficient at page 58. Dinesh Dalmia. Well, he uses more than one name. At one stage, at one place, he would use his name as Nick Mittal. At another place, he would use it as Dinesh Kumar. At another place, he would use his name as Dinesh Dalmia. Well, may I just request your lordship to kindly go to page 56, that is sufficient for the time being. But these are only to demonstrate that these are all international fraudsters. That is all, excepting that nothing else. Kindly go to page 56. The grand jury re-alleges and incorporates by reference the allegations contained in this indictment for the purpose of noticing forfeiture pursuant to Title 18 of the United States Code, Section 982. Upon conviction, my lord may kindly see, upon conviction of one or more of the offences alleged in the count 1 through count 5 to this indictment, defendant Dinesh Dalmia and the defendant Ashish Paul shall forfeit to the United States pursuant to Section 18 U.S.C. and 982, etc., all property, real and personal, constituting or derived from proceeds obtained as a result of such offences, including but not limited to the following. It is not a case of indictment. It is a case of he being found guilty of the offences which he has committed, and ultimately the U.S. court finding. Now, my lord, the basic question which my lord in front has raised is with regard to the jurisdiction of the Bangalore City Police in registering the crime and taking up the investigation. Probably that seems to be the only ground. But may I just request your lordship to kindly turn to section 177 of the CRPC for a second.
177.
Yes.
177. Every offense, my lord gets it?
177.
177. 177.
Yes, sir. I am there.
Yes, ma'am. Every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. 178. When it is uncertain in which of several local areas an offense was committed, or where an offense is committed partly in one local area and partly in another, or where an offense is continuing one and continues to be committed in more local areas than one, or where it consists of several acts done in different local areas, it may be inquired into or tried by a court having jurisdiction over any of such local areas. Now, my lord, I have got to point out to your lordship whether any offense as such, a part of the offense as such has been committed in Bangalore or not, probably is the basic or the primary question which my lord in front has raised. But may I just request your lordship, but the modus operandi of these persons on the merits of the matter, only one sentence for the purpose of jurisdiction. Otherwise, no. But there are three institutions or three organizations. The first is RHP. That is the first accused in the case. The second is Arimore. That is the second. The third is the informant Zetwork. But this RHP is into the business of supply of agricultural products. But this Arimore is none other than the sister concern of the RHP. The directors of RHP are the directors of Arimore. The shareholders of Arimore are the shareholders of RHP. But what this Arimore does, they would place an order upon me for supply of agricultural products that is being manufactured by RHP instead of they buying directly from RHP. They don't buy from RHP. That is their concern only. Common directors, common shareholders, sister concern. Well, I would place an order upon RHP, believing in the representations which came to be made by the Arimore, in particular by this Dalmia, Dinesh Dalmia. I shall take your lordship to that particular paragraph where the offense took place. But I will place the order. They would make a pretense of making the payments to me. Subsequently, since they did not choose to make the payments, I would stop making purchases from them. The matter ends there as far as I am concerned. But what they do is they would prepare false invoices, false delivery notes, and then make it appear as if they have made the supplies to me and discount those invoices with more than one bank. They being HDFC Bank, Axis Bank, and then Fincare Small Finance Bank, Indusland Bank, which the details of which my lord gets it at page 48, all these banking institutions. Well, the banker would subsequently put forward a claim upon me saying, look here, supplies are made by this RHP to you, you please pay us the money. All these are fraud. Well, it is a fraud, a false and a fabricated document. But now, my lord, what I need to bring it to your lordship's notice is, as far as the Bangalore police is concerned, what is the cause of action? That's all, accepting that nothing else at this point of time. My lord, having invited my lord's kind attention to 177 and 178, even if a part of cause of action has taken place in Bangalore. My lord, Z-Work is my sister concern. Singapore Z-Work, Z-Work India. May I request your lordship to kindly turn to page 2, para 2 of my complaint, which my lord gets at page 45.
Yes.
In the month
Yes.
of I'm sorry, my lord
Yes,
gets
sir.
it. In
Yes,
the month
nothing.
of January 2022, Z-Work India was approached by Mr. Dinesh Kumar. Dinesh, who represented himself as a top management and founder of Messrs. Right Health Platter Private Limited, a company having its office at number so and so, Radhakrishna Salai, 3rd floor, that is in Chennai. He would come to me in Bangalore. He would approach me. Well, that is the inducement. Your lordship would get that under 415. Where the induce, well, the basic ingredient is inducement to constitute an offense of cheating. 3rd floor. Northeast Mylapore, Chennai, Tamil Nadu. Mr. Dinesh presented certain documents to Z-Work India representing and representatives demonstrating his authorized role as the representative of RHP. These documents confirmed his directorship at RHP, providing evidence of his ability to effectively represent and make decisions on behalf of the company. Mr. Dinesh portrayed RHP in an appealing manner, showcasing it as a strong food technology company driven by research and development. He had represented that RHP had orders worth millions of dollars in the pipeline. Mr. Dinesh deceitfully induced Z-Work India. Kindly note this, my lord. Dinesh deceitfully induced Z-Work India and urged for both support and invest in his business scheme. Dinesh presented an appealing proposition to Z-Work India, suggesting that they provide their services to RHP's operation by procuring raw materials from dairy plants, which would be utilized by RHP to craft their final products. Furthermore, Mr. Dinesh, via email, had proposed Z-Work India to be a partner in this project and the procurement of new equipment for the newly established facilities to achieve their goals. Mr. Dinesh estimated the total transaction cost at approximately $25 million. But the inducement starts at Bangalore, Z-Work India. But may I just request your lordship to kindly have a look at section 415, how cheating has been defined.
Yes.
Just to refresh my lord's memory, day in and day out, your lordship would be
Yes, yes.
coming across what is inducement and all that.
Yes.
But cheating, one of the offense that is alleged is the one that is made penal under section 420. Whoever by deceiving any person fraudulently or dishonestly induces the person so deceived to deliver any property to any person or to consent that person shall retain any property or intentionally induces the person so deliver to do or omit to do anything which you would not do or omit if you were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, or property is said to cheat. But the inducement starts at Bengaluru, ends at Singapore, and then Tamil Nadu. A chain. But may I just invite my lord's attention to paragraph 5 of my complaint, which my lord gets at page 46.
Yes. Yes.
However, to the surprise of Z-Work, in August 2023, HDFC Bank executives had contacted Z-Work seeking information on seeking certain information on certain list of invoices attached as Annexure B, raised on the Z-Work Singapore, for which RHP had received funds from HDFC Bank by the process of invoice discounting. Upon verification, it has come to Z-Work's knowledge that the RHP has discounted invoices before and after April 2023. This can only be done through fabrication and forgery of documents, and allegedly in the following manner. Well, I shall give the details to how they committed acts of fraud, forgery, cheating, and all that.
Yes.
But does it not indicate prima facie an offense which warrants investigation? Well, could the investigation be nipped in the bud itself? It can't be. That too,
Many cases we have done, sir.
I'm sorry, man.
And many cases my learned senior only has appeared. Well,
Well,
it's nipped in the bud.
That depends upon the
Yes.
facts of the
Case
case.
to case basis.
That
Of
depends
course.
upon the facts of the case. Whether in the instant case, my lord, whether the investigation could be nipped in the bud, that even millions and millions of dollars. That too, my lord, if fraudsters, international fraudsters, American court, and then, my lord, the SEBI, and thereafter Tamil Nadu police registering crime after crime against them.
Yes.
So my respectful submission to your lordship is they can't contend that the Bangalore police have no jurisdiction to register crime and to take up the investigation.
Yes, yeah.
Lord, the order of the SEBI was subsequently set aside by the SAT, and some fine was levied, and that was the end of it. 1 second, wait. Then, Lord, the third one is not a judgment. I don't know why they call it a judgment. It's an
Indictment.
Indictment, and that's the allegation. Therefore, to read this and
Indictments are drawn. That is why it is said, in the case you are convicted, you are supposed to do these things.
correct,
So
absolutely.
those are indictments, like
Indictment.
charges that are drawn.
It is, if the grand jury comes to a conclusion, then this is the consequence. That's all. Therefore,
Anyway, indictments are drawn against you. That's all.
indictments are drawn, Lord, maybe against me, but nothing has happened after this. We are talking about 2004, 2006, and I think, as your lordships know, Lord, Section 54 of the Indian Evidence Act.
Yes.
You can't cite to justify one prosecution which is wrong, some other prosecution which is pending or which has been initiated somewhere else. That is, of course, one point. But really,
No,
my lord, what
under
they are
one-
saying
sorry,
in the complaint,
under 146 of the Evidence Act, certainly I can invite the attention of the court.
Not
to
at
the
this stage.
accused.
Yes.
146 of the Evidence Act.
Yes, sir. Yes.
I have not yet been held guilty anywhere. So
Yes, yes.
Sorry.
now, the whole story, my lord,
So SEBI's order is set aside.
set aside, my lord, and modified.
Modified.
I don't have the order right now. I don't want to make a.
By the appellate tribunal.
It is incorrect, I am told. Not set aside.
The fine is modified to.
The fine is modified, I'm told, to 1 crore totally, my lord.
All right.
And that has already been paid. So that is done. But it is a story, my lord, which is very old. It relates to some DSQ software company at that point in time. And there were certain allegations there. But really,
You have traveled only in this path.
in which this part.
All right.
But Lord, merely, it's
Story
like,
is older.
I always say, it's like an adjournment application. The last time's reason is not good for this time. Every time you have to see whether the
That's
reasons are
something new.
justified. Therefore, merely because Network will not start saying, oh, there are 50 complaints against him. Therefore, my complaint is justified can't be an answer. At that I'm sure my learned friend will agree.
Will consider.
But that by itself is not sufficient also to say that this complaint can continue. And now, not only one thing,
Yes.
please see what they say is really the allegation. And the allegation is entirely everything that has occurred either in Singapore or in Chennai. At para 4, the entire transaction.
What happened to the proceedings in Chennai?
That plot we
It's
have
still-
challenged it in this pending.
There, man.
Pending.
No charge sheet has been filed. It's an FIR.
Then challenge madilwa ನೀವು.
Now challenge Madila.
Yeah.
It's
There's
it's
no
not yet
stay.
come up before the court, I'm told, in Chennai. Unfortunately, it takes a little longer there than here.
Oh, then we are better.
After filing, it doesn't come up. Here, at least we are before your lordship, so it's coming up.
Yes.
Therefore, my lord, the entire allegation of so-called misappropriation is all with respect to what happened. Because I'll tell you, lordship, what I'm saying. He says himself that 19 million is received in his complaint. Therefore, it is not a case, my lord, where someone was told something. At best, this could be a breach of contract. It can't be anything more. Because his statement is very clear that he has received 19 million. And he says after that 4 million is the amount of money which is not received from Avamore.
So for that purpose, the crime is registered.
Therefore, my lord, the crime is registered. It
That's
is
his-
not as
That's
if,
your submission.
yes, no, I'm saying that is the complaint. On the
Complaint.
reading of the complaint, that is
So
what
it's for recovery of money.
it's a claim for recovery of money. And for that, you start building an entire story of something which has happened in Bangalore, saying this has happened in Bangalore. Someone came, we spoke to them, but with whom? That entire discussion, even according to the complaint, happened with a company called Zetwork in India. And the transaction has nothing to do with Zetwork India at all. It is with Zetwork in Singapore.
What happened to the indictments that are drawn by the US jury?
No, proceeding is not, cognizance was not taken, and thereafter I'm told proceedings did not go on at all. So it remained as an indictment itself. Nothing else happened. There was no grand jury summoned or anything of that kind. Therefore, that remained there, my lord. Now, I'm saying ultimately, my lord, on the basis of this complaint at para 4, has anything happened in Bangalore with respect to that transaction? Because really they are making a claim for that 4 million, which they claim should come not from us,
Avamore.
but from Avon. And therefore, in my humble submission, can this be anything more than a civil claim for recovery of money, which, my lord, in my respectful submission, they can't do? I'll leave two authorities of your lordships, my lord, on civil dispute and.
Lord, I'm sorry, I forgot to invite my lord's kind attention to one paragraph in the complaint. That would further make it clear that the inducement started at Bangalore with Z-Work India. My lord, kindly turn to paragraph 3 at page 45. Para 3. Well, I read to your lordship para 2. Now, kindly permit me to take your lordship. It is a small paragraph, para 3 at page 45. It is pertinent to note that Mr. Dinesh had represented, because my lawyer friend said with whom, he is the companion accused of the petitioners in the first petition, and he is the petitioner in the second petition. It is pertinent to note that Mr. Dinesh had represented Z-Work India, that the end customers of RHP, but he is the director in RHP also.
No,
And the
I'm
directors
not
of
a director
RHP,
anywhere.
yes, I
No,
have.
sir, I'm not a director anywhere.
Oh, no, sir, it is there, sir. I can show
No,
you. But these are
I'm
all
not a
matters for investigation.
But I'm not a director.
You can't, yes, you are a director. I'm saying it. But it is pertinent to note that Mr. Dinesh had represented to Z-Work India that the end customers of RHP were based out of Dubai and the monies would only be paid to Z-Work India. Kindly note this, my lord. Z-Work India.
Z-Work India is Bangalore.
Bangalore, my lord. Z-Work India is Bangalore. And there is no other Z-Work other than in Bangalore, in India. Once the monies would be realized from Dubai end customers, since Z-Work India was hesitant to enter into any commercial transaction where payments were dependent on RHP getting paid by these end customers. As an alternative plan, Mr. Dinesh had proposed to set up a meeting between Z-Work India and one of the directors of RHP, Mr. Gopal Padia. Mr. Dinesh claimed that Mr. Gopal Padia held the position of the director at RHP and also served as the managing director and proprietor of Mrs. Avamore. Same, Yure. Avamore, PTE Limited. Yes, sir. He is also an accused. PTE Limited, a company incorporated under the laws of the Republic of Singapore. Further, Mr. Dinesh has proposed that since Z-Work India is unwilling to enter into any commercial arrangements which are conditional on payment from end customers, Avamore will take on the role and will place purchase orders on Z-Work India, and in turn, Z-Work India should provide a certain number of days of credit to Avamore, which will not be conditional.
So this
on
is for
getting paid by Avamore's
jurisdictional
customer.
submission.
Jurisdictional submission.
Anything else?
No, that's.
There is one forensic audit report, my lordship. It is petitioner submitting the
Which
that we'll see. How is that?
How?
It is involved in many other cases.
That senior has made. We'll consider that. We are concerned about this crime. Yes, heard. So and so reserved.
Interim order will be continued.
Interim order idea.
It is.
Interim order subsisting.
Incidentally,
will continue
he
to
was
the
able to
disposal
have
of
the
petition.
advantage of an interim order,
That
which he could not get for 5 hearings.
I had an interim order, sir.
interim order is there.
Certainly, sir. I'm not saying anything.
No,
Certainly.
you said I didn't have it for 5 hearings.
Yes, you did not. You could not.
That is
But
all.
now that he has the benefit of an interim order, probably his request has got to be granted. That is, in fairness, I am submitting till the disposal of the petition.
I'm grateful.
Yes, sir. Shamsundar 3:30. 3:30 Shamsundar. Next further hearing 3:30 ಅದೇ ತಾನೆ? Correct.
180.
The primary question Milord's raised is that whether.
24/8 first your locus.
Yes. Anbalagan's case, my lord, is relied upon. May I just pass on, my lord, Anbalagan for a moment? Yeah. If your lordships could kindly have, my lord, paragraph number 30. As my lords rightly said, my lord, my locus to hold this, my lord, it stands on the lintel of, my lord, my notification. If my notification, my lord, does not permit me to plead for an appeal, Anbalagan's case, my lord, was dealing with a situation of appeal. My lord, case in hand, I am not, my lord, in appeal before the court. I am, my lord, challenging an interim order passed while, my lord, during the course of, my lord, the trial. The case has not, my lord, been communicated. It is not yet over. My lord, during the conduct of prosecution, I find certain order passed by, my lord, the learned sessions judge is not conducive. Therefore, my lord, I am here. Now, my lord, if me being the prosecutor of the case, my lord, having confronted with the situation that there is something coming in my way to prosecute the case properly at the trial court, kindly, my lord, have Anbalagan's case, my lord, paragraph number 33.
Yes, sir. I have seen.
Yes.
You have to get over paragraph 32 lines, that's all.
That's
Otherwise-
it, appeal, my lord. Anbalagan's case was totally appeal, my lord. May I just pass on, my lord, one judgment of His Lordship Justice Nageshwar of bench? My lords may kindly have. Lord, please have paragraph number 6 in this, my lord. 6. Only, my lord, 2 lines. On page number, my lord, on second page, the pagination is in the bottom. My lord, on paragraph number 6. It may be noticed that under section 301 of the code, the public prosecutor may appear and plead without any authority before any court in which that case is under inquiry, trial, or appeal, and any person may instruct a pleader. My lord, I stop you. Lord, the observation of the Honorable Supreme Court in this matter is, in which case.
No, are you the special prosecutor there? And 302. All right, yes.
This is on 301. Then, my lords may kindly also have, my lord, His Lordship Justice Mohan Shantan Gowda's judgment, the Honorable Supreme Court, my lord, in Rekha Muraka. My lords may kindly have paragraph number 8 in this. My lord, the paragraph number 8 is on page number 5. Pagination is in the bottom. Paragraph number 5. In our criminal justice system, the public prosecutor occupies a position of great importance given that the crimes are treated as wrong against the society as a whole. His role in the administration of justice is crucial as he is not just a representative of the aggrieved person, but that of the state at large. Though he is appointed by the government, he is not the servant of the government or the investigation agency. He is an officer of the court and his primary duty is to assist the court in arriving at the truth by putting forth all the relevant material on behalf of the prosecution. While discharging his duties, he must act in a manner that is fair to the court, to the investigation agencies, as well as to the accused. This means that in the instances where he finds material indicating that the accused legitimately deserves the benefit during the trial, he must not conceal it. The space carved out for the public prosecutor is clearly that of an independent officer who secures the cause of justice and fair play in a criminal trial. Then, my lords may kindly have, my lord, another judgment, my lord, His Lordship Justice Chandrachud's judgment, my lord, in
Supreme Court andre saku.
I'm sorry, my lord, I'm sorry. My lord, in Honnaya's case, my lords have noticed Honnaya's case. My lord, Honnaya's case I am citing for 2 reasons. The first objection of my senior was that this order is an interlocutory order, my lord, which in fact is not an interlocutory order, because interlocutory order is what, my lord, that finally decides the rights between parties. Therefore, my lord, the principal objection of my learned senior was also that since this order which is under challenge.
So you say it is an intermediary order?
It is an intermediary order. It is.
All right.
This is for 2 reasons, my lord. I am laying upon this, my lord, Honaya's case. My lord, may I just read, my lord, paragraph number?
Yes, I have seen, sir.
Yes. Then, my lord, one more portion of this. Kindly, my lord, have. My lord, if my lords have seen the judgment, my lord, I will not.
No, this I am aware. What is intermediate, what is interlocutory?
Yes,
Fine.
yes.
Yes. My lord, all the case laws.
Sir, in ಒಂದೇ ಒಂದು ಕೇಸ್ la sir.
ಮುಗಿಸ್ಬಿಡ್ಲಿ.
Yes.
My lord, in Abdul Latif's case.
ಅದು ಏನು interlocutory intermediate?
ಇಲ್ಲ. ಇದು once again on locus.
Locus.
Yes, paragraph number, page number 11, my lord, paragraph number 35, 34. From all the above, it can be safely concluded that the court has power to direct investigation agency. My lord, this was on a different, slightly on a different note. From all the above, it can be safely concluded that the court has power to direct investigation agency to conduct further investigation under 173 clause 8 CRPC. In a manner, in a matter, even after taking cognizance on the final report filed by the investigation agency before it under section 173 clause 2 CRPC, either the de facto complainant who is aggrieved on account of any lapse committed by the investigation agency in conducting the investigation or in not conducting the investigation in other line to which ought to have been conducted, or the public prosecutor who notices serious lapse committed by the investigation agency in not conducting the investigation properly, can invite the attention of the court through an application for satisfying the court in respect of the necessity to invoke the power of the court under section 173 clause 8 of CRPC, even without any such wake-up call, the court on its own can invoke the power under section 173. Matters being so, we do not find any legal infirmity or jurisdictional error in the impugned.
All right, yes.
My lord, all the time, my lord.
Now on merits.
On merits, my lord, my humble submission is this.
Where is this Dikshit or order?
ಇದೊಂದು ರೂಲ್ಸ್ ಒಂದು ಎವ್ರಿ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಇದೊಂದು ರೂಲ್ಸ್ ಒಂದು ಕೋಟ್ ಮಾಡ್ತಾರೆ. This is, my lord, that rule.
You are still at the trial stage, sir.
Yes, my lord, that.
It is not concluded before the concerned court.
Not yet concluded.
So don't.
Not yet concluded. No, my lord,
You come on merits now.
Sir, my submission on the merits is, my lord, I made an application. We are as of today.
To examine CW 35 by putting leading questions.
By putting leading questions.
That was your specific application.
Yes, or by way of, my lord, cross-examining. In a manner, my lord, how it is covered under 154.
Without declaring him hostile.
Yes.
That was.
The danger of declaring my own witness as hostile, my lord, would be this. Now, my lord, either I like it or don't like it, my lord, he is the investigation officer. He has recorded many statements.
You don't like it, obviously.
I'll have to, in this case, yes. My lord, he has done major part of the investigations. Now, my lord, because he has done all the investigations, wherever the investigation supports the case of the victims, the say of the victims, the case which was noticed by the Honorable Court while, my lord, passing an order under 319, my lord, I have used them. Now, my lord, as long as the witness who is the investigation officer says on those lines, yes.
Now you want to get from the investigating officer why he gave up those things.
I may not even ask those things, my lord. I'll only do this, my lord. It will be, my lord, too premature, my lord. If I may say this.
What you'll ask?
Why should my lord the witness should feel shy? My lord, I might ask something. Even if, my lord, I ask him a tricky question, if he has done something correct, he can stand by that, my lord. It's not that. In the cross-examination, the moment I am permitted to put questions, my lord, the witness is being, my lord, denigrated, or the credibility of the witness is being, my lord, pulled down. It's not so. My lord, I'll make an attempt by putting whatever the questions which I feel like. My lord, if those questions are answered in a manner, my lord, what he knows, and if I am unable to take, my lord, something what I want, that goes with that. The other way, if I don't put certain questions and leave it at that, my lord, without testing the correctness of the investigation. In fact, my lord, it is in his good interest also, because there is already an observation that he has committed certain lapses.
All right.
My lord, I test him.
So it is whether you are permitted to put leading questions without declaring him hostile is to be answered.
That's all.
We will answer it. Yes.
My lord, if it comes to, my lord, I want to, my lord, keep one submission open. My lord, if it is on the locus, and if judgment, my lord, of the Honorable Supreme Court in Anbalagan's case is made applicable to me, which is in fact, my lord, in its restricted sense of appeals, then, my lord, I would, my lord, I'll only, my lord, say that I have made my attempt, my lord, as a prosecutor without seeking any authority from the government, because 301, my lord, speaks in any unconfused language, my lord, I can do anything.
I'll answer.
That's it.
Yes. Merits ಮೇಲೆ ಅಷ್ಟೇನಾ?
Aste, my lord, that's all.
Yes,
that-
sir.
My lord, crime was registered on the night of 22/5/2010 on the complaint of PW1 in respect of the assault done on the person of PW2, his sister. Both of them were staying in different places at that point of time in Bhadravati town. He was getting some sport competitions conducted elsewhere on that night.
No, that's on the merit of the matter.
But my lord, he would come home. And that, as he got into the house, 5 of these accused were said to have barged into the house, assaulted his sister and gone back. Now, in this complaint, my lord, it is very, very pertinent and relevant to read the complaint before my lord in order to demonstrate the frivolity. My lord, he says his sister was assaulted when he was washing his.
One clarification. Order under section 319 that is passed
Yes.
has become final. So all that putting the clock back and saying complaint is frivolous would not be available now.
Yes.
Let us stick in.
Yes.
No, let us confine our deliberations to whether he could have put leading questions in through his application, whether rejection of the application is correct or not.
When we come to the province of leading questions,
Yes, sir.
putting leading questions,
Yes.
may refer to section 142 of the Evidence Act for a
Evidence Act,
moment
yes.
before my lord. 142.
142 says what is a leading question?
140, it is only 142 that provides for putting leading questions.
Yes.
That is the
Yes.
clear section.
Yes, sir.
And the only section, 142, and they must not be asked. I mean,
Leading questions must
leading-
not be asked
yes, must not, if objected to
by the adverse.
adverse party, be asked in the examination in chief
yes.
or in the re-examination, except with the permission of the court. With the permission of the court. Next, court shall permit leading questions as to matters which are interlocutory, undisputed, or which have in its opinion been already, sufficiently proved. Now,
No.
now he wants
Come to section 154.
154. Section 154. My lord, section 154.
Now it is his own witness.
My lord, section 154 is permitting the party permitting the party to cross-examine the witness.
No, putting questions
own
to his own
witness.
witness,
Yes.
he might have put it in cross-examination to our adverse part.
Yes.
ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ ಅದು?
ಹೇಳಿದೀವಿ.
ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ? ನನಗೆ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿ.
ಇಲ್ಲ.
Where did you make those submissions on 154?
154, my lord, I in fact relied upon the
Yes,
judgment of, my
ಆಮೇಲೆ?
lord, in Kishore Prasad,
ಹಾ.
in Ram Kishore, my lord.
Early, let him finish. Wait.
Yes.
Yeah. Now, my lord, question by party to his own witness. He can put any questions to his witness.
See, this is court may, in its discretion, permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party.
In ordinary
So
parlance,
it is a leading question also
that
can be put.
it is this in ordinary parlance known as treating the witness hostile and permitting the party calling him to cross-examine him.
Alla, there is nothing said in the Evidence Act who is hostile.
Word hostile is not used unless the witness shows that he is hostile to the prosecution, he is hostile to the party summoning him. Well, there must be ostensibility. There must be something to attribute to him that he is hostile to him. He is hostile to the party summoning him. What is that my learned friend is able to show here, demonstrate here? When a crime was registered, investigation was done by CW 33 local police officer only for a few days. Important thing, paramount point for me to urge before your lordship is No sooner the crime was registered and the investigation was taken up by local investigating officer, they approached this honorable court, filing a writ petition that it should be referred to the CBI. CBI. Well, in that writ petition, decision was taken by this honorable court to refer that matter to the CID forthwith for investigation. It was referred to. They were satisfied. They did not, they had the facility of making 164 statement before the court, before the magistrate, expressing of their dissatisfaction. They did not do. They could have offered one further 161 statement under the provisions of 161. They did not do. Then, my lord, they were satisfied with the order passed in the writ petition. Now, CW 36, CW 37 are other two investigating officers from the CID. CW 35 is from local police, CW 36 and 37. They don't say anything against them. It is, my lord, it is their child. Now they investigated into the matter and filed charge sheet.
No, those are other things. Now, we are on a limited question.
My lord, your lordship, kindly bear with me.
Yes, yes.
What is the test it has passed? What is all that it has gone through at this stage of 226, 227? Even the court was not able to find any fault with the investigation. 226 and 227, here before framing of charge, they had an occasion to address argument saying that the earlier, the first complaint given by them against 5 persons, including of an MLA, I could have mentioned of that, they have been left scot-free, and A6 has been brought on record as accused, as district accused, who was nowhere in the site, etc., etc. They could have urged of that. They did not do. Then, my lord, when the matter, when they were summoned to tender evidence, the sister and brother, they implicated all these 5 persons again in their examination in chief. Therefore, the court proceeded to take cognizance of offense against them.
That has become final.
All this happened. Now, my lord, what is the order passed under 319? They should have, the court should have made all this.
You are not under challenge for that order. We will not enter into merits of why 319 was passed, why they were brought back.
I'm not on that aspect. I'm not
limited aspect.
I'm not on that aspect. I'm on the aspect that these 5 persons should have been made to stand trial with the accused who was already facing trial. Now, what is the position?
That stage is over.
My lord,
that stage is over. I am not going to go back to 319. It is plain and simple. 35 CW 35. He wanted to cross-examine without declaring him hostile. No, he wanted to put leading questions. The application was that.
No. It is not for treating him hostile.
Not for treating him hostile.
Yes.
Putting leading questions without treating him hostile.
Only leading questions.
Yes. Whether that is permissible or not, ashte answer iga. 319, I'm not going to go back.
Yeah.
The background of the case has to be looked at.
My lord, even to take a decision on that score, the backdrop of the case has got to be looked at.
Leading questions, whatever the court has answered, 319, I can't go back. Whether that is correct or not, I will not go back.
If he is anxious to put only leading questions, and his anxiety is confined only to that, the section 142 and 143 can as well take care of.
I will consider that. That's all.
Yes.
Yes, Shyam Sundar sir.
Only one judgment, my lord. Jugal Kishore.
ದೀಕ್ಷಿತ್ ಅವರು ಜಡ್ಮೆಂಟ್ ಕೊಟ್ಟರಲ್ಲ ಒಂದು ಕೊಡಿ.
ಇಲ್ಲ ಇನ್ಫ್ಯಾಕ್ಟ್ ಅದಕ್ಕಿಂತ ಇದರಲ್ಲಿ ಇನ್ನ ಜಾಸ್ತಿ
ಅಲ್ಲ ಅದು ಕೊಡಿ.
The condition precedent to put leading questions without treating the witness hostile is that he must be able to bring up, he must be able to demonstrate hostility on the part of the investigator.
You will answer all that. Yes.
My lord, on page number 4, my lord, pagination in the bottom, paragraph number 11, my lord.
ಯಾಕೆ ಇದು ಇಂಡಿಯನ್ ಕಾನೂನು ಬಿಟ್ಟು ಬೇರೆ ಯಾವ್ದು ಸಿಕ್ಕಿಲ್ವಾ?
ಅದು ಇದು ಬಹಳ ಕಡೆ ಹುಡುಕ್ತಾ ಇದೀವಿ ಅದರದ್ದು. ಈಗ ನಮ್ಮ ಆಫೀಸ್ ನಲ್ಲಿ ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ವಾಲ್ಯೂಮ್ ಇಸ್ ಮಿಸ್ಸಿಂಗ್, my lord. That's the reason. In a hurry, my lord.
363 ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ವಾ?
Kindly, my lord, have page number 4, my lord, on the bottom, to state to clear the controversy over meaning of the term hostile witness, adverse witness, unfavorable witness, that given rise to the considerable
ಎಲ್ಲಿ
difficulty.
ಓದ್ತಾ ಇದ್ದೀರಾ ಸರ್?
Page number 4 ನಲ್ಲಿ ಕೆಳಗಡೆ paragraph number
ಟು
11.
ಸ್ಟೀರ್ ಕ್ಲಿಯರ್ ಅದ?
Yeah, to steer clear
ಹಾ.
of the controversy over the meaning of the term hostile witness, adverse witness, unfavorable witness, which had given rise to the considerable difficulty and conflict of opinion in England. The authors of the Indian Evidence Act seem to have advisedly avoided the use of those terms so that in India, the grant of permission to cross-examine his own witness by a party is not conditional on the witness being declared adverse or hostile, whether it be
That's a condition in English law. It's not here.
condition in English law. In India, my lord, 140, 154 departs from using these words.
The word hostile witness is not there in the Evidence Act,
Indian,
but in
yes.
English law it
Yes.
is there. You have, if you want to cross-examine your own witness
Yes.
or put leading questions, you shall be declared hostile.
Yes.
You shall declare him hostile only, then cross-examine.
Yes, that is, my lord. the
That is in
position
English law.
Under English law. In India, my lord, no.
But
The law is settled on this.
We'll
Jugal
see.
Kishore settles.
we'll
My lord, now one to four, PWs 1 to 4. They are inmates of the same family. Complainant, his sister, etc., etc. They got into the box. My learned friend never suggested to 4 of these witnesses that the act did not come about at the instance of one accused, but at the instance of 5 accused, or involving 5 accused. No suggestion was put to any of these persons. Nextly, important aspect is the melod of 6 persons have been examined who are the immediate neighbors of PW2, the victim in this case. Melod, they came out as she raised hue and cry in the during the unearthly hours. All these persons came out of their houses and gathered there. They say one person with a chopper they could see running away from there, from the house of the accused. Now, he examined them.
according to
You will
the-
let me kindly extend me
Yes,
some, I mean, a little more indulgence. My lord, he examined on his behalf PW 5 to 10, immediate neighbors of PW2. Now, was it not incumbent upon him? Was he not bound to treat them hostile? Because they were not sailing with this case. They have not sailed with this case. They have not towed on this line. They ought to have been, if what they state was not conducive to him, if it was not fitting in, then he ought to have treated them hostile. He never treated them, any of them hostile. My lord, I would go a step, one step ahead and submit for my lord. Even a suggestion is not put to them. None of them is not only treated hostile, even suggestion is not put to them saying it was committed by 5 persons, not by 1 person. His own witnesses, 5 to 6. Now the different story is brought in
No,
without
even-
treating them
No
hostile.
story, but he wants to cross-examine or put leading questions to the
What is
investigating
the
officer.
hostility, my lord? What is this hostility
one
he has been
observation-
able to find in CW 35? What is that hostility? Where is he found hostile to him? What injustice has he meted out during the course of investigation? What has he done, my lord? He has only discharged his duty, and he was not even allowed to discharge his duty full well. There was an order, yes.
So he's
It
not
was-
wanting
it was
he's
not.
not wanting a sentence or indictments brought against him. He
Then
only
the
wants to
order
examine
of
him.
this honorable court came in between. It was handed over to the CID. He is now, CID has recorded the statement of CW 35. Nowhere we have been able to find any fault with him. If we are not able to find any fault with CW 35, how could my learned friend seek, I mean, the sanction or permission to permit him to cross-examine him, or without cross-examining, to put leading questions which could be put only in the cross-examination of witness? How could he do that, my lord? How could he afford to do it in the framework of Indian Evidence Act?
We'll answer it.
Yes, he must be first able to demonstrate he has been his enemy. He has been hostile to him. He is not prepared to sail with him. He has not done it in the course of investigation also, not only during trial. Let him point out let him give me one inkling where he has been hostile to him. I would not argue the matter further.
No, I cannot say what he will ask here. Or I cannot ask, what are you going to
Yeah.
ask here?
Where is hostility, my lord, on the part of CW 35?
He's not saying hostility at all.
No,
He
if
wants
he-
questions.
No, the law, what law says is,
That I will answer.
if he is hostile, if he has exhibited hostility, then permission could be granted, accorded to him to put leading questions which could possibly be put in cross-examination. We are not able to find any of such things here. Now, I'm placing before my lord
What?
case class,
Kodi.
widely covering of this. Para 10, Swami. Para 10 of the first case law. Before proceeding further, we might like to state that the law on the subject at this stage, Section 154 of the Evidence Act is the only provision under which a party calling its own witness may claim permission of the court to cross-examine them. The section runs thus: court may, in its discretion, permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party. The section confers a judicial discretion on the court to permit cross-examination and does not contain any conditions or principles which may govern the exercise of such discretion. It is, however, well settled that the discretion must be judiciously and properly exercised in the interest of justice. The law on the subject is well settled that a party will not normally be allowed to cross-examine its own witness and declare the same hostile unless the court is satisfied that the statement of the witness exhibits an element of hostility, or that he has resiled from a material statement which he made before an earlier authority, or where the court is satisfied that the witness is not speaking the truth, and it may be necessary to cross-examine him to get out the truth. One of the glaring instances in which this court sustained the order of the court in allowing cross-examination was where the witness resiles from a very material statement regarding the manner in which the accused committed the offense. In hostility is the material point. Let my learned friend show how has he been hostile to him, and how has he brought out that he had the facility of leading evidence of PW 1 to 4, as I submitted before my lord a jeep back, all of them hailing from the same house, PW 1 to 4. How has he been able to bring out hostility on the part of this witness from their evidence? They should have said something adverse having happened at the instance of this investigator, one of the three investigators. Nothing has been brought out. And his own witnesses said, PW 5 to 10. One of them is brother of PW1. My lord, 5 to 10. One of them is brother of PW10, PW1. The first information he got from the complainant himself. He never disclosed this incident having come about involving 5 accused persons. Only one person. Rightly, they filed charge sheet into the court against one person who is now.
You're going back on 319. I'm not on 319.
Yes.
Yes, Jagdish, anything to say?
Yes. My last citation number 3. Investigating officer was not allowed.
When he should be treated as hostile? Madras, right?
Madras.
When he should be treated as hostile?
The investigating officer was not allowed to be treated hostile.
1991 Madras, yes.
Only one sentence, my lord, before my friend amicus curiae, only one sentence of submission.
Illa, I will permit you after him.
Yes,
Yes, sir.
okay.
On 2 occasions, my lord, you can read those facts. You can cross-examine our own witness. Of course, one not supporting. Second, you should have a foundation factor to show that the truth is not brought before the in the course of investigation. One problem lacks in this case, my lord.
No, truth is not brought in the law. That is clearly prima facie demonstrated by the order recalling 1 to 5. Recalling 1 to 5, saying investigating officer washed off his hands. So that is what he wants to say.
One issue, my lord, the PW 8, the special public prosecutor relied on 161 statement. and treated him overstep.
You're relying on 161 of whom?
161 of the investigation officer. Place the.
Kodi? You want to rely on that
161
statement?
Recorded by.
Recorded by.
Not
investigating officer,
In fact,
ಯಾವ
I was
161
taken
statement
aback
ಕೊಟ್ಟಿದ್ದಾರೆ?
whether there is a new situation of investigation officer.
Giving 161 statement, recorded by the.
Now, the same, if he is going to go by to this 161 statement, then the fact that he is relying on that, that is what my lord trial court also observes.
Sir, 161 ಏನ್ value ಅಂತ ನಿಮಗೆ ಗೊತ್ತು. Whether he relies on this or doesn't rely on it makes no difference.
But should have been cross-examined.
No.
Should have been treated in hostile, not by.
That is qua other witnesses. CW 35.
Hello, not
We'll see.
Well, all of them
Submission
stated, only
on-
one person having committed the incident. Only one person.
No, we'll answer,
having
because
committed
this has
assault
wide
on one
ramification, I will have to answer, I will answer it.
On one.
They all have,
on-
they
on-
all have gone out, intact,
in
without
fact,
being treated hostile by my net front.
on one count.
And now he would make out his case under 319, tutoring the witness with the
That is
two or
over,
three
stage is
witnesses
over now.
to improve their story.
No, we'll see.
Improve their story
See,
in
it is
examination.
not that he would be permitted to do so. We'll analyze the statutory provisions and answer it. It needs an answer. Both 24(8) and this.
Yes. On one count, my lord, both my learned senior and the learned amicus curia are on, my lord, they are in unison. That is, because I have not opted to cross-examine the other witnesses who were cited as witnesses by these very investigation officers, I have not treated them hostile. Can I be doing that? My lord, it is, my lord, to my satisfaction, if I feel that their version as it is useful to sue, is to, my lord, prove some prosecution case, why should I, my lord, spoil them? Why should I, my lord, forego them? And my lord, why should I treat them as hostile?
We'll see, we'll answer it.
So,
Either way, recorded later.
my lord, the matter is on 9th.
I've already stayed it.
No, my lord, it is only deferred.
It will be deferred.
Lord, Lord,
They
kindly
heard
state
the learned prosecutor, M.S. Shamsundar appearing for the petitioner, learned counsel CH-17 and the amicus B.N. Jagdish. Heard judgment reserved. The concerned court shall defer the matter till the judgment is pronounced.
So great.
We'll answer it.
4 o'clock.
It has
One matter for
ramification.
settlement.
4 o'clock.
One matter for settlement.
Settlement, Kodi, ಏನದು?
Yes.
What settlement?
Mediation, they have agreed to.
Offense?
They expect file that the,
Where is the respondent? No, counsel for the respondent.
no, not it, they
Okay.
are not taken. Okay.
Who is the respondent?
Vidyashri,
What is the settlement?
they have matrimonial case, my lord. 1/2/20. They have settled their issues and divorce has been granted. In
But
mediation,
ಯಾರಾದರೂ somebody should be there representing.
she
the
is
counsel.
presenting herself.
You are representing yourself.
Yes, representing herself.
All right.
Petitioner is here.
Madam. Begin. Yes. Closed. Signature mark. 498. Yes. Flag ಹಾಕಿದ್ದೀನಿ.
Signatures. My lord, item 151, mentioned in the morning. It was also directed to be listed at 4 PM.
Not before me. Let the matter go before any other judge. Yes.
My lord, with your lordships kindly.
My lord, till such time your lordships are extending the interim order given.
I am not saying anything. Not before me. That's all. Yes.
Serial number 161, my lord.
What? I am not saying anything, sir. I am just saying not before me. It is obvious that I have not done anything. You can it will be posted before any other judge.
Serial number.
Order already
Serial number.
existing.
Already existing will continue, obviously.
My lord, if in case this court is going
I
to.
am saying not before me. Have I passed any order?
My lords, on the previous.
Have I
occasion-
passed any order on today saying that it will be extended? I am only saying not before me,
My
that's
lords,
all.
can you Allow me to make submission at least. My lords, on the previous occasion, I had raised an objection with regard to the extension of the order. Despite
You-
my objection.
You
my lord,
can,
the order
you
was
can
extended.
argue the matter before any other. What is this, madam?
My lords,
I am saying not before me, you are asking me to pass some order.
I'm not mentioning.
Then what
that.
is it, madam?
My lord, I'm just saying that on the previous occasion of hearing, your lordship extended the order despite my objections without considering.
It's all right, what to do? It's
So
done.
same should not happen today. That's my.
Now I
submission.
am
That's
not
all.
doing anything. Have I done anything now?
I'm not
Then-
saying.
Then what?
Now your lordship
What
raised
is
the
this?
matter, that's fine.
Something more serious has happened.
No, sir, let it go before any other judge, not before me. Yes.
Serial number 161.
Because it directly concerns the case.
I am not passed any order, sir. Today I have just said not before me, that's all. Yes.
Serial number 161, my
My
lord.
lords, with your
Connected with
lordships, kindly-
6299 but 2024, my lord. Day after tomorrow, my lord, 8th, my lord.
ಏನು sir?
Day of the man.
One ನಿಮಿಷ, call the matter, call the cases, madam.
My lord, one more submission. My lord, I was willing to file one application. That can be taken on record.
What application?
Application.
In
for-
that, madam, when I say not before me, can I take the application? What is all this?
My lord, it's urgent.
No, no, no. You move the registry is directed to place the matter before any other judge after obtaining the orders of the Honorable Chief Justice. Yes.
Okay.
Next.
My lord, serial number 117, my lords.
1 minute, call the cases, madam. Andre, page wise career.
Page 15, till number 96,
94, 94, not yet call.
94 and 96.
ಒಂದು ನಿಮಿಷ, ಎಲ್ಲಿಗೆ ನಿಂತಿದ್ವಿ ಮೇಡಮ್?
94.
94.
My lord, it's covered by lordship decision, my lord.
Where interim orders ಇದೆಯಾ?
My lord, the essential commodities act. release of
Interim order ಇದೆಯಾ?
Either. Alas, stay.
Company is not made a party?
My lord,
What ground?
my lord, they seize the goods, seize the vehicle, then register.
Interim order ಇದೆ ಅಲ್ವಾ?
It is, ಅಲ್ಲ, ಇದು food grains release ಆಗಿಲ್ಲ.
ಓ, ಇದು ಫುಡ್ ಗ್ರೈನ್.
ಅದಕ್ಕೆ.
ಮತ್ತೆ ಇದು ಲಿಸ್ಟ್ ಫ್ರೈಡೆ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
Please.
ಎಸ್. ಪೆರಿಷಬಲ್ ಕಮಾಡಿಟಿ ಅಂತ ಫ್ರೈಡೆ ಕೊಡ್ತೀನಿ
Please.
ಅಷ್ಟೇ. ಎಸ್.
96.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್.
96.
Initiating legal action. ಇದು ಲಿಸ್ಟ್ ಆನ್ ಫ್ರೈಡೆ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
Interim order is there in connected.
Interim order subsisting wherever shall continue. Friday we will have to finish it in the, and that will be pronounced tomorrow.
Could it be on Thursday, my lord? Friday I have some inconvenience.
ಆಯ್ತು, Thursday. Thursday in the fresh matters list, yes.
I have a submission in this. Lordship,
Really.
I have a submission in this.
Not now, on Thursday, yes.
Okay.
Next,
97 to 102.
99, my lord. 99, coming for third time before your lordship.
let it come, sir.
April,
In 1 minute, dates ಕೊಡಿ madam, 1 ನಿಮಿಷ.
Interim order ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಅದಕ್ಕೆ.
1 ನಿಮಿಷ,
Warrant.
First, ಯಾವತ್ತು madam, ತೊಗೊಳ್ಳಿ. 13th? September 13th. 30th. 13th ಬೇಡ. ಆಮೇಲೆ ಬೈತೀನಿ. Interim order ಇಲ್ಲದೆ ಇರೋ cases which are in admission will all come on 28th and 29th of August.
Yes.
No other date is available. Then all where interim orders are there, they'll come in the first week or second week of September. Yes.
My lord.
My lord, with your
Where
lordships,
interim orders
kindly-
are there.
142.
My
Withdraw
lord.
ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ, ಇಲ್ಲಿ withdraw ಇಲ್ಲ.
ಹಾ.
Withdraw ಇಲ್ಲ. Bank has issued 7 days notice for.
ಓ, ಸರ್ಫೇಸ್ ಇದಲ್ವಾ?
surface.
ಅದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿ. ಲಿಸ್ಟ್ ಡೇ ಫ್ರೈಡೆ ಹಾಕಿ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ.
My lords, for
My lord,
settlement.
serial
My
number
lord.
164,
142
my
ಮಾತ್ರ.
lord.
Well, my lord, 161, my lord.
1 minute, sir. VCL ಇರೋರು ಪ್ಲೀಸ್ ವೇಟ್.
Sir,
1 ನಿಮಿಷ, ಪೇಜ್ ವೈಸ್ ಹೋಗಿ. Yes,
my
next.
lord, you stay ಕೊಡ್ತೀರಕ್ಕೆ 1
ಫ್ರೈಡೆ ಮಾಡ್ತೀನಿ ಸರ್.
Friday ಮಾಡ್ತೀರಾ?
ಎಸ್. ಬ್ಯಾಂಕ್ ಯಾವ್ದು? ಯಾರು? ನೀವಾ?
UCO Bank.
ಯಾವ ಬ್ಯಾಂಕ್?
UCO Bank.
ನೀವಾ? ನೀವ್ ಯಾಕೆ ಇಲ್ಲಿದ್ದೀರಾ?
SBI ಇದೆ sir.
ಓ, ಸರಿ,
UCO
ಆಯ್ತು.
Bank.
Parashuram, sir.
1 minute, next page.
Parashuram ಅವ್ರು,
1 minute, next page ಕರೀರಿ. VC, please wait.
112. Page.
ಹಾ. ಏನೀಗ? ಯಾವ ಕೇಸಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ?
ನಾನು ಹಾಕಿದಕ್ಕೆ stay ಆಗಿದೆ.
ಯಾವ್ದದು ನಂಬರ್?
ಈಗ petition my lord.
ಈಗ ನಿಮ್ ಮೇಲೆ ಹಾಕಿರೋದು ಸ್ಟೇ ಆಗಿಲ್ವಾ?
ನನ್ನ ಹಾಕಿರೋದು stay ಆಗಿದೆ.
ಆಗಿಲ್ವಾ?
ನಾನು ಹಾಕಿರೋದು stay ಆಗಿದೆ ಸರ್. ಅವ್ರು ಹಾಕಿರೋದು stay ಆಗಿಲ್ಲ.
ಈಗ ಅವ್ರು ಹಾಕಿರೋದು ಯಾವ್ದು?
ಅವ್ರು ಹಾಕಿರೋದು ಅದು ಎರಡು ಒಂದಿಲ್ಲ, ಈಗ ಒಂದು ಮಾತ್ರ ಇದೆ ಸರ್.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಅವ್ರು ಹಾಕೇ ಇಲ್ವಾ?
1318
ನೀವ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ ನಿಮ್ ಮೇಲೆ ಆಗಿರೋದು?
ಇಲ್ಲ.
ಮತ್ತೆ
1318 ಅವ್ರು
I will see.
ಮಾಡ್ತಾರೆ.
Yes, let it be. It will come on first week September. Yes, next.
720, 113 to
107 somebody told.
104 your lordship.
10 entry model ilva? Idre 2 weeks. Yes, yes.
Your lordship, 104 your lordship. Matter has been settled your lordship.
Huh?
104.
Settlement, wait sir, I'll tell you. Ilde iradu 28, 29 September. Yes. Next.
Page 18, 113 to 117.
My lords, serial number 117, my lords.
117 ಏನು madam?
My lords, first connected matters minus criminal petition 8719. Kindly interim order may be extended, my lords.
My lord, this 117 is a SFIO matters, my lord. SFIO matters, my lords.
117.
117,
Yes,
my lords.
How many?
All
117s
SFIO
are there,
matters.
sir? ಏನಾಗ್ಬೇಕು ಈಗ ಅದರಲ್ಲಿ?
Kindly interim order may be extended, my
ಅದು
lords.
ಅಷ್ಟೇ. Since it is SFIO, list it on 12th September. Interim orders granted earlier stands extended to the next date of hearing. Interim orders will be extended. Please don't make a mention. Yes, next.
Page 19, 118. Page 20, 119 to 126.
Serial number 120.
120.
Appearing for respond, my lord. Petition may be allowed, my lord.
Petition may be allowed. 311 application. List day after tomorrow in the fresh matter. Illa Friday in the fresh matters list.
Your lord, serial number 124, your lords.
One minute, sir.
As per, yes.
122. Oh, that yes. ಇದು ಇಂಟರ್ಮೋಡ್ ಇಲ್ಲ ಅಲ್ವಾ? Anyway, list on 28, 29th ಅವತ್ತೇ ಹಾಕಿ. Yes.
Page 21, 127 to 137.
Your lordship, 127, your lordship.
Serial number 137.
131 withdrawal ಮಾಡಿ. 130? ಏನದು? Yes.
137, serial number 137, my lords.
What is that?
I am for the petitioner, my lords. This is with respect to that CCB's charge sheet where about 300 accused are arraigned, my lords. I am a director of a company, my lords. There is the only allegation against me is that I became a director in the year
Interim order ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
28th or 29th?
Serial number 128, my lord.
128. ವಾಪಸ್
ಸೆಟಲ್ಮೆಂಟ್ ಅದು 9ನೇ ತಾರೀಕು ಲಿಸ್ಟ್
ಕಾಂಪ್ರಮೈಸ್. ಈಗ ರೆಡಿ ಇದ್ದೀರಾ?
ಇವತ್ತು ಪಾರ್ಟೀಸ್ ಬಂದಿಲ್ಲ 9th ಅಂತ ಹೇಳಿದೆ ಅವರು.
ಆಯ್ತು. We'll list it on 9th.
Serial number 130, my lord.
130.
And for the respondent, I have filed.
Interim order ಇದೆಯಾ ಇಲ್ವಾ?
Interim order ಇದೆ ಸ್ವಾಮಿ. I have filed application to vacate the interim order.
ಆಯ್ತು. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
I filed, my lord.
List ಅದನ್ನ again that also on 28th you list in interlocutory. Yes.
Your lord, serial number 127, your lordship.
Interlocutory applications only 28th September it will come. Yes.
Your lord, serial number 127, your lordship. Notice is not at order, your lordship.
Fresh matter ಅದು.
Yes, your fresh matter, your lordship. This court is directed for produce the investigation papers, your lordship.
List on Friday.
In fresh matter list, your
Friday in the
lordship.
fresh matters list. Yes.
Serial number 135.
130?
135 minutes.
28, 29.
Interim order ಇದೆ ಅಲ್ವಾ?
ಇಲ್ಲ.
28th.
Right.
Yes.
Serial number 107.
I have to go back. Wait, madam. Yes.
Page 22, 138 to 140.
Serial number 138, my lord.
138.
My lord, BWSSB matter, my lord.
B group ಎಲ್ಲ BWSSB covered.
Yes, my lord.
Then disposed. Yes. BWSSB format ಇದೆ.
144.
140?
144, my lord. ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಿಡಿಯೇಷನ್ ರೆಫರ್ ಆಗಿದೆ ಸ್ವಾಮಿ. 4 weeks ಆದ್ಮೇಲೆ ಒಂದು
ಆಯ್ತು. It will come. The settlement matters will.
ಪಿಟಿಷನರ್ ಡೆಲ್ಲಿಯಲ್ಲಿ ಇದ್ದಾರೆ ಹಂಗಾಗಿ 4 weeks ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ರೆ ಅವ್ರು ಕರೆಸ್ತಾರೆ.
ಆಯ್ತು ಸರಿ. 19th September.
146.
144 19th September. 145 ಏನು?
So in this matter.
Settlement.
ಇದು matrimonial dispute my lords, MFL settle ಆಗಿದೆ.
ಹಾ.
But respondent is not coordinating properly it seems my lords. Notice may be ordered.
ಸೆಟ್ಲ್ ಆದ್ಮೇಲೆ ನೋ ಕೋಆರ್ಡಿನೇಷನ್ ಆಬ್ವಿಯಸ್ಲಿ. ಎಸ್ ನೋಟಿಸ್ ಒನ್ HCGP 2 emergent notice.
My lords, and you had actually directed the registry to list another matter where respondent is the complainant and petitioners are the
ನಂಬರ್
accused. I've already given my lords, but
ಅಯ್ಯೋ ಇನ್ನೊಂದ್ಸರಿ ಕೊಡಿ ಸರ್.
459 of WP,
ಹಾ.
459 of 2024 my lords.
Tag this petition along with WP 459 of 2024. ಆಮೇಲೆ
146 my lord that.
146, yes sir.
Both the matters interim order is there.
Final disposal, it will, interim order will continue sir.
143, we are taking execution of NBW. Not without execution of NBW, trial is not proceeding further.
1 minute, 143 list on Thursday ಎಷ್ಟಾಗಿದೆ ಅಂದ್ರೆ 8th 136 ಅದೆಲ್ಲ ಇದೆಲ್ಲ ಮೇಡಮ್ 8 7 list on 9th fresh matters list, yes.
Number 139.
Proceeding. This being civil proceeding. But after
In-
10 years.
interim order ಇಲ್ವಾ? interim order ಇಲ್ವಾ? ಸರ್ it will come, yes. Yes, ಒಂದ್ ಆಮೇಲೆ ಎಲ್ಲರಿಗೂ ಕೊಡ್ಬೇಕು ನಾನು. ಅಷ್ಟೇ ಅಲ್ಲ?
150.
On Friday 150
Dictating ಅಲ್ಲಿದೆ. Any date make it.
Friday.
Very well.
My lord, serial number 164, my lords.
161.
1 minute, page wise we are going, wait. Yes. 151 illa budi, not before me. Friday.
20, page 25, 150 further in, 152 to
All this
156.
will go on Friday again.
My lords, 159.
153
my lord, so please do.
ಏನು ಗೊತ್ತು ಫ್ರೈಡೆ ಹಾಕ್ತೇನೆ. Yes.
Once.
ಈಗ
My
ಕೇಳ್ಬೇಕಾ?
lord, serial number
ಈಗ
164.
ಕೇಳ್ಬೇಕಾ? Friday, yes.
Interim order.
Interim orders will continue, sir, wherever they are.
61.
Lord, 161 my lord.
My lord, serial number 164, my lords. I appear for the petitioners. My lords, your lord.
One minute, madam. I'm just passing through the pages. Wait. 164.
Please, my lord.
161.
Yes, madam. What do you want?
My lord,
I
your
appear-
lordship may have it on Friday, my lord.
Your Honor, I appear for
Even
the
otherwise, it is on Friday.
respondent
Yes.
Your Honor, I appear for respondent in serial number 164. We have engaged senior counsel.
166.
164, Your Honor.
Yes, madam.
Your Honor, I appear for respondent
1
in
minute,
serial
madam.
number.
VC, please wait, madam. I'll come back to you. Yes. ಅಲ್ಲ ಇಲ್ಲಿ ಯಾಕೆ ಬಂತಿದ್ದು?
Documents release ಮಾಡಿದ್ರೆ
Francis, where is Francis Xavier? ಆಯ್ತು ಇದನ್ನ I'll post it on 20th in the fresh matters. We'll post, yes. List on 20th in the fresh matters list. Next week ಇರೋದೇ 3 ದಿನ ಮೇಡಮ್. ಅದಕ್ಕೆ it's full. Yes.
My lords, 163 Friday.
160?
163.
ಏಕೆ Friday?
It may be.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಎಲ್ಲ Friday ಸರ್.
161.
ತಾಹಿರ್ ನಿಮ್ದು ಯಾವ್ದು?
161.
number 167.
I'll take it, wait. Yes.
161.
160?
161 my lord.
Page number 28 ಅಲ್ಲಿ ಏನಿದೆ ಸರ್?
161 you lord can direct.
161 ನಲ್ಲಿ
107
I filed an NOC ವಕೀಲ್ ಪತ್ರ for bank ಮೇಲೆ.
161.
161. My lord, 6299 is required to my lord connected with one C other.
ನೀವೆಲ್ಲೋ ಕಾರಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ ಸರ್.
I'm sorry my lord, I'm sorry my lord, I'm sorry, extremely sorry.
Connected.
161.
161.
No, one common order, sir. Wherever interim orders are there, they will come in the second week of September. Wherever interim orders are not there, 28th or 29th, no more submission. Yes.
Connected.
All further hearing matters will come on Friday. Interim orders will be extended. Don't make any mention.
Connected ಆಗ್ಬೇಕಾಗಿತ್ತು.
Serial number 167, my lord.
6299 but
I'll rise and go. If this is the chaos, then what can be done? ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಹೇಳಿದ್ರೆ ಹೆಂಗ?
ಅದ್ರಲ್ಲಿ ಮೊದಲು ಆಗಿತ್ತು ಬಟ್
which matter, sir?
6299 but 2000.
ಯಾವ ಮ್ಯಾಟರ್ಗೆ ಸರ್?
161 my lord.
ಡಿಲಿಂಕ್ ಆಗಿದೆಯಾ?
ಹೌದು ಅದು ಏನೋ
ಡೀಲಿಂಗ್
ಬಂದಿಲ್ಲ.
ಆಗಿದ್ರೆ ನಾನು ಮಾಡಲ್ಲ.
ಅಲ್ಲ ಡೀಲಿಂಕ್ ಮಾಡಿಲ್ಲ ಅದು ಏನಾಗಿದೆ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಇದಾಗಿದೆ ಹಾಕಿಲ್ಲ.
ಅದ್ ತಗೊಳ್ಳಿ, ನಂಬರ್ ತಗೊಳ್ಳಿ.
ಕನೆಕ್ಟೆಡ್ ವಿತ್
Number ತಗೊಳ್ಳಿ,
6299.
ಎಸ್,
ಗುರುವಾರ ಸಮಯ 8ನೇ ತಾರೀಕಿಗೆ
ಆಗಲ್ಲ.
ಏಜೆನ್ಸಿ ಇದೆ.
ಎಲ್ಲಾ ನಿಮ್ ತರ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಆಗಲ್ಲ. ಆಲ್ ಫರ್ದರ್ ಹಿಯರ್, ಇಫ್ ಇಟ್ ಇಸ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇಟ್ ವಿಲ್ ಕಮ್ ಆನ್ ಫ್ರೈಡೆ. ಅದರ್ವೈಸ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಸರ್.
2 weeks ಬಿಟ್ಟು ಬರುತ್ತೆ.
ಇಲ್ಲ ಸರ್.
Your Honor, one submission.
Serial
No,
number
it's
2
a professional-
pass over. Serial number 2 pass over.
Yes, one ನಿಮಿಷ. Come back to it. 168. ಏನಾಯ್ತು ಇದು? ಮೇಡಮ್ ಇದು 168 ಪ್ಲಸ್ ಇದು ಗಾರ್ಬೇಜ್ ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ ಯಾವ್ದು? Garbage matter and this both list on Friday at 2:30 PM. 2:30 PM.
My lord,
Yes.
serial number 167, garbage matter, my lord. May I make a submission?
On Friday, madam,
My
at
lord, on
2:30.
behalf of the department. My lord,
Friday at
I'm
2:30,
filing
madam.
my objections, my lord.
You file it on that day, yes.
Serial number 107. Stay on
Yes.
investigation is there.
ನಿಮ್ದು ಎಷ್ಟನೇದು madam?
107.
107. ಇಂಟರ್ಮೋ ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ
Respondent.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಈಗ ಶಿಲ್ಪ ಅವ್ರು ಇದ್ರಲ್ಲ ಇಲ್ಲಿ. ಎಸ್, 107. ಇದು ಲಿಸ್ಟ್ ಆನ್ 21st ಇನ್ ದಿ ಕ್ಯಾಪ್ಷನ್ ಇಂಟರ್ಲೋಕೇಟರಿ ಅಪ್ಲಿಕೇಶನ್ಸ್. ಎಸ್.
21st.
Your Honor,
182 for settlement, my lord.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅದು ಅವತ್ತೇ ಬರುತ್ತೆ. 21. ಇಲ್ಲಾಂದ್ರೆ 28. 21 ಅಥವಾ 28. 28 ಹಾಕ್ಲಾ?
My lord, the interim order was passed in the presence of both the parties, my lord.
That's all right. I'm not, I'm while hearing, I'll decide that. But 21st, yes.
Interim order may kindly be
Huh?
extended.
4 PM for further hearing.
Yeah, further hearing ಎಲ್ಲ Fridays.
My lords, for settlement, my lord, serial number 182.
Now,
No, my lords, on 14th, my lords.
whenever
file
you
is
want, you
coming.
tell me, madam, for settlement.
Serial number 104, my lord, settlement.
ಈಗಿದ
ಅಲ್ಲಿ ಮಧ್ಯಾಹ್ನ ಇತ್ತು, ಈ ಪಾರ್ಟಿ ಈಗ ಬಂದಿದ್ದಾರೆ.
ಕೊಡಿ.
104. Party sir.
Offense.
354D, my lord.
Stalking. Jagdish, 354D. ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಇವ್ರಿಗೆ? ಜಗದೀಶ್ ಈಗ ಕೊಟ್ರಲ್ಲ. ಆಸ್ ದೆಮ್ ಟು ಕಮ್ ಆನ್ ಫ್ರೈಡೆ. ಎಲ್ಲಿಂದ ಬರೋದು ಅವ್ರು?
ಅವ್ರು ಕೇರಳದಿಂದ.
ಸ್ಟಾಕಿಂಗ್ ಕೇರಳ ಏನ್ ಮಾಡಿದಾರಾ?
ಒಬ್ರು ಕೇರಳ, ಒಬ್ರು ತಮಿಳ್ನಾಡು. ಅದಕ್ಕೋಸ್ಕರ.
Who is the complainant?
Complaint.
Who represents the complainant?
I'm for the respondent. Respondent number 2, madam.
Why is settling the issue, is it?
Yes, ma'am.
Why?
354D is there, due to the interventions of the well-wishers and the parents, madam.
Due to the intrusion.
Interventions, madam.
Yes, Jagdish will settle it. Yes, SJK. Yes.
Sorry.
One matter for settlement, my lord, kindly taken to.
ಎಲ್ಲಾರು ಹೇಳಿದೆ.
Settlement for tonight.
Wait.
One matter for settlement kindly be taken tomorrow.
Why? Settlement ga.
Please.
ಕೊಡಿ. ಅಷ್ಟೇನಾ? ಪಾಸ್ ಓವರ್
Pass over.
ನಾಳೆಗೆ ಆಗಲ್ಲ. ಎಲ್ಲಿ ಅವರು? ಸೆಟಲ್ಮೆಂಟ್ ನಾಳೆ ಆಗಲ್ಲ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
One submission. Morning, I would like to play apologies.
You should not do that.
That's what I just wanted to, because
You can't
it's
do that.
frustration and it
You
is,
can't say, that's all right. However
this
frustrated you
repercussion
are,
is happening.
release it and bar.
It's repercussion is happening.
All right, whatever. That should not be the practice.
My apologies.
My lord, 230 matter list ಆಗಿದೆ, but respondent ಬರಕ್ಕಾಗಿಲ್ಲ. Kindly what next date, my lord.
ಒಂದ್ ನಿಮಿಷ, ಇದ್ಯಾವ 230 ಮೂಡ್ ಮ್ಯಾಟರ್ಸ್ ಬೇರೆ ಇದೆ. ವೇಟ್ ಸರ್.
Mine is 7291, my lord, of 23.
Tomorrow.
Mine petition is criminal petition 7291. 7291 of 2023.
ವೇಟ್ ಸರ್. ಫಸ್ಟ್ 230 ಮೂಡ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವ್ದು ನೋಡೋಣ.
Still number 1, Pavan here.
What's that?
2008 transaction, they say that they have borrowed loan, I mean, they have paid loan about 6.5 crores for a purchase of 4 acres of land. 2024, they files a complaint.
Oh,
before the
so what, sir? Let it be investigated.
Allah, 2018, that's all. They say that there was no agreement. He said that he has paid in cash.
So what, sir?
2008, Swami, 16 ವರ್ಷ.
Crime ಅವ್ರು ಯಾವಾಗ ಬೇಕು ಅವಾಗ ಮಾಡ್ತಾರೆ, sir. What can be done?
I'm sorry, Mila.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ 230.
ಕೊಟ್ಟಿದೆ ಅವ್ರಿಗೆ.
ಅದರಲ್ಲೂ ಡಿಲೇನಾ?
Now they are, police are after me now.
Police
Both
are after you.
Hmm.
After all,
Petitioner,
police will
but
always
they are
be after
aged.
you.
Both are aged Keralians, Mila.
Yes. Heard the learned senior counsel, Shashidhar, appearing for the petitioner. The matter is moved to be taken up at 2:30, to taken up at the end of the list on the score that the police are harassing the petitioner. The issue in the list is a crime registered on 20th March 2024 for an alleged transaction of the year 2008, to be precise, on 1/6/2008. The complaint does not narrate any speck of explanation for the delay so caused in registering the complaint. A stale and a vintage complaint is sought to be given life. Vintage incident is sought to be given life by registering the crime in the year 2024. Permitting further investigation in the case at hand would run foul of the judgment of the Apex Court in the case of Chanchalapati Das versus State of West Bengal, 2023 SSC Online SC page 650. Therefore, there shall be an interim order of stay of further investigation qua the petitioner till the next date of hearing. One additional SPP 2 emergent notice returnable by the 10th of September. List on 10th of September in the fresh matters.
Great. Hand delivery maybe.
ಒಂದೊಂದಾಗಿ ಇದೆಲ್ಲ ಕೇಳಬಾರ್ದು.
ಅಲ್ಲ ಏನಾಗಿದೆ
No, no.
ಪೊಲೀಸ್
ನಾಳೆ
ಬರ್ತಾರೆ. Please,
Take it tomorrow.
please, I am great.
No hand delivery.
Great.
ನೀವು ಸಾಯಂಕಾಲ ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ 6 ಗಂಟೆಗೆ ಮೆಮೊ ಕೊಟ್ಬಿಟ್ಟು
Sorry,
ತಕ್ಷಣ
madam,
hand
my
delivery.
apologies.
ಇದು
I have
ವೆಕೇಶನ್
seen-
ಅಲ್ಲ ಸರ್.
No, I have seen all your lordships.
What, sir? Yes.
I'm sorry for your lordships.
Yes, next.
Number 2, Harish Bandari.
Withdrawn in terms of the memo, yes. Learned counsel of the petition moved the matter to withdraw the petition. In the light of the said the submission is placed on record, disposed as withdrawn. Next. SPP. ನೀವು ಯಾಕೆ?
This is a matter, my lord,
ನೀವು 2:30 ಮೂವ್ ಮಾಡಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದೀರಾ?
No, my lord, in view of the urgency
Huh.
that the impugned order, my lord, the magistrate has referred the matter for further investigation to CID, my lord.
Further investigation to different entity.
CID refer ಮಾಡಿದ್ದಾರೆ. My lordship may kindly see the application, my lord, prayer column of the application.
Page. Office directed to issue intimation to Commissioner of Police to direct CID. ಮುಂಚೆ ಯಾರು ಮಾಡಿದ್ದು?
It is the local police, my lord.
The state is before the court calling in question an order dated 20th November 2023 by which the concerned court has referred the matter for further investigation under section 173(8) to the hands of the CID. It is by now a too well settled principle of law that the concerned court cannot exercise the jurisdiction under section 482 of the CRPC to refer the matter for further investigation to any other investigating agency. It would always be open for the concerned court to permit further investigation by the very same investigating agency and not any other. In the light of the said circumstance, there shall be an interim order of stay of the order dated 20th November 2023 and all further proceedings taken thereto.
Please, very well.
Yes.
I appear for the respondent.
Yes, sir.
Wakalat on this, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
The same matter which my learned friend
ಯಾವ್ದು ಸರ್?
SPP, the 156.
ಅದ್ರಲ್ಲಿ ನೀವು ಆಗ್ಲೇ ಅಪೇರ್ ಆಗ್ತಿದ್ದೀರಾ?
No, my lord, today it was listed for the first time. They want to take notice and appear.
Learned counsel, ಅಲ್ಲಿ first ಬರ್ಕೊಂಬಿಡಿ. Learned counsel undertakes to enter appearance for the second respondent complainant so and so. Magistrate power ಇಲ್ಲ sir.
Indeed, my lord, the only confusion here is further investigation is fine, but with respect to whether it's going to CID or further investigation, the same police. is
Same
what they are
police, no
challenged.
problem at all. CID power of this court.
1 minute if I may.
ಮೂರ್ತಿ ಸರ್ ಅದಕ್ಕೆ ಇರೋದಾ? What Murthy sir?
In fact, our prayer, my
It
lord,
is-
was for further investigation.
We will direct for further investigation by the same agency, no problem.
Correct. Our prayer is also for further
Yeah,
investigation
magistrate,
as against 5 accused. The learned session.
They would never be aggrieved if it is further investigation.
So that can be, my lord, given a quietus instead of indefinite. This is a 302.
Day after tomorrow I'll take. ಇದು ಇರ್ಲಿ ಆರ್ಡರ್ ಇದು.
ಅದಿರ್ಬೋದು.
Day after tomorrow I'll take. ಅದೇ council so and so enters appearance ಅಂತ ಮಾಡಿ. Day after tomorrow
In fresh matter.
fresh matters.
Grateful. Yes.
The number of orders have been passed by the same court, my lord, are directing further investigation to CID.
No, I will pass a detailed order.
ಆಗ್ಬೋದು.
Yes.
That is settled principle,
Yes.
sir. What is this?
And in fact, our
That
prayer.
power is only of this court under
Yes,
four
and
eighty-two, sir.
and our
not-
prayer will Lord is also for further investigation.
Yes,
They can serve a copy for
Please, my
a
lord,
change.
serve a copy.
Yes.
copy ಕೊಡಿ day after tomorrow.
Please, I will.
ಅಷ್ಟೇ ಇದೆ ಎಲ್ಲ ಆರ್ಡರ್ ಇರಲಿ ಯಾವುದು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಏನಿಲ್ಲ ಡೋಂಟ್ ಸ್ಟೇಟ್ಗೆ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಬೇಕಾಗಿಲ್ಲ ಯಾವತ್ತು
It's
That
day
we
after
will,
tomorrow,
that
my
will
lord,
not
it is on eight.
precipitate.
ಇವರೇ ಹಾಕಿರುತ್ತಾನೆ ಕಣ್ಣು
ಇವ್ರೇ ಹಾಕಿರೋದು.
Will not precipitate.
That submission may kindly be recorded.
ಸರ್ ಮೂರ್ತಿ ಸರ್ is saying this, he will not do
Very
that.
well, my
don't
lord.
worry. Yes,
Grateful.
when he is appearing, we don't need an order.
Please, very well, my
Have
lord.
belief on all councils, sir. Yes,
Grateful.
Admission.
why Sham Sundar sir is laughing? Belief on all the councils,
Any appreciation to Murthy, my lord, I always.
you get, you want to give a smile, is it? Yes.
Arunji for settlement.
Kindly 6 adjournment my lord, ಒಟ್ಟು ರೆಸ್ಪಾಂಡೆಂಟ್
Move ಮಾಡಿದ್ದು ಯಾಕೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಬರ್ತಾರೆ ಅಂದ್ರೆ ಒಟ್ಟು ಬಟ್ ಲೇಡಿ ಇದಾರೆ ಬರಕ್ಕಾಗಲಿ
ಆಯ್ತು ಸರ್. Yes, next week ಅಲ್ಲ 20
ಅಲ್ಲ ಆಫ್ಟರ್ 3 weeks my lord. ಅವ್ರು
after 3 weeks.
Yes, my lord.
ಆಯ್ತು, list on the 9th, 12th September.
I will move my lord.
Move ಮಾಡಿ ಸರ್.
ಡೇಟ್ ನೋಡ್ಕೊಂಡು
Date
move
ಏನ್
ಮಾಡ್ತೀನಿ.
ಬೇಡ.
ಡೇಟ್ ಬೇಡ my lord. ಮಚ್ ಒಬ್ಲೈಸ್ my lord.
ಪಾಸ್ ಓವರ್ ಏನಾಗಿತ್ತಲ್ಲ ಯಾವ್ದು ಕೊಡಿ.
Submission.
ಈಗೇನ್ ಸಬ್ಮಿಷನ್ ಇಲ್ಲ, ಪಾಸ್ ಓವರ್ ಮಾತ್ರ ಕೊಡಿ. ಮಹಾದೇವ. Thank you. Yes, withdrawal.
Serial number 100, he has no objection to allow the petition.
Should I allow it now sitting?
Yeah.
There should be some reasonableness in asking, sir. What is this, Rajat? Not correct. Next time allow ಮಾಡೋಣ. Again stay ಇದೆಯಾ?
They are precipitating the matter.
Yes, ಪಾಸ್ ಓವರ್ ಮಾಡಿದೀನಿ 2 have to take. ಅದೇ ನೀವೇನ್ ಅಟಿಕಾಗೋಳ್ ಬಿಡೋದಿಲ್ಲ.
Like the other case, last time your lordship passed an order, same case he is coming for quashing of the.
Same case.
Same case.
The same case, lordship. Here the ground is that now.
In fact, my lord, I called the IO, which was, I thought it was posted tomorrow.
ನಾಳೆ ಆಗಲ್ಲ. ಏನಾಗಿದೆ? ನಾಡಿದ್ದು ಹಾಕ್ತೀನಿ, don't precipitate till then.
Again, investigation is directed by your lordship in coordinate another matter. We are not doing anything. We are continuing our investigation.
Same crime.
Same crime.
Same, I'm submission.
No,
is-
he
I made a
said,
submission
I
yesterday.
took it a little. He may
So
have
the
said
same
that.
case, only thing is that lordship now the condition is imposed by that bail court to appear in every first and third Sunday. For that reason, it's other difficulties there. And we are on 411 and 413, ingredient, 411 and 413. Even though we accept that we have purchased it, without knowledge.
In fact, I showed to my learned friend a program which was a pamphlet printed, shows that he is the owner of the Attica.
Some other person has private lordship, somebody has invited him.
That's all right.
Somebody is invited.
Why are you getting agitated? Don't worry.
Projecting in such a way that I myself is projecting. I am Attica Gold Company.
ನಿಮಗೆ ತೋರಿಸಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು. Why do you take everything personal? No, not that.
Till then, lordship, because
Don't precipitate till day after tomorrow. I'll take it day after tomorrow. List the matter day after tomorrow.
My lord, I'll play.
Next Tuesday. All right. List
Will
the
not
matter.
Anyway, we are not calling him.
List
That's
the matter
direction.
on 13th. The respondents shall not precipitate the matter till the next date. ಸಾಕು. ಅವತ್ತು ತೀರ್ಮಾನ ಮಾಡುವ 411 ಏನು 413.
because this is only your legal aspect, Lord. Supreme Court judgment is there on that aspect.
He has given some judgment.
Yes, I seen that. Only one step, my friend has come forward one step.
ಏನ್ ಸರ್? ಹಾ. Who is taken into custody? Why?
He has not appeared on certain dates. Bail application is pending before other court. He dispose ಆದ್ಮೇಲೆ ಬನ್ನಿ ಅಂತ ನಾಡಿದ್ದು date.
Bail application. What is that, Jagdish? Why is he taken into custody? Because you have not appeared. Court alla.
Before the trial court.
Then we can't.
Fresh matter. ಅಲ್ಲಿ
Thursday we'll take it on Friday. ಇವಾಗ ಲಿಸ್ಟ್ ಮಾಡಕ್ಕೂ ಆಗಲ್ಲ. Thursday fresh matters.
Serial number 2,
ಏನ್ ಭಾನುಪ್ರಕಾಶ್ ನಿಮ್ಗೆ? ಅವ್ರು ಬರ್ಲೇ ಇಲ್ವಲ್ಲ?
I producing the 2 citation, my lordship. They have already told they have no objection.
ಈಗ ಏನಾಗಿದೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Court ಅಲ್ಲಿ judgment ಗೆ ಪೋಸ್ಟ್ ಆಗಿದೆ. On that day,
ಗೆ?
judgment ಪೋಸ್ಟ್ ಆಗಿದೆ.
ಹೋಗ್ತಾ ಇದೆಯಾ?
ಪೋಸ್ಟ್ ಆಗಿದೆ.
ಹೋಗ್ತಾ ಇರೋದನ್ನ ನಾವು ತಡೆ ಹಿಡಿಯಕ್ಕಾಗುತ್ತಾ? ಕೊಡಿ. ಎಸ್. ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ನಾಡಿದ್ದು ಬರ್ಲಿ ಅದೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ. ಜಡ್ಮೆಂಟ್ ಯಾವತ್ತಿದೆ? 9th. ಅದ್ರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. ದಿ ಕನ್ಸರ್ನ್ ಕೋರ್ಟ್ shall defer the proceedings till the next date of hearing ಅಂತ ಬರ್ಕೊಂಡೆ.
Stays already there.
ಆಲ್ರೆಡಿ ದೇರ್ ಅಲ್ವಾ? ಹಿಂಗ್ ಮಾಡೋಣ ಒಂದ್ ನಿಮಿಷ. ಬೇಡ, ಇದು ಮಾಡಿರಿ, next we'll see. Yes.
Serial number 13 also passed over.
Why, sir?
Lord, they submitted a report, police
What report?
Report, investigation team.
school matter, my lord.
How school?
Was Chrysalis School, my lord. Fence is
Oh, theft,
yes, my lord.
ಬರ್ಲಿ, let it come on Friday. Yes, ಇದು ಫೈಲ್ಗೆ ಹಾಕಿ ಮೇಡಮ್, list on Friday in the fresh matters list. Yes.
Serial number 47 was passed over. This is with regard to the complainant, the victim before this court seeking for filing of the protest
I know
petition.
that I have to pass orders.
Please.
Friday ne ಮಾಡ್ತೀನಿ.
Item 87 was passed over. Let me see the date. Item 87
ಏನಾಯ್ತು?
passed over. Let me see the date.
For what?
For next court.
Why passed over, madam? Why passed over 87?
Files,
ಏನ್ ಫೈಲ್?
afternoon, 6961,
Hmm.
6964 file.
ಫೈಲ್ ಹೋಗಿದೆ ಬ್ರಾಂಚ್. ನೀವು KPTCL ಎಂಪ್ಲಾಯಿಯಾ? ಎಲ್ಲ ರಿಪೋರ್ಟ್ ತರಿಸಿ.
I'll get it tomorrow.
If I find what he says is false, I will direct action to be taken against him.
Yes.
You must be aware, you are making statements in a court of law. If there is any falsehood in what you have said in the morning, you will face action. Be prepared for that. I'm getting a report, factual report of what has happened. All right? Yes.
Let him be present tomorrow.
Tomorrow, be present in the court.
Yes, sir.
Yes. Madam,